Have you pleased your lordship?
Yes.
Yesterday I did not come to the court due to my illness. That's today I am mentioning. It is a matter. Lordship was pleased to pass an order. The matter was sent to the mediation center on 24th September, but the matter was not yet been settled.
It's an appeal we are taking up. We'll take up after some time.
My lord, your lordship.
We know.
At two occasions.
We know, but we'll
My
take
lord,
up after some time. We already have matters in the list. We'll take up after some time. Yes.
This is lodging my matter.
Please hand over. Yes.
My lord, may I have my lord's leave, my lord, to file and move an appeal without certified copy, my lord. 5th February is the order impugned, my lord. Partition suit, injunction refused at the interim stage, where the learned judge finds that their shares in
Please
the
not.
property.
Please.
My lord, could I have my lord's leave
You have
to
an
move
application mentioned?
it? My lord, it's there. The application is there. Could it be listed tomorrow if it commences tomorrow? I know, my lord,
You have to give the slip.
it's already there, my lord. My lord, we'll file it and again. Deeply obliged.
Yes.
Deeply obliged.
Application heading.
Application is.
Your lordship, review application of an
Application.
passed by your lordship.
Review application is an application.
41, my lord.
Yes. Grateful. Forget.
Not apply the order take on
What heading will it appear under?
that is not appearing.
It will appear under which heading? What heading?
We have made an can application.
Can then application. Write application and hand over. Write application.
My lord, may I?
Write application. Yes.
My lord, may I allow to mention this matter for inclusion?
What is the matter?
It is the second appeal.
For what? Admission?
Admission, my lord.
Admission, right admission or order for 20?
Your Lordship, if I may be permitted to mention the matter, liberty was granted upon us on the previous occasion to mention this matter for inclusion, Your Lordship.
What is the matter? Application or what?
There were certain defects in the application due to which it was removed from the list. And on 13th January, it appeared.
It was appearing under what heading?
Your Lordship, it is SAT.
Order 41 or what? Please ascertain, ma'am, and come back tomorrow. If it's order 41, write order 41, we'll take tomorrow.
It is order 41.
Write order 41 and hand over. Yes.
My lord, first appeal filed on 2023.
First appeal hearing.
Or admission not taken. The
First appeal is not required to be formally admitted. It automatically admitted. If you file an application, mention that. Yes.
Pilot for inclusion.
No. Inclusion of what? What is you handing over?
What will be transferred?
Firdo. Yes.
Pilot group 1 application. Land matter.
Application is. Can number টা আছে কিনা দেখে নেবেন ওটা যেটা উনি দিচ্ছেন ইনি না উনি give the can number. If it's an application, you have to give the application number. Just writing application won't do. You have to write the application number.
Anytime the record is not placed before this honorable court.
It will not be placed unless you file an application. Yes.
My lord, may be permitted to mention a matter for release, my lord.
Yes, to be mentioned. Call on the list.
May I be permitted?
No further mention. Accordingly, FMAT 460 of 2025 is partially allowed on contest, thereby modifying the impugned order bearing such and such to the effect that the defendant respondent shall remain restrained by an order of injunction from soliciting or inducing any employee of the plaintiff appellant company to leave its service, as well as from using or disclosing any confidential information or trade secrets belonging to the plaintiff appellant in any manner whatsoever till disposal of the temporary injunction application by the trial court. We have not granted his joining service. It is made clear that the above findings, these are tentative in nature and won't. We fully appreciate that we don't know how to distinguish. I mean, if one joins another company, how he shall be prevented from disclosing the secrets. But still, Section 27 operated. That played in our mind. Mr. Mahato was successful on 27. Yes.
Item number 2.
First time এগুলো আসছে? None appears for the parties at the time of call. As a last chance to the appellant stroke petitioner to move the matter, let the same stand adjourned for the day.
I'm for the appellant.
Oh,
I'm praying for my 2 weeks time because I could not contact.
On the prayer of the appellant, the matter is adjourned till
3 weeks or 2 weeks.
Till February 24th, 2026, when it will be next listed under the same heading. 24th February, 3 weeks.
24th February or
24th February. Yes, next.
Item number 4.
None appears for the parties. Pratham.
3, 4 একসাথে না 3, 4 টা একসাথে না
Item number 6.
4, 5, 6 সেম ওই মানে এর আগেরটা যেটা করলো লাস্ট চান্স সেম
Item number 8.
সেম
9.
সেম
Item number 10.
সেম
Item number 11.
দেখি একবার ফাইলটা Please mention on the next day, please. Every hour is not the mentioning hour. Mentioning is over. Thank you. By our order dated January 19, 2026, we had recorded that the petitioner sought for an adjournment on the ground that service on the private respondents had not yet been completed, although the state was represented through counsel. Thus, on the prayer of the writ petitioner, the matter was adjourned till January 27, 2026. The matter was next taken up on February 9, 2026, when an accommodation was again sought on behalf of the petitioner. We had recorded in the order dated February 9, 2026 that accommodation was granted on the ground of serious illness of learned lead counsel for the petitioner, for which we had adjourned the matter, but as a last chance to the petitioner to move the matter. Next para. Even today, at the time of call, none appears to move the writ petition. Hence, WPLRT 221 of 2025 is dismissed for default without any orders to cost. Interim order, if any, stands vacated. Next.
What the statement?
Yes, Mr. None appears for the petitioners at the time of call, although the state is represented through the learned additional government pleader. So, as a last chance to the petitioners to move the matter, the same is adjourned for the day. We have given a last chance, Mr. If they don't appear on the next occasion, we'll next. Call on the list, please. Carry on. Yeah.
I am for the. I appear for the petitioner in item number 30.
Yes.
I am for the.
Right. What is the matter?
This is a matter, my lord, where the petitioner before Lordship has approached this honorable court. My lord, a contempt application is pending before the learned tribunal. My lord, initially an order was passed by this honorable court. My lord, in terms of that honorable court's order, my lord, we approached the learned tribunal for correction of the record of rights. Now, my lord, the order was in our favor in terms of the order passed by this court by the single judge and as well as by the division bench. It was in our favor. My lord, they moved a petition before this court. That was dismissed. They moved the petition. They moved the SLP before the Supreme Court. That was also dismissed. My lord, we came with a contempt before the learned tribunal. The contempt was pending. At that juncture, my lord, they again in the tribunal they said they have moved the review petition before this honorable court. The review also got dismissed. My lord, again they went to the Supreme Court. My lord, in the Supreme Court they said, my lord, when an application SLP was filed, when the matter was taken up, they said the earlier order, which was earlier dismissed by the Supreme Court, that requires another review. Well, leave was granted. At this juncture, the tribunal is not approaching with the contempt application which is pending before them.
So, two applications are pending before the Supreme Court. One, the SLP against the dismissal of the review,
Lord,
and the other, a review application has been filed.
My lord, I'm coming, my lord.
What is the number of this case?
WPRT 14.
No, my lord. 13 is 3 of WPLRT 3 of.
WPLRT 3 of 2026.
So,
WPRT 14 is
item 13, 14.
13 and 14, my lord.
13 and 14 are WPLRT 3 and 5.
3 and 5.
WPRT 14.
Yours is WPLRT what?
14, my lord.
WPLRT 14 is item 23 in the day's list.
The list of yesterday's list, my lord.
We are not following. Why should we follow the yesterday's list?
Today's list is.
We are following today's list.
I'm wrong, my lord.
My lord, internet, that is the number is, my lord, 1, 2, and 3. And now, my lord, in the.
We are following the hard list.
Yes, my
lord. The internet list says 13 is WP4. That is the mistake I made, my lord.
We don't know. We have to resolve these issues. Too much time is consumed in these things for us. But you have to follow the hard list. Yes, Miss, you are appearing for the state.
Yes, madam. But they are not.
Hard in part, we have to complete hearing. We are passing it over, Mr. De, because it's a part hard matter. We
Yes,
want to
madam.
conclude it.
Yes, madam.
এখন অর্ডার রেকর্ড করতে হবে না, পাস ওভার করে দিন 24-এর পর আবার ডাকবে মিস্টার দে উইল কল ইট আফটার 24
Yes,
আফটার দি মোশন স্যার
Yes,
রিট
ma'am.
মোশন
item 11, 12 মানে
সময় দিয়েছি।
নেক্সট
না ওই dismissed for default বলছে তো
যাও না।
none appears for the time for the parties at the time of call to serve as a last chance to the petitioner to move the matter comma let the matter stand addend for the day next
করা হচ্ছে প্রত্যেকদিন। যাও না।
same
করো না, হয়ে গেছে তো।
yes please
My lord, in this matter, my lord, Mr. Lalit Mohan Mahato is appearing for the state.
who is appearing
Lalit Mohan Mahato, my lord. My lord,
let him come we'll start the matter no possible yes
This matter, your lordship kindly state a come to my lord, page 43.
page 43 yes
It is my retained land. The land involved in question is retained land under West Bengal State Acquisition.
this is page 43
Yes, yes.
uh-huh.
Yes, yes.
where is it written
That is my lordship kindly.
thank you
Yeah, act, মানে plot number.
yes yes yeah act yes
দাগ দুইটি retained.
হ্যাঁ
No,
বেস্ট হয়ে আছে
no, retained, not waste.
দুইটি ইয়ে অ্যাক্টে নম্বর কেস মূলে ভেস্ট হইয়াছে এবং তাহার পরিমাণ
Oh, it is my information. I want to make information whether the land is retained or not. Or
আচ্ছা
vested.
আচ্ছা
And maybe
লেফট হ্যান্ড সাইড ইজ দি ইনফরমেশন
yes, information. And it is my দাগ দুইটি retained. Does you get it? Right hand side.
দাগ দুটি রিটেন অলরাইট the most important portion is the most illegible one
My
দাগ দুইটি রিটেন ভেরি গুড yes yes
মানে এই lordship kindly come to মানে page mail 45. This makes the this 45.
45
It is stated that the your petition noted that this is informed to electrode number such and such under Khutian number 1. It is vested. Land
Yes.
was transferred in the year 1963. One before the date of my lord 69.
transfer to you
Yes, yes. Transfer main transfer from the.
আচ্ছা your predecessor
Yes.
all right
I have stated it. So therefore no scope to vesting under the West Bengal Land Reforms Act. Well, it is land is already transferred 1963. Your lordship and get it. The
no page 45 what is this
40.
this is another answer to
Yes,
information
yes, yes. Well, two contradicts that the one said it is a retained land and subsequently say it is not details information, but it is stated that it is my land is reported in under heading my lord.
Elar
Khutian
plot
number.
numbers are recorded as in Khotian number but this does not say it is vested or something like that
But it cannot be. Now I said that meaning your lordship kindly see the land was page 18.
no this does not say page 45 does not say it has vested
It is not, but it is apparently when it is BLR said that until and unless it is some order not passed by the court, then I am not able to correct the record. So this is the problem. This creates the problem to the.
no but page 45 does not say it has vested
But it is one.
in response to your petition
That's
as
Khutian number 1. Khutian number 1.
one
Yes, yes.
one tested
Khutian number 1.
yes
And your lordship kindly come to my lord.
page 18 is your deed
My deed. That is
your predecessor's deed actually
Yes. That is page 63, your lordship kindly.
one second
63. Lordship kindly.
give us half a second
20.
half a second
Page 20.
Page 63 or 20?
63 when starts.
63 there is
It is my page 18. When the land was transferred by way of my deed.
page 18.
Page 18. Sudhir Kumar Bhuya, Grohita,
Yes.
and Data Uddin Samuddin. That it is my registered deed, sell it, and which was my purchased my your lordship will get it 20, page 20, 1963.
Yes.
So my what was 14p, land reforms that my if land is that is restriction period my 16th day of 1969, September 1969. From that date, my lord, the calculation will be made. P.
We'll just check.
Right.
ওসীমা দি নামটা লিখুন।
Right. So it was before that. Yes.
So my lord, there is no question obviously. So therefore, I made representation to the concerned authority. I tried to my lord make understand to the my lord land reforms tribunal that certain something to be given so that I should not come back once again.
What did you challenge before the tribunal?
That is when record has not been corrected. I made representation.
Achha.
So my lord, I want that the effective order to be passed so that the record to be corrected.
All right.
My lord only say that I only consider this matter, direction to consider this matter, then BLR will never, my lord.
That has been done. Direction has been given.
That direction has been given, but page 46 is the representation.
Yes.
So what is the wrong in that? You asked for direction,
Ask
you
for
got
the
a direction.
consideration.
Only, my
It
lord.
will be prejudging if because tribunal did not commit any error. Whatever you sought, it was given.
I am only praying.
We'll ask the
praying to consider.
We'll ask the BLL. We say there is no mistake in this order, but we'll express
Part of my lordship, my BLR himself surrender. He said that.
No,
this
we
is
understand,
yes,
but
yes.
since you have asked for a representation, that has
That
been
is not
considered.
good record. The
Right, it is
PLRO
not-
has surrendered, only averment is there, but no document.
BLRO has
It is there is an averment that BLRO said unless the higher authority directs.
that has to be. We'll direct the BLRO to pass a rescind order on his.
My lord.
That will take care of issues. If he is aggrieved, if you are aggrieved, then you can challenge again.
My lord.
But you have asked for a representation under the first
Frankly,
place.
I am only my lord praying before your lordship.
No, this court sitting in 226 is not in a position to adjudicate on merits the representation before the BLRO. That will be entirely prejudging and usurping forums. That would be not correct.
Again, I know. Again,
Certain things have to be done again because why have you come here? You should have waited for the BLRO to be.
Kindly.
There is no error in this order.
Something. Well, kindly give something that when a land.
We'll give you an order. We'll give you an order where we'll say there is no mistake in this order. You're asking for something, we'll give you something. 6 months have been given, we'll make it shorter. 6 months have been given to the BLFP. 6 months is too much.
Consider the two aspects. Only one. Only consider the deed, 63 transfer, and it is only.
Well, BLRO will give you an opportunity to produce all these documents, and upon considering those, BLRO will consider.
Including deed, which was sale.
Yes, we'll say that.
Your lordship give.
Because in any event, if you place before the BLRO has to consider. So we'll say that.
I know.
No, but we'll say that in an order, so we'll get something.
We are yesterday. I'm saying before the lordship. 2007, 98 record was corrected. 2000 against it was vested. And I filed application 2007. Yesterday, my lord, I own this matter that the vesting is illegal. After, my lord,
we are changing our orders every day. We are changing our orders, passed in the morning something, in the evening something else. So how can the BLRO be blamed? We are equally to blame. High Court is equally to blame. Supreme Court is equally to blame.
Kindly indicate that consider the
learned counsel. The learned counsel for the petitioner submits that initially an information was obtained from the concerned authority in respect of the subject plots, that is Dag numbers 28/1 428 and 28/431, comma, upon which the petitioner was informed that the said two plots had been retained by the riot. Full stop. However, comma, in a subsequent information issued by the concerned BL and LRO on May 22, 2025, comma, it was intimated that the said plots were recorded in Khatian number 01 of the concerned Mauza, comma, which clearly indicates that the said plots are treated to be vested in the state government. Full stop. Learned Counsel submits, comma, by placing reliance on a title deed executed in favor of the predecessor in interest of the petitioner, dated September 16, 1963, that the lands were already transferred in the year 1963, and as such, comma, do not come within the purview of the ceiling limits as contemplated in the West Bengal Land Reforms Act 1955. Full of Learned Counsel places reliance on section 14 capital P within bracket 1 of the said act, which stipulates that in determining the ceiling area, comma, any land transferred by sale, comma, gift or otherwise, or partitioned by a riot after the 7th day of August 1969, but before the date of publication of the West Bengal Land Reforms within bracket Amendment bracket Close Act, comma, 1971 in the official gazette, comma, shall be taken into account as if such land had not been transferred or partitioned, as the case may be. Full stop. Next para, it is, comma, thus, comma, submitted that since the plots in question had already been transferred prior to the cutoff date and thereafter further transferred in favor of the petitioner, comma, the same could not have been vested at any point of time. Full stop. Next para, when the petitioner approached the concerned BL and LRO with a representation to effect the necessary corrections to the land records in that regard, comma, the same was the BL and LRO sat tight over the matter, comma, prompting the petitioner to move the West Bengal Land Reforms and Tenancy Tribunal. Full stop. Next para, the tribunal, comma, by its impugned order dated September 18, 2025, comma, merely directed the BL and LRO to dispose of the representation of the petitioner within 6 months from the date of communication of the order, comma, thereby relegating the issue again to the BL and LRO. Full stop. It is submitted that a positive order ought to have been passed by the tribunal directing correction of the records of rights on the basis of the sale deed, transfer deeds produced by the petitioner. Full stop. Heard Learned Counsel for the petitioner as well as the learned additional government pleader appearing for the state. Full stop. Next para. On a perusal of the impugned order, comma, we do not find any illegality or irregularity in the same, inasmuch as the prayer of the writ petitioner was confined before the tribunal to a direction on the BL and LRO to consider the petitioner's representation, comma, which was granted by the tribunal. Full stop. Next para. However, comma, it would be appropriate, comma, in our view, comma, if the timeline granted to the BL and LRO for such consideration was shorter. Full stop. Next para. Accordingly, comma, WP-LRT 07 of 2026 is disposed of without interfering with the impugned order dated September 18, 2025, passed by the 4th bench, comma, West Bengal Land Reforms and Tenancy Tribunal in OA number 2407 of 2025, bracket LRTT, bracket close, full stop. However, comma, comma দিয়ে, full stop দিয়ে, comma দিয়ে, apart from the minor modification that the timeline given to the BL and LRO to complete the consideration of the petitioner's representation is shortened to 6 weeks from the date of communication of this order to the concerned BL and LRO. Full stop. Next para. While so considering, comma, the BL and LRO shall grant the petitioner opportunity of hearing and to place all documents and shall consider such documents, comma, including the title deeds of the predecessor in interest of the petitioner as well as the petitioner and any other relevant document, comma, if produced by the petitioner. Full stop. Next para. No orders to cause urgent certificate. Thanks.
affidavit of service.
আচ্ছা প্রথমেই affidavit of service file to be kept under. হ্যাঁ। বেড়ে গেল আর বেশি হয়ে গেল এখানে এসছে ঠিক আছে yes
Lordship, they same order,
same order
same fate. Why you have come? Milord,
Milord, in item number 18, Milord, I beg to appear on behalf of the Milord private respondents, Milord.
yes
Milord, in this matter, Milord, I'm led by Mr. Odun Pahadi, Milord. Milord, he has been suddenly attacked with fever, Milord, since yesterday, Milord. I'm praying for a week accommodation, Milord.
competent enough let us hear him if you grant
Very-
at all relief then yes
so
Very
complicated.
well, Milord.
yes let us see if something
Very
complicated
well, Milord. Very well.
Two admitted facts. One is,
Mr. Basu you take the microphone closer so that Mr. he can hear you.
oh, achha. I thought
Yes,
my lord is
not for us yes
1928 for 5 years lease agreement. 1928, 5 years lease agreement. Ticket Tenancy Act came into force 1949.
Hmm.
Now, my lord, and another admitted fact is structure on the plot is pakka.
at that point when it was given
Now, before 49, pakka structure. Keeping in those two facts, my lord, it cannot be any Ticket Tenancy. On these facts, I am being delegated thrice from tribunal to Thika controller to tribunal and High Court. Again, the same thing happened.
why what was the initial order?
Initial, my lord, not decided, delegated. Thereafter, it was
So
decided.
you went to the
Thika controller said that Thika tenant only on the ground that they have filed the challan, so deemed Thika tenancy. Nothing decided. Challenge that. Up to your lordship's court decided to decide that in terms of 1981 Act. I don't know, my lord. I will know, no comment. Gone there. Thika controller said, I have no power today.
under 81 act
But they are taken with a deemed provision. Where from they are got it. Again, now my lord, again I have relegated to decide it under 2001 Act.
rightly right 2001 act
I know, but this is the situation, my lord. Thrice I have.
unless there is 2001 act the ticket control does not have the power even
I know that.
now you have got a proper order so we should not interfere.
See my fate.
Mr. Pahari wins without appeal
See my fate.
yes
I approach your lordship's court. Two admitted facts. The one is
ticket controller decide
when
now as per the order of the tribunal why should you interfere with if you interfere with these orders Mr.
I know.
Basu, the tribunal will lose its confidence they won't know what would be a good order
19. Your lordship's court directed 91 to decide on the basis of 91.
not the
81 Act.
tribunal this
Your
court
lordship's court decided.
this court decided
Yes. To
direct,
decide it in terms of 81 Act.
directly the tribunal
Yes. No. Direct Thika controller.
so that is what has been done by the tribunal and
No,
now it has been
tribunal-
corrected
I cannot decide under 81 Act.
This court said that it
rightly
has to be a-
rightly
Now see the litigant's fate.
very good order sir.
See the kindly see the other order. Kindly come to page 43.
No, then if you want an adjudication under the 1981 Act, then it will be the same.
That I'm saying
He does not
what
have
the
the power.
litigant will do.
He'll go to the Thika controller and get his order.
Already gone there in terms of page 43.
He had gone in terms of 81.
In terms of I am not gone. Your lordship's court directed to decide it on the 81 Act.
It's you who went.
But I have to go. Court said
Directed,
go.
You went. Yes. So what's the difficulty in that? Now it has been rectified. Why are you aggrieved with this? You should
I should be aggrieved because
should keep a picture of the tribunal and put a
since
incense stick every day. You have got a good order for the first time.
And this
Really, Mr. Bachu, this is the first good order you have got in your case.
only 15 years has passed in the meantime.
Yes, our fault, court's fault.
So
Someone like you must have convinced the court that
that
some senior advocate like you must have convinced the court that it should be under the 81 Act. Either you or somebody, not you, somebody else.
Why not me also?
Maybe you also. There's every chance that you did it.
But see the fate of the litigant. 15 years passed.
Are you sure you did not do it? We'll check up. We'll check up who did
Check it up. I cannot say this.
Which page?
Page 43.
Check it up. And another matter, I move, my lord, like this, your lordship has considered that judgment and distinguished in your lordship's own way. They are also same thing decided by your lordship's court, but another division bench. Hopefully, I am not there. What can I pray, my lord? Kindly expedite. Nothing more I can praise. It will come to your lordship's mind, my lord. If you lordship give me 1 minute's time, it will come to your lordship's mind. I have only one copy justice. Night and. Yes. But kindly, where is it? It will come to your lordship's mind.
Nothing comes to my mind so easily.
You kindly read 1 or 2 pages, your lordship will come to your mind. Same point. It was directed to consider, not that 81 has the power, Tika controller.
Yes, sir, there is no decision is necessary for that.
No.
81.
My lord, distinguish that, this judgment. Or need not.
Yes.
My lord, kindly, what else I can pray, kindly, mandatorily expedite this. Fact is this, I have a Pakka structure and 1928 lease deed for 5 years. By no means it can.
Will you are Mr. What is your name?
Orkoduti Pahari Millet.
You are also Mr. Acha, you are a relative of Mr. Pahari.
I'm his son Millet.
Oh, Acha, good. So, Junior Mr. Pahari, we are recording that you are disputing his contentions on merits and sending
And Millet.
Yes. You are frozen now.
Frozen.
Eight problem.
We will do whatever. Learned Senior Counsel appearing for the petitioner submits that a lease in respect of the subject property was granted in the year 1928, full stop.
For 5 years.
For a period of 5 years. Full stop. Next para. Subsequently, prior to the coming into force of the Thika Tenancy Act, Calcutta Thika Tenancy Act 1949, a Pakka structure existed on the property. Full stop. Thus, it is argued that the property could not have been a Thika property within the contemplation of the Thika Tenancy Act, as it stood evolved by successive amendments. Full stop. Next para. On a previous occasion, when the matter came up before this court, a coordinate bench, by an order dated August 14, 2023, passed in WP LRT 85 of 2023, had directed the controller to decide the issue as to whether the property is a Thika tenancy in accordance with the Calcutta Thika Tenancy Act, in accordance with the Calcutta Thika Tenancy Act 1981. Full stop. Next para. Subsequently, the matter went back to the controller and again came up before the tribunal.
No, he decided that he cannot know her power.
Acha. Went back to the Thika controller, who held that he did not have the power to adjudicate such issue under the 1981 Act. Full stop. Being aggrieved, the petitioner moved an original application bearing OA number 762 of 2024 LRTT before the West Bengal Land Reforms and Tenancy Tribunal. Full stop. The learned tribunal, by the impugned order dated January 6, 2026,
rightly decided,
held that the legal position is well settled that when a dispute arises as to whether a land is a Thika land and or whether an occupier is a Thika tenant, such dispute squarely falls within the exclusive jurisdiction of the Thika controller under section 5 (3) of the West Bengal Thika Tenancy Acquisition and Regulation Act, 2001. Full stop. Accordingly, the matter was remitted by the tribunal back to the Thika controller Kolkata to adjudicate the dispute afresh, strictly in accordance with law, by exercising powers under section 5 (3) of the 2001 Act, upon giving reasonable opportunity of hearing to all concerned parties and permitting them to file pleadings and documents and to pass a reasoned and speaking order dealing with all issues raised. Full stop. Next para. Having regard to the prolonged nature of litigation, the Thika controller was directed to conclude the entire exercise and pass a final order within a period of 3 months from the date of communication of the order. Full stop. Next para. Learned Senior Counsel submits that the petitioner has been running from pillar to post for a prolonged period and the learned tribunal ought to have concluded the matter by deciding the issue himself, without without relegating it further. Full stop. Next para. Upon hearing learned senior counsel for the petitioner as well as the learned senior government advocate appearing for the state and the learned advocate appearing for the private respondent, this court does not find any illegality or irregularity in the order of the tribunal, comma, since it is under the 2001 Act, where a power was vested on the Thika controller for the first time to adjudicate the issues in question between the parties. Full stop. Next para. However, comma, we record the fact that the contentions of the writ petitioner on merits are disputed by learned counsel for the private respondent. Full stop. Next para. Be that as it may, comma, in view of the long time which has elapsed in the meantime, comma, it is expected that the Thika controller shall decide the issue in question strictly in terms of the order of the learned tribunal, comma, adhering to the timeline as stipulated by the tribunal. Full stop. Next para. WPLRT 8 of 2025 is accordingly disposed of without interfering with the impugned order dated January 6, 2026, passed by the which bench is second bench,
Second bench.
West Bengal Firms and Tenancy Tribunal in OA 762 of 2024 bracket LRTT, in the light of the above observations. No orders to cause or dissection. Thank you. It ফেরত দিই প্রথমেই affidavit is tried to be kept. Thank you.
Grateful to you, Lordship.
Thank you. Next. Need. In a different matter, we may. Yes.
Always be done.
Yes. What is the matter?
This matter, I am appealing for the respondent number 13.
Private respondent. Yeah.
I am the bargadar of the landowners, the private respondents. I have been cultivating since 1998. My lord, their allegation is that I am not giving the share of the crops, and my lord, I have been engaged as, I have been recorded as bargadar without notifying them.
They are who? They are
the landowners, landlord, Riot. My lord, they preferred an application before the BLRO, and BLRO affirmed
application for removing your name as a bargadar or what?
Removing me as well as that I am not the bargadar. My lord, the BLRO
allowed.
No.
Refused.
Thereafter, they preferred appeal under section 54. The SDLRO also affirmed the BLRO's order that I am the owner. My lord, may I?
You are the bargadar.
Pardon, my lord. I'm
Bargadar, and it was observed that you are paying the share of the produce.
No, my lord, kindly.
And how could you be held to be a bargadar?
My lord, kindly come to the order of the page number 38, order dated 24th June 2019. Second paragraph. Heard both sides at length and examined the documents produced by both sides. After perusing LCR, it transpired that the bone of contention WRT with
respect to WRT is with respect to. Yes.
With respect to the suit land arises in the Borga proceeding drawn up by the learned RO. In case number such and such, the learned RO passed the following order. The name of the petitioner Manwar Hussain. Manwar Hussain, I am Manwar Hussain, my lord, is recorded as Borgadar against plot number 1330 of Mouja, Baborpur, measuring about such and such. The respondent sides has submitted a list of documents through their learned advocates, from which it transpired that the recorded Borgadar has informed the concerned BLRO time to time for delivery of share to produce to the landowners, but each time the bargadar has failed and the landowner refuses to accept the share of the produce. The bargadar has done what he has to do in respect of delivery of share of the produce after each showing reason. My lord, now it is clear that I have tried to give them crops, but they refused. Now, my lord, kindly come to the tribunal's observation, the decision with reason at page 46. The recording of the respondent number 6 as Borgadar in 1998 was illegal, being made without notice to the landowners. In the record of rights at page 18, everywhere it has been shown that I am the Borgadar, Manwar Hussain, Borga. Page number 8.
BLRO did not give notice to them.
BLRO give notice.
Show us the BLRO order. Show us the BLRO order.
Page 34.
Thank you. 30. No, that is the appeal.
54 proceeding.
54.
No, 34 is.
Yeah, 34 is 54. You have not annexed the order of
No,
the
it is not
BLRO.
there. Not there, Lord.
Only 5.
Where is the order of the BLRO?
Before you start, page 36, my lord.
No, 34 to 36 is the appeal code.
Appellate of the test. No, BLR
No, BLRO has not been annexed.
has not been annexed.
But the finding is that the BLRO did not give notice to them. You have not annexed that order. So how can you be sure? Then you have to remand it to the BLRO stage and he'll give notice to him. Then both sides will be heard and it will be decided. They'll also produce their documents. You'll produce your documents. They'll lead evidence and we'll make it a fixed period.
The said observation, the landed tribunal has passed this order.
No, Nallat tribunal has held that recording was. Acha, it has been remanded.
To the BLRO.
Right. Absolutely right order.
But my lord,
Absolutely.
That's why, my lord.
That's
Directed to the appraise to consider the
exactly what we would do.
the appellate order dated such and such is
Yes, that is
non-speaking. It is not a not speaking order. It has non-speaking order.
The appellate
Has
authority's order, we just proceeded on the basis of your submission.
Yes, ma'am.
You have submitted, I have tendered without any proof, any document.
Yes.
You have said that I have tendered, he has refused.
Yes.
Then every tenant in a tenancy also, every tenant will say that I have tendered, but he has refused. Evidence is required to be laid on that. They have to be heard. If the first forum did not hear them, then they did not have an opportunity. Both sides have to be heard. Both sides have to lead evidence, whatever evidence. And then it has to be decided. Perfectly correct order. We won't interfere. We are not interfering and we'll say that we have not interfered with them.
There is wrong in the passed by the landed tribunal's order. Ma'am.
Yes.
Set aside and
The present
back to
challenge
the-
has been preferred by the petitioner, who claims to be a Borgadar in respect of the subject plots of land. Push up next para. Learned counsel for the petitioner argues that the BL and LRO, upon hearing the petitioner, held the petitioner to be a Borgadar. Full stop. An appeal was preferred against the same by the private respondent stroke Rayat, full stop. In an order dated June 24, 2019, the appellate authority observed that the respondent side, within bracket present petitioner, bracket closed, had submitted a list of documents to their learned advocate from which it transpired that the recorded Borgadar had informed the concerned BL and LRO time to time for delivery of the share of produce to the landowners. But each time the Borgadar had failed and the landlord refused to accept the share of the produce. Full stop. It was further observed that the Borgadar had done what he had to do in respect of delivery of the share of the produce after each sowing, SOWING, sowing season. Full stop. Consequentially, by a subsequent order, what is the date, page 39? The left-hand margin has cut off.
Yes.
It is 10th July, my lord.
It is recorded in the tribunal's order.
Lordship.
My lord, 10
Lordship.
July, 10.
Thank you. Subsequently, yes, we have seen. Subsequently, by an order dated July 10, 2019, the appeal was dismissed. Full stop. Next para, the private respondent stroke Rayat, within bracket landowner, bracket closed, being aggrieved against the said order of the appellate authority, moved the West Bengal Land Reforms and Tenancy Tribunal, which, by the impugned order, observed that the recording of the present petitioner as Borgadar in 1998 was illegal, being made without notice to the landowners. Full stop. Next para. The appellate authority's order was held to be non-speaking and mechanical, lacking judicial reasoning. Full stop. For the above, on the above grounds, the matter was relegated to the BL and LRO for a fresh hearing and adjudication on merits. Full stop. Next para, learned counsel for the petitioner submits that the order of the appellate authority was quite reasoned and, as such, the learned tribunal erred in law in setting aside the same. Full stop. Next para, on the other hand, learned counsel appearing for the private respondent stroke Rayat submits that the order of the learned tribunal is justified, inasmuch as proper reasoning was not given by the appellate authority, and since no notice of hearing was given to the private respondent stroke landowner before the BL and LRO came to the finding that the present writ petitioner is a Borgada. Full stop. Next para, on a perusal of the orders of the appellate authority, we find that although the appellate authority adverted to a list of documents filed on behalf of the writ petitioner, at the same time, we cannot overlook the fact that the appellate authority accepted the unilateral version of the writ petitioner as the gospel truth without adverting to the stand taken by the landowner stroke Rayat. Full stop. Next para, that apart, the order of the BL and LRO has not been annexed to the present writ petition. Full stop. There cannot be any reason to doubt the finding of the learned tribunal, which was the last court of facts, to the effect that the order of the initial order of the BL and LRO was passed without notice to the landowners. Full stop. Next para, thus, we do not find any illegality in the order of the learned tribunal, inasmuch as the initial hearing given by the BL and LRO was illusory, since the Rayat did not have an opportunity to present his case. Full stop. Next para, accordingly, there is no scope of interference with the impugned order. Full stop. Hence, WP LRT 9 of 2026 is dismissed, thereby affirming the impugned order dated
25th September, Lord.
September 25, 2025, passed by the third bench, West Bengal Land Reforms and Tenancy Tribunal in OA number 230 of 2022 within bracket LRTT. Full stop. Next para, however, we make it abundantly clear that this court has not entered into the merits of the matter, and it will be open to the BL and LRO to re-adjudicate the issues before him afresh in accordance with law, in terms of the directions of the learned tribunal. Full stop. No orders to cause urgency. You tried well, but sorry. This is a good order. You fight out before the BLRO, you should get a order if you have the materials. Thanks. Next. Yes, 20. None appears for the parties. Yes. Yes, what is the matter?
In this matter, I am.
Yes.
This is evident to service.
Yes. Yes. We wanted to hurry you up so that you start the. Yes. Yes, Mr. Shah, what is it?
Before going to records, just hear me.
If you are a relative of the petitioner, then we are not hearing it. H and W difference in name. W, yes. Yes, Mr. Shah, what is it?
Before going to petitioner, my lord, the owner in respect of this property, since the date of CS, RS, and LR, my lord, the rent has been paid from the date of RS and till date of the LR. Now, my lord, total area is 11 decimal. Only 11 decimal. Plot number 270.
270?
272. 270. Now, sometime, my lord, the state authority stopped for receiving the, my lord, the rent receipt. My lord, on query, they said that land certain portion has been vested to this time. I made an application under the RTI Act with a view to know whether the land is vested, what is the position, whether the land is vested to this person. On the basis of the application, they furnished a report by saying that land has been vested. They have, my lord, they pointed out a case number, and they have taken that the land has been, my lord, the taken possession under section 10(2) of the Estate Acquisition Act. Now, my lord, immediately thereafter, I made an application for obtaining the certified copy of the order, so that I can take step further. Now the my lord, the trouble has started. That application was made to the ADMLR. Now the ADMLR circulated to the my lord, the Bosirat 2, where the land is situated, supply it. Now they supplied in information by saying that this my lord, the proceeding may exist either in Hasnabad, either in my lord, the Bosirat 1 and Bosirat 2. After getting it, my lord, I made
Which authority is saying this?
my lord, the BLLRO Bosirat 2. I will show
Bosirat 2.
2. Yes, I will show the my lord, the document.
Yes,
one
yes,
by
yes. Just let us hear it. Yeah.
Thereafter, my lord, I made an application. All the authorities says that the my lord, no proceeding is there. Hasnabad says that no such proceeding is there. Bosirat 1 says that no proceeding is there, and the Bosirat 2 says that the file is not traceable. Thereafter, my lord, finding no other alternative, my lord, a repeated representation has been made for obtaining the. Thereafter, I made an application for certified copy of the order. My lord.
No, initial application was certified copy application.
No, RTS, with a view to know what is the fate. When they disclose.
So RTI gave rise to this hornet's nest and all these things. Then you applied for a certified
copy
before
of
Bosirat 2.
Bosirat 2, because of the land is situated in the Bosirat 2.
Yes.
Now that application was not disposed of. That is why I traveled to the tribunal.
Not disposal.
Not disposed. Travel to the tribunal.
Tribunal says?
Now that was in the year of 2013. 13, yes. Now the tribunal repeatedly, my lord, directed the authorities for furnishing the report. All the report says, they are saying, sometimes they are saying the land is vested under section 4 and 5 of the Estate Acquisition Act. Sometimes they are saying that the land has been vested under section 6(1) of the Estate Acquisition Act. Sometimes they are saying they have pointed out a case number. Case number 2 of
25
they have said the case number 2 of 72. Oh, case number 6 of 1972. 6 of 1972.
The case number remains constant.
Constant. Now, sometimes they are saying that this case number pertaining to my lord, the section 10(2) of the Estate Acquisition Act. My lord, they are not sure. Now, and ultimately, my lord, an application was made for obtaining the certified copy of the order. Now, your lordship kindly come. What was my original order in the read application? Original application, page 52. Your lordship kindly. Page 52 is the original application. This is my prayer.
Page?
Page 52. That is the prayer of the original application. Have you lordship got it, man?
Yes.
This is my innocuous prayer that supply certified copy. Nothing more, nothing less.
What did the tribunal say?
Tribunal says that you have got no locus standi. And tribunal, my lord, on merit dismissed it. That you have no right. Nothing of this.
You claim to be a riot in respect of the property?
Yes.
You claim to be a riot?
Yes, I have got all the documents I have.
What is the finding of the riot? Page 3 of the tribunal, let us come there.
Yes, your lordship kindly.
Locus standi, permissive possessor. So you were recorded all along as a permissive?
Yes, your lordship kindly say come.
Permissive occupier?
Your lordship kindly come.
How can you claim to be a riot?
My lord, permissive possession in the year of 19, in the CS part. Thereafter, my lord, as soon as the estate acquisition came into force, my lord, that I was still in possession. I have paid rent, my lord, to the state of West Bengal till, my lord, the LR.
Say that you become a direct
at the state. My name has also been featured in the RS record.
And in any event, you have a right to get a certified copy at least.
Yes, only that. Nothing more, nothing.
Your right has been pre-decided.
Pre-decided.
Yes.
This is the whole case.
You have said what you said to him, that we say to you.
My lord, actually, my lord, his prayer for certified.
We'll set aside this, we'll direct the certified copy to be given. If the certified copy is not given, then what will happen, Mr. Mahato?
My lord,
then it will be treated that there is no such
no such proceeding vesting unless the vesting is there. my lord, his right cannot be, my lord, curtailed. And 10-2 is given. 10-2 can comes only after 6-1
6-1,
proceeding.
yes.
10-2 comes only after 6-1.
You know the law much better than us, both of you.
No, my lord.
That is
Better than me. Justice Bhattacharya may know it better because he was in the trial courts also. But both of you know it better than me, and you know that is the follow.
That is the follow, my lord.
that
So
is why he
we
has
are wondering only whether to put that in our order. That if it is not done within a limited period, it will be deemed that there is no such order.
yes.
My lord,
That
I
is the
can-
extrajudicial part of
my
it,
lord, I cannot
which
say-
can be you can take it up in challenge. That last portion that will be modified. The rest will remain. Anyway,
That is why he has fairly submitted.
the petitioner, learned counsel for the petitioner argues that the
No.
writ petitioner, the writ petitioner has been recorded to be in possession of the subject plot bearing plot number 272, comma, comprised of 11 decimal of land, comma,
Vastu, nature of Vastu.
within bracket, Bastu, bracket closed, all along, comma, from the regime of the CS records, comma, RS records, till the LR records of rights. For sub next para, although initially in the CS records, comma, the petitioner was recorded to be a permissive occupant, comma, by introduction of the West Bengal Estate Acquisition Act, comma, 1953, comma, the petitioner became a direct tenant under the state. For sub next para, however, comma, subsequently, when the petitioner, comma, on certain occasions, comma, attempted to deposit rent in respect of the property, comma, the concerned authorities refused to accept the same, and an impression was given that the petitioner, that the land in question had vested in the state. Full stop. Upon being thus apprehensive, comma, the writ petitioner made an application for information in that regard under the Right to Information Act 2005 before the ADMLR, Bosirhat. ADMLR is Barashat.
Not 24 Pargana,
Right. ADMLR, comma, North 24 Parganas, within bracket, Barashat, bracket closed, full stop. Next para, the matter, ADMLR sent it to BLR or Bosirhat too.
Yes.
The ADMLR relegated the matter to the BL and LRO, comma, Bosirhat 2, which was who was of the opinion, who was unsure as to whether the records would be available with the Hasnabad or Bosirhat 1 authorities. Full stop. Next para, accordingly, comma, it is submitted that the petitioner ran from pillar to post by approaching all such authorities, but ultimately having met a dead end before such authorities, comma, returned to the BL and LRO Bosirhat 2 and applied for a certified copy of the alleged order of
Case number 6 of 19.
of the relevant papers pertaining to BR case number, BR case number
6 of
1972, comma, which was the number provided by the said authorities.
You also can mention the date, 28 June 2018.
On that you made that application.
Yes, yes, page 96.
Which of such application, comma, we are apprised, comma, was made on June 28, 2018.
Yes.
Full stop. It is submitted by learned counsel for the petitioner that at different points of time, comma, the authorities gave out different provisions under which the aforesaid proceeding took place, comma, sometimes citing section 6 within bracket 1, comma, at others sections 4 and 5, and at still other times section 10 within bracket 2 of the 1953 Act. Full stop. Next para, be that as it may, comma, ultimately no certified copy having been provided, comma, the writ petitioner was constrained to move the West Bengal Land Reforms and Tenancy Tribunal, which, comma, by the impugned order dated March 21, 2025, comma, not only rejected the original application of the petitioner, but observed that since the writ petitioner was recorded to be in permissive possession, comma, the petitioner did not have any locus standi to seek a certified copy or raise a challenge regarding the records of the proceeding number 6 of 1972. Full stop. It is submitted that not only did the tribunal prejudge the issue, comma, but closed the right of the petitioner of getting a certified copy in the list. Full stop. Next para, learned additional government pleader, comma, appearing for the state, submits that that in view of the writ petitioner being recorded as a permissive possessor, comma, no locus standi accrued in favor of the petitioner. Full stop. Next para, upon hearing learned counsel, comma, this court finds that the impugned order of the learned tribunal was palpably dehorsed the law. Full stop. Any and every person has the right to obtain a certified copy in the list, comma, of any public records. Full stop. That apart, comma, the writ petitioner, comma, being in possession of the property, comma, which is not disputed by any party till date, comma, has all the more a vested interest in obtaining a certified copy of the purported case number 6 of 1972, comma, in order to enable the writ petitioner to prefer a challenge against the same. Full stop. Next para. Secondly, comma, it was premature for the learned tribunal to hold that the petitioner does not have locus standi merely on the basis of the recording in the CS records that the petitioner was a permissive possessor, comma, since, comma, by operation of the West Bengal Estates Acquisition Act 1953, comma, the petitioner ought to have become a direct tenant under the state, comma, unless, of course, there was a proceeding to the contrary. Full stop. Next para. Since the state authorities have miserably failed till date to furnish any certified copy of the said proceedings, comma, the obvious corollary would, comma, in normal circumstances, comma, be that it would be disbelieved that there was ever any such proceeding, and the petitioner ought to be construed to have become a direct tenant under the state. Full stop. Next para. Be that as it may, comma, at this stage, comma, this court does not want to enter into any conclusive finding in that regard. Full stop. However, comma, since the petitioner has formally applied for a certified copy, comma, the learned tribunal ought to have directed the BL and LRO, comma, Bosirhat 2, comma, to furnish a certified copy as sought by the writ petitioner, comma, in respect of case number 6 of 1972. Full stop. Next para. We make the above observation, comma, since the land in question is situated within the territorial jurisdiction of the said BL and LRO. Full stop. Next para. Accordingly, comma, WPLRT 10 of 2025 is allowed on contest, comma, thereby setting aside the impugned order dated March 21, 2025, passed by the second bench, comma, West Bengal Land Reforms and Tenancy Tribunal in OA number 2674 of 2018 within bracket LRTT, and directing the BL and LRO, comma, Bosirhat Roman 2, comma, District North 24 Parganas to furnish certified copies in terms of the application made by the writ petitioner in respect of the purported proceeding number 6 of 1972, comma, if necessary, upon tracing out the records from his own records and or the records of any other jurisdiction, comma, including Hasnabad and Bosirhat 1, comma, if not available with the office of the BL and LRO, comma, Bosirhat 2. Full stop. Such exercise shall be completed within an outer limit of 1 month from the date of communication.
6 weeks.
Within a period of 2 months from the date of communication of this order to the BL and LRO, comma, Bosirhat Roman 2. Full stop. A certified copy of the relevant papers, comma, in terms of the application of the writ petitioner shall be furnished to the writ petitioner by the said BL and LRO, comma, Bosirhat 2 within such period of 2 months from the date of communication of this order to the BL and LRO. Full stop. Next para. In the event no such certified copy is furnished, comma, it will be construed that the petitioner that there never was any existence of such proceeding, comma, bearing number 6 of 1972, and the writ petitioner shall be entitled to proceed on the premise that the writ petitioner has become a direct tenant under the state, full stop. In such circumstances, comma, the writ petitioner shall go on paying the necessary rates and charges stroke taxes to the appropriate authority of the state, which will be accepted by the said authority without any demur on the issue that the writ petitioner is not a riot in respect of the subject property. Full stop, no orders to cause certain certificate. Prothomei affidavit size filed today. You got a better relief.
Better relief. One trend may I make only. I have paid rent. This is the rent issue. You also kindly add one line that already I have.
You have already held that view.
Yes, yes. I'm deep.
পার্সিকা পেয়ে গেছে, সোলানের জায়গায় পার্সিকা পেয়ে গেছে।
Yes. Plot of land টা আগে বলে দিয়েছি নাম্বার। প্লট নাম্বারটা ওই জন্য মেনশন করে। এসব বলতে গেলে কমপ্লিকেশন কি হবে? প্লট অফ ল্যান্ড মেনশন করেছি, এন্টার যদি না বলে দিই পার্ট, তাহলে তো এন্টার হবে। Yes.
My lord, I am appealing for the petitioner. My lord, this is the matter, my lord, where the where the
private respondent is there.
Yes.
Good service affected.
My lord, service has been affected.
Please check up, Mr. Dhol, whether the private respondent has been served.
Expeditious disposal.
Oh, yes.
Expeditious disposal.
When was it filed?
My lord, in 2022. In 2022, what happened, my lord? I am the private respondent in that petition. My lord, what happened is
then
that,
please check up whether you have served, because otherwise he'll not know. His proceeding will be expedited.
Next date in tribunal is 25th August 2026.
What is the nature of the application? The challenge.
Lord,
It's the application by the
challenging the my lord appellate order.
From arising from?
Arising from my application.
Under which provision?
My lord,
original application was for?
Original application, my lord, I have made a prayer for correction of the record of right.
Section 50.
Under my lord, my lord, for 51A4. My lord, I was a purchaser. My name was recorded. That is no question, my lord. The classification of the land was part my recording, my lord, is VT. Now, my lord, suddenly on the application of the private respondent, it has changed to playground. My lord, that playground was there, my lord. I made an application before the authority, my lord, to change the it from playground to VT because it is not on the basis of any document. My lord, that was, my lord, after my lord approaching the tribunal twice, my lord, that was my lord rejected by the my lord BLLRO.
Pro forma respondent. Why pro forma respondent?
Pro forma respondent.
He's with you.
One of my my lord brother died. His son is far off, my lord. So
this Torun Sangho represented by please check up whether it has been served. If it was the petitioner's application, the applicant's petition, then we could have understood, but without their knowing. Anyway, we will direct you to serve a copy of this order on the private respondent.
Lordship.
We will pass an order. We will dispose of and direct you to serve a copy of this order on the private. Affidavit of service filed to be kept on record. In view of the innocuous nature of the prayer, comma, we take up the application for hearing. Upon hearing learned counsel for the parties, comma, it transpires that the writ petitioner, comma, with the grievance that the subject plot, comma, being in the nature of VT.
It is served, my lord. It is served, my lord. Kindly turns to page 5.
VT, within single inverted, comma, was erroneously recorded as a playground at the behest of the private respondent. Full stop. Next para. Accordingly, comma, the petitioner sought for a correction of the records of rights, comma, from which a challenge was preferred before the appellate authority, comma, ultimately culminating in a challenge at the behest of the private respondent before the tribunal, before the West Bengal Land Reforms and Tenancy Tribunal. Full stop. the said challenge, comma, bearing OA number 728 of 2022 bracket LRTT bracket closed is pending before the tribunal since the year 2022. Full-stop, it is submitted that the petitioner is unnecessarily having to take the trouble of pursuing the litigation before the tribunal since its inception and seeks for an early disposal of the said original application. Full stop. Next para, as it appears from the affidavit of service that the private respondent within bracket applicant before the tribunal bracket close has been served, comma, there is no impediment in disposing of the present petition in the following terms, colon diye. Next para, WPLRT 11 of 2026 is disposed of by directing the second bench of the West Bengal Land Reforms and Tenancy Tribunal, requesting the second bench of the West Bengal Land Reforms and Tenancy Tribunal to dispose of OA number 728 of 2022 within bracket LRTT. Finally, comma, within an outer limit of 6 months from the date of 6 months from the date of communication of this order to the tribunal. Full stop. Next para. Since we are apprised that the next date fixed before the tribunal is August 25, 2026, comma, in order to implement the above direction, comma, implement the above request, comma, the tribunal shall shift back the next date. Full stop. Next para, it is expected that the timeline given above shall be strictly adhered to. Full stop. We express further that the merits of the respective contentions of the parties before the tribunal have not been entered into by this court. Full stop. No orders to cause urgency. Thank you.
Lordship is giving 6 months.
6 months, yes, 6 months.
It comes to August only.
Comes to the same, but the date has to be preponed because if it starts on August, it won't be finished. We are saying it should be finished by that. It has to be shifted back.
Appellate authority has directed 5 days for correction by the BLLR, and that has been lingered for since 2023.
Good. Thank you.
Yes.
Oh, one second.
I'm developing.
DL and A. একদম ঠিক।
Next.
Number 22.
20.
Yes.
May I, my lord,
state is
back tomorrow, my lord,
Why? What happened?
I missed the list, my lord. I could not go through the.
On the prayer of the state, let the matter stand adjourned for the day.
Lordship.
Next.
Number 23.
23, my lord, I
have granted adjournment as an exception to you because you are appearing in every matter which is called on. So that's why. That's the only exception we have made today.
Lordship.
Yes. I appear for the petitioner, my lord. This is matter, my lord. I just told, my lord, this matter, my lord, initially I moved the learned tribunal, my lord, seeking for correction of the record of rights. My lord, in terms of a decision passed by the Honorable Court and affirmed by the division bench. Now, my lord, the learned tribunal, my lord, allowing my original application, my lord, passed the direction that his name may be there in the record of rights, and my lord, the subject land should be treated as Danga in case of forest. Now, Lord, against that, they moved a writ petition before this Honorable Court in WPLRT number 50 of 2016. That got dismissed. Lord, they moved this Honorable Supreme Court. The SLPs was dismissed. Lord, they came back here and filed a review petition before this Honorable Court again. Lord, review was also dismissed. Lord, now they have again went to the Supreme Court. In the Supreme Court, they have said now they will review the earlier SLP order. This was their contention, my lord.
Review of earlier SLP order that review application has been filed.
I do not know, my lord. Nothing has been served upon us.
Name is the state.
State. Now, lord, now,
yes, so please
now,
continue.
lord, this been the situation, my lord. I mentioned before the matter, but initially, my lord, one show cause was filed before the state, although in the date says the review is pending, and thereafter they moved the. My lord,
review means the second review, the before the
second review. No, my lord, review before this Honorable Court. Lord, against that, they have already preferred an SLP before the Honorable Supreme Court. They have said in the show cause.
Whatever is pending now, if it is pending at all, is it before the Supreme Court.
Supreme Court.
One, the SLP against the review order.
Yes, my lord.
And the other, the review to the
Earlier
previous
SLP.
earlier SLP.
Well, I do not know whether they have filed it or not, but there is no stay. But the learned tribunal reluctant to proceed in the contempt proceeding. Well, I mentioned the matter, my lord, when the matter came up. The learned tribunal fixed the matter, my lord, on.
Pass a direction on the Supreme Court to decide the matter.
No, I will never say so, my lord.
So then that is what it tantamount to, Mr. Rai. How
There is
can
no
it-
stay.
the tribunal was justified? We would have done the same thing. We would be hesitant if it's pending before this. In umpteen matters, the Honorable Supreme Court is saying that how dare the High Court proceed with in a different language, obviously. How dare the High Court proceed with the matters since it's
Well,
we are in season?
I understand your lordship.
Now, what can the poor tribunal do?
Well, I'm just saying, my lord.
We are in mortal fear of the Supreme Court.
Well, I'm just subject lordship kind leave. My lord, in case of a application along with the stay applications, then this modern orders are there, my lord. Normally, the court should not be proceeding. But my lord,
The
in
law
case
is
of
that
review,
if there is no specific stay order,
yes,
there is no bar.
But in case of a review, my lord, what they have said, my lord, if your lordship sees two orders, my lord, thereafter your lordship may decide. My lord, this is the order. My lord, this is the order in the, my lord, before the Supreme Court, last order. My lord, your lordship kindly have a look.
Mr. Rai, as a rule, whatever you hand over to us, give a copy to your.
Purely hand over, my lord.
My lord,
This is
I
the
am with the instructions, my lord.
Now you'll have the copy also.
Two proceedings are pending. He has.
And my lord, if your lordship kindly have a look at the order of the Supreme Court in my lord, Reliance Industries was Vijay and A. Well, it says, in case, well, your lordship kindly have a look at the order. My lord, order dated on 22nd of September 2025, what they said. The learned senior counsel for the petitioner submitted that this special petition may be adjourned so that the petitioner state of West Bengal could file an application seeking recall review of the order dated 6/10/17 passed by this court in the earlier special petition. So, my lord, undisputed fact, if they do, they have to file a review petition. My lord, your lordship can have a look at this order of the honorable court.
But the next page, what is that?
My lord, that is the earlier order of the SLP. Next page, the earlier order of the SLP, which was dismissed. A single line order, your lordship will find.
Yes. Yes.
Now, my lord, in case of a review, if I'm subject to lordship, kindly, if your lordship allows me to say, now what they can do, they can file a review.
Scope is much limited.
They can only review limit.
It's not an original challenge that.
Yes, my lord. Now, my lord, this your lordship knows Reliance Industries order is there.
Don't know.
Or your lordship can have a look. I think this is more or less settled the issue, my lord.
Another copy for him.
Just move it. Hand over.
Yes.
But your lordship will have upon. But your lordship can turns up to the next page.
Yes.
Lord, second paragraph. We have gone through the aforesaid decisions and the subsequent orders of this court dated such and such in a review petition criminal number such and such. The pendency of an appeal or a writ petition along with the stay cannot be equated to the pendency of a review petition.
Yes.
There is a final decision by this court in an appeal. Merely because a stay application is pending in the review petition cannot be the ground to stay the respondents on its own and not to comply with the direction issued by this court. So, even if they assume they have moved the review petition, that is not a bar for the tribunal to proceed. It is required to be noted in the state of J&K versus Muhammad Yaqub Khan and others was the case. There is a ex parte order passed by the learned single judge. Pending writ petition, the contempt proceedings were initiated. Therefore, this court observed that when a stay application is yet to be heard and decided and disposed of, the contempt proceeding cannot be initiated under the circumstances.
We get your point.
Decision cannot be.
We get your point, Mr. Rai.
So, Malad, this nothing that stops.
Let's hear Mr. Rai. Yes, Mr. Gali, you have
My lord,
filed a review.
No, yes, lordship.
Number?
May I, my lord, hand over this to my lord instructions copy. My lord, page 45 of the writ petition is the order under contempt was challenged. Order under contempt was under challenge in a WPLRT 50 of 2016. That is page 45. State lost. Preferred SLP. SLP dismissed. Thereafter,
no, what is the number of the new review? Second review. This is, you have handed over this.
There are two reviews, my lord. Pending.
One review against the original SLP order.
I'm the sequence will be clear, my lord. So, my lord, first WPLRT 50 or 2016 state lost. Here the challenge was the order which is under contempt. Now, my lord, state prefers a review before a coordinate bench of this court. That is, my lord, page 77. Page 77. Review dismissed. Now, from the parent order passed in WPLRT 50 or 20.
WPLRT was their WPLRT, which was allowed.
No, it is state's WPLRT. The state suffer an order in before the learned tribunal, and a
yes.
state preferred one WPLRT, that is 50 of 2016. That is the order which my learned friend is.
So tribunal passed an order. Against that, they preferred. You preferred.
State preferred an appeal, that is WPLRT 50 or 2016.
That was dismissed. So they
State
took out
lost.
contempt application in respect of the tribunal order.
That was
which was affirmed.
Yes.
Achha, you preferred at page 77 is the review dismissal in respect of
No,
the
my
first
first page.
WPLRT.
Page 1 is the moment this was dismissed. Page 40, that is WPLRT 50 or 2016 judgment. This was carried forward in SLP. SLP dismissed.
That's the second page order, please. My lord.
And then you took out a review of the WPLRT order.
Review was
Dismissed.
of the WPLRT. Review
Again,
dismissed.
another SLP, first page.
Yes, my first page.
Lordship. Now, while that SLP was being heard,
You grew wiser and you thought that you would prefer a review against the previous SLP.
now when this review was, second review was being heard by the Honorable Supreme Court on 22nd September 2025, which
Second review was not being heard.
this is review.
That was the first review.
This is, yes,
That was the SLP against the review of this
against
court.
review. SLP against review of 164.
So we are asking you, have you filed the second review?
Yes, yes, my lord. So, my lord,
What is the
yes,
number?
we have already.
What is the number?
So, in that,
Number.
that is the number, my lord. Lordship will kindly come at page, my lord, 6. That is the lawyer's communication, which you are getting. Kindly see review petition VDA number 7208 dated 12th at page 6, my lord.
Yes. So what is the stage of that? Has been filed only.
That is further development will be mentioned.
So there is no bar.
It is
You
a
are filing
communi-
review after review after review. Review is very
No,
important.
this is the review which
We
has
follow the Supreme Court judgment. Now we have a handle.
This is the recalling petition which was, my lord, filed, my lord, pursuant to the liberty given by the Honorable Supreme Court. That you can bring in the recalling of the earlier dismissal.
Prepare another challenge against SLP against our order. We'll follow the Supreme Court and say that no, contempt should proceed.
So, my, this is the, my lord, fact I have brought.
We cannot indefinitely wait, Mr. They cannot indefinitely. We can wait indefinitely. We do.
But, my lord,
But they can.
It's a Chinese luck, my lord, and Supreme Court has given the
So
liberty.
filing review of liberty is always there.
No, my lord, even Supreme Court, my lord, even the original order, which my learned friend is taking up for contempt, that was under challenge before Honorable Coordinate Bench.
The original challenge has been turned down. Your challenge has been turned down.
Now, again, Supreme Court is giving
Now
a
you
liberty.
are on review. Review before this court, SLP against that, and review before the Supreme Court. So both arise from reviews. Review scope becomes much more constricted, as held by the Supreme Court also, and rightly.
And my lord, Honorable Supreme Court is giving a liberty that you can also prefer recall or review of the earlier. My lord, kindly sees, my lord, 22nd September 2025
Yes.
order. That learned senior counsel for the Swansea submitted special leave may be adjourned so that the petitioner state could file an application seeking recall review of the order dated.
No leave is no liberty or anything of that sort is given. You sought for an adjournment, you want to file a review, that is adjourned.
And that was
But
granted.
it's a question of a liberty being given to you. And even if liberty was given, that would not inure to your benefit. No right would be accrued in your favor. You asked for adjournment, Supreme Court granted adjournment, whatever was the ground. And we are going on asking adjournments and they'll wait indefinitely. What was the nature of the direction? The correction of records of rights.
My lord, that
This
is
one from forest to Danga.
Forest to Danga. Let that be done. That will abide by the result of whatever you win. If you win in the review, that will go. We'll make that clear.
No, my lord,
But this is contempt. Sorry.
This is he is asking for expeditious disposal of the contempt application before the learned tribunal.
You are in contempt.
No, let it be heard before the learned tribunal, my lord.
Yes, we are directing that. That we are,
that is not my
we
submission.
accept your prayer.
No,
We'll direct the tribunal.
I am placing the fact as on date, Supreme Court, in my humble understanding, is in season of the matter, even the parent order as well as the review order.
We'll consider that and pass it.
Lordship. And his prayer is here is expeditious disposal of contempt before.
No, we'll direct that one. We'll direct that.
I'm opposing that.
Learned counsel for the petitioner submits that the petitioner has been waiting for a prolonged period to get the fruits of litigation. Fruits of next para, initially, being aggrieved by the recording of the subject plot as it was recorded as Danga.
Initially, it's Danga.
As Danga instead of
forest.
You want Danga or forest?
I want Danga, my lord.
Acha, recorded as forest instead of danga, comma, the petitioner moved the appropriate authority for correction of the records. Full stop. Next para, ultimately a favorable order having been passed in favor of the petitioner in that regard, comma, the matter came up to this court in a challenge preferred by the respondent state by way of a writ petition. Full stop. The said writ petition being dismissed, comma, thereby affirming the order of the tribunal, comma, the present writ petitioner preferred a contempt application before the tribunal for violation of its order. Full stop. Next para. Simultaneously, comma, the state had preferred a special leave petition against the order of this court, whereby the state's writ petition was dismissed and the tribunal's order was affirmed. Full stop. However, comma, the said SLP was dismissed by an order dated October 6, 2017. Full stop. Next para. Thereafter, comma, the state took out an application for review of the order of this court passed in the state's initial writ petition, which was also dismissed. Full stop. Being aggrieved by the dismissal of the review application before this court, comma, the state intended to file a further special leave petition, full stop, from an order dated September 22, 2025, passed in the earlier SLP, comma, it transpires that the state sought for an adjournment to enable it to file the further SLP against the dismissal of its review application. Full stop. Next para, learned senior government advocate appearing for the state hands over a bunch of papers, including a printout of an email dated December 16, 2025, indicating that a review petition, that a petition for review of the Supreme Court's initial order of dismissal of SLP has been preferred, bearing review petition, bearing diary number 7208 dated December 12, 2025. Full stop. Next para, learned counsel for the petitioner submits, comma, by placing reliance on an unreported judgment of the Honorable Supreme Court in the matter of Reliance Industries Limited versus Vijayan A, comma, that the position is different if if a substantive appeal is pending against an order passed by the High Court, comma, which cannot be equated with the pendency of a review petition, comma, the scope of the latter being limited. Full stop. While in case of a substantive appeal, comma, the Honorable Supreme Court expressed the opinion that contempt proceedings cannot be initiated in view of the pendency of such appeal, comma, the said advantage is not available to the order-debtor in case of a review application. Full stop. Thus, comma, learned counsel submits that the learned tribunal may be directed to dispose of the contempt application pending at the behest of the writ petitioner at the earliest. Full stop. Next para, learned senior government advocate opposes such prayer and submits that since a review petition has already filed with regard to the dismissal of the earlier SLP, as well as the second SLP is still pending, comma, it would not be appropriate for the learned tribunal to proceed with the hearing of the contempt application. Full stop. Next para, upon careful consideration of the submissions of parties, comma, we choose to abide by the proposition laid down by the Honorable Supreme Court in the order dated November 7, 2022, passed in contempt petition within bracket C number 570 of 2022 within bracket Reliance Industries Limited versus Vijayan A. In the said full stop. In the said matter, comma, the Honorable Supreme Court, comma, while discussing an observation of a previous learned single judge of the a previous bench of the said court in state of J&K versus Muhammad Yaqub Khan and others, comma, to the effect that when the stay application is yet to be heard and decided and disposed of in connection with an appeal against the parent order, comma, the content proceedings cannot be initiated, comma, held in no uncertain terms that the pendency of an appeal and stroke or writ petition along with stay cannot be equated with pendency of a review petition. Full stop. In the latter case, comma, there is a final decision by the court in an appeal, and merely because the stay application is pending in review petition cannot be a ground to grant stay by the respondent on its own and not to comply with the directions issued by the Honorable Supreme Court. Full stop. Next para, borrowing the said proposition, comma, in the present case, comma, the substantive special leave petition, comma, bearing SLP number
28736.
Is it so?
No, no,
That was diary number in the
277.
Actually, 22nd September order lordship is getting, then that is diary number, which was subsequently SLP number is 28736.
Bearing SLP number 28736 of 2017.
Lordship.
Of 2017 within bracket diary number 27716/2017 bracket closed. Sentence শুরু করলাম কি in view of the হ্যাঁ তারপর comma, preferred by the state against the dismissal of its writ petition on the earlier occasion, comma, was itself dismissed vide order dated October 6, 2017. Full stop. Next para, at subsequently, comma, the state grew wiser and has now taken out a review application before the Honorable Supreme Court against the said dismissal of SLP, which is pending. Full stop. Next para, on the other hand, comma, despite having preferred an SLP against the order dismissing the state's writ petition, comma, an application for review of the self-same order of the writ court was preferred by the state, which was also dismissed. Full stop. Against the said dismissal of the state's review application, comma, the other SLP, comma, bearing SLP number 44742 of 2025 is also pending before the Honorable Supreme Court. Full stop. Next para, thus, comma, in both the said cases pending before the Honorable Supreme Court, comma, the stage is that of review, comma, either by the first court or by the Honorable Supreme Court itself, comma, a substantive adjudication having already culminated in dismissal against the state up to the Honorable Supreme Court. Full stop. Next para, hence, comma, the proposition laid down in Reliance Industries Supra is squarely applicable to the present case, comma, since the substantive challenge to the parent order of the tribunal has already been turned down up to the Honorable Apex Court of the country. Full stop. Next para, repetitive filing of review applications and SLPs against dismissal of the same by the state does not confer a special right in favor of the state to drag on the contempt proceeding in respect of the parent order of the tribunal. Full stop. Hence, comma, following the proposition laid down in Reliance Industries Supra, comma, this court is of the opinion that there is no impediment in the learned tribunal taking up the contempt application and taking it to its logical conclusion. Full stop. Accordingly, WPLRT 14 of 2026 is allowed, comma, thereby requesting the first bench of the West Bengal Land Reforms and Tenancy Tribunal to take up for consideration and dispose of which one? MA 53?
125. MA 120 is the contempt, my lord.
Prayer C, kindly see prayer C, lordship.
Disposing of
Page 21, prayer C, my lord.
Thank you. Yes. MA 125 of 2017 within bracket arising out of OA number 233 of 2011 bracket closed as expeditiously as possible, comma, preferably within We'll give them 2 months.
Next date is
Within-
4th August.
Within 2 months from the date of communication of this order to the learned tribunal, comma, by shifting back the next date already fixed by the tribunal in order to comply with the above request. Full stop, no orders to cause unnecessary.
My lord, the affidavit of service be kept with the record.
প্রথমেই affidavit service.
Date.
My lord,
My lord, reports be retained with the record, Lordship.
Acha, the copies of the orders of the Honorable Supreme Court handed over by learned counsel for the writ petitioner, as well as the bunch of documents, including communications, comma, handed over by the learned senior government advocate for the state, today be kept on record.
My lord, that is dated 3rd February 20. Lordship.
my lord, 11
Yes.
My lord, I am for the petitioners in this matter. May I file the affidavit in service? My lord, here it is written that if service has been effected upon the private respondents,
Yes, I have
6 and 7, one of the private respondents is present, the other private respondent, it is stated that the address is not correct as per the record. But I have taken the address from the OA application itself.
It's their OA application.
Their OA application, my lord.
You are appealing not for the all the private respondents.
No, one. My lord, respondent number, my lord, 6.
From the from the affidavit of service filed today, which is kept on record, it transpires that all the parties, apart from one of the private respondents, has substantially been served. Insofar as the non-appearing private respondent is concerned, learned counsel for the petitioner submits that the postal article was sent to the address of the said private respondent as available from the private respondent's own original application before the tribunal. As such, we deem good service to have been effected on all the parties and take up the matter for hearing. Yes.
Lord, I have come before your lordship from an MA application appearing at page 233 and the prayer at page
that can be
247.
That can be directly disposed of.
Kindly see on 7th.
He has not even started and you people are disturbing him.
Sorry.
What is this?
At page 247, my lord.
Yes, let us see what is the prayer.
Yes.
The prayer was C, pass an ad interim order keeping in abeyance the operation of the said interim order passed by this Learned Tribunal on 24/1/2025, extended till 6/4/2026 till disposal. Your lordship may kindly come to the order at page 249. The tribunal has even refused to record my order and rejection of the prayer, which I have stated at page 16 of the petition, where I have stated that the applicant has not come up with clean hands. The applicant has come with fraudulent documents.
You want at least an adjudication of prayer C?
Lordship.
Ad interim.
Lordship.
Mr. Kalabi is also saying so. Let us hear you, learned friend. Yes. We'll just direct the tribunal to immediately adjudicate prayer C.
Can you see on 7th January 2026?
We read that. That was placed before us.
Last order.
Yes.
That
we have read that.
Yes. Liberties kindly see on being mentioned.
No, liberty can the ad interim adjudication cannot wait for affidavit in opposition. That has to be taken up immediately.
That is the fixed on 6th April 2026. On this is the February, March and April. 6th.
What happens in the meantime? That order will remain.
My lord, I have served the copy of MA application long back.
We can do this. We can do this because the tribunal is also hard.
My lord, completely fraudulent documents. My lord,
we understand there is a.
They are playing fraud upon the court.
No, we'll direct the tribunal to take up for hearing and adjudicate on the identity prayer on the next date, on 6th of April.
My lord, I am suffering tremendously, my lord. Since
what sort of interim order has been passed in their favor?
The interim order is at page next page, my lord. Lordship, from the bottom third paragraph, the point of maintainability raised by the learned counsel appearing for the private respondent number 6 to 8 is kept open. The learned counsel for the applicant has prayed for interim order of stay against impugned order passed by the deputy controller, Kolkata, dated.
What was the order of the deputy controller?
Page 18. Declared Thika. Declared Thika. The petitioners has been declared Thika tenant. They are claiming as land.
How can we be so seriously prejudiced that we cannot wait for some time?
My lord, they are
declared.
The police is not. They are grabbing properties. They are very powerful people.
That is a different cause of action. Not that you can take appropriate action.
Cobblers. We are being.
We understand your predicament, but
police is not taking any action only on the basis of this act.
No, that's a subsequent cause of action. Police, if they do something illegal, even if they are ticketed, they cannot do anything illegal.
Well, if they do that, that order has been stayed. Your lordship kindly comes.
Order has been stayed. Order has been stayed.
Lordship kindly comes at page 88. Lordship.
No, who has been declared as a ticket tenant?
The petitioners. The petitioners.
So that has been stayed.
Yes.
So now at present, how can we be so prejudiced
without indicating anything?
You can be prejudiced, but how can you be so prejudiced that it is immediately that ad interim order should be vacated immediately?
My lord, the police is not taking any action.
Will not take unless the issue is decided by the tribunal as to whether the controller was justified in holding you to be a ticket tenant. If there is no stay, then nothing will remain in the challenge in the original application. What will remain in the original application if no stay is granted?
My lord, it is a government property. It is a
Let
Chika
the original
property.
application be
They
heard
are
on its
not in
merits.
possession even.
Have
They
you-
are grabbing property.
Have you filed any opposition to the
Yes, yes, I have also filed that.
original application?
Yes, yes, that I have filed.
We'll
there.
direct the tribunal to take up and decide your ad interim prayer made in this MA 3.
Your lordship kindly direct the matter to be disposed of on April.
That cannot be. Tribunal
Lordship,
can't do that.
there is nothing
On
in
a
this
single
matter.
day,
They
tribunal
are rank outsider, interloper, busy
Then
money,
we
subject to correction by your
we
lordship.
can do this. We can direct the tribunal to take up the MA along with the main OA
Lordship.
on the next date and to dispose of within say 2 months after that.
That is already fixed in May.
April.
No, the
Main matter is fixed in May.
No. MA 1451, that is vacating application
Yes,
by the petitioner before your lordship.
That is an
Is pending and liberty to file opposition thereto was given.
That is my client.
It is
You will file your opposition to MA within a week,
Within it.
within a fortnight. And you'll file your reply within a week after that, and we'll direct the MA along with in the main OA you have filed your opposition.
Yes.
You can also file your reply to that
Yes.
OA.
My learned friend filed an MA application to vacating interim order. And against that, my lord, I filed this affidavit of opposition in connection with the MA application.
We have covered that.
Yes, ma'am.
We have covered that in what we said in
In
the
a way, pleadings are complete. In a main way,
I have filed my
The
opposition.
grievance
They
of the
have-
writ petitioner is that despite the writ petitioner having made an application for vacating an ad interim order passed in OA 3331 of 2024, preferred by the private respondents against an order declaring the writ petitioners to be Thika tenants,
at page 92,
the said the ad interim prayer made in connection with the said vacating application has not been decided upon, but the matter has been relegated 3 months after the date when it was taken up, TO2, April 6, 2026. Fusap, it is submitted that in view of the stay order granted ex parte at the earlier stage by the tribunal in favor of the private respondents, the private respondents, who are powerful people in the locality, are harassing the writ petitioners. Full next para, such contentions are controverted by learned counsel for the private respondents. Full stop. Upon hearing learned counsel for the petitioner, for the parties, including the state, we find that the next date fixed for hearing of the vacating application bearing MA 1451 of 2025 within bracket LRTT is April 6, 2026.
Yes.
Full stop. Next para. Accordingly, this court is of the opinion that, for the ends of justice, on the said returnable date, the original application along with the vacating application ought to be taken up for hearing, and the main matter ought to be decided within a short period thereafter. Full stop. Accordingly, WP LRT 18 of 2026 is disposed of by directing the third bench of the West Bengal Land Reforms and Tenancy Tribunal to take up for hearing MA 1451 of 2025 along with OA 3331 of 2024 within bracket LRTT on the returnable date, that is on April 6, 2026, and upon giving adequate opportunity to the parties to address the issues involved, dispose of the original application bearing OA 3331 of 2024 along with MA 1451 of 2025 as expeditiously thereafter as possible, preferably by the end of June, the month of June 2026. Full stop. Next para. To facilitate the above timeline, the private respondents herein shall file their affidavit in opposition to MA 1451 of 2025, along with a reply to the affidavit in opposition filed by the writ petitioners in OA 3331 of 2024,
Reply and rejoinder.
second reply na kore rejoinder within a fortnight from date, full stop, Next para, rejoinder, comma, if any, comma, to the affidavit in opposition filed by the to the opposition filed by the uh, private respondents shall be filed by the writ petitioners within a week thereafter. Full stop. Next para. It is expected that the timelines stipulated above shall be strictly adhered to by the parties as well as by the learned tribunal.
Yes.
The parties and the tribunal shall act on the written communication of the learned advocates for the parties, comma, coupled with a server copy of this order without insisting on prior production of a certified copy. Full stop. No
May I beseech one line? The order of not giving effect will not hamper the interest of the residents
That will
of the.
be touching the merits. We'll leave it on the tribunal. That will be virtually allowing your ad interim play.
Lord, actually, I'm suffering. We are poor people, my lord.
You are poor people. That's why we have directed the poor tribunal to do it within 2 months. Otherwise, the tribunal is extremely poor now. Totally hard pressed. Lack of administrative members. In another matter, we have asked the state to inform us as to which department of the government makes this appointment, so that we can request the department to do something. Pass over. Thank you.
Pass over item number 13 and 14.
Yes.
I apologize for not being there.
No difficulty. Yes. Please carry on your arguments.
Yesterday,
Just remind us in a nutshell and then start.
Two issues were raised yesterday, Millets. First was non-joinder of the petitioners plaintiffs in the second matter.
এটা খুলে দিন না। আচ্ছা, অর্ডারের মাঝখানে ঢোকাবেন না কোনোদিন, বারবার বলছি আমি। এটা কোনোদিন অর্ডারের মাঝখানে ঢুকবে না। অর্ডার একসঙ্গে থাকবে, অন্য কাগজ আলাদাভাবে থাকবে। সবকটা অর্ডার একসঙ্গে করে দেবেন, হ্যাঁ? এই দেখুন, এখানে একটা অর্ডার রয়েছে, এখানে ওখানে একটা, ওটার মাঝখানে একটা। অর্ডারগুলো একটা বাঞ্চে থাকবে। কিলো আপনি
Firstly, the plaintiffs petitioners in the second matter who had filed the suits, they were not arraigned as parties before the tribunal. Hence, the order is bad for non-joinder of necessary parties. And along with that, suppression of the suit itself.
Yes, WPLT 5, they were the parties to the suit.
They were the plaintiffs in the suit, Millets.
You were impleaded. WPLT 3 petitioner was impleaded. Yes.
The second issue that I had raised is that the order of the tribunal nullifying the effect of the decree passed by the civil court, that cannot be done, Millard. The third issue, Millard, taking a cue from the bench yesterday, that I would submit today is that there is no enabling provisions in the either in the Act of 1955 or the rules framed thereunder, or even in the West Bengal Land Reforms Manual, to the effect that the adjudicating authority or any authority for that reason can pass an order for recovery of possession in favor of a patta holder. But the case of the patta holder as made out in her applications before the authorities is, I was a patta holder, I am a patta holder, I have been dispossessed by XYZ, and hence my possession should be restored. But the third leg of submission would be that the reliefs claimed by the patta holder is akin to that of Section 6 of the Specific Relief Act. So that exclusive jurisdiction lies with the civil court. There is no provision in the Act. If your lordships consider Section 49 also.
No, Section 49 is on different footing. They have been given the power.
But any other provision, there is no enabling provision, is my submission.
Apparently so, because if there is a revision or any correction, and then to implement that, probably certain orders can be
the patta is cancelled otherwise.
If the patta is cancelled, then
yes,
it can be
then
done.
It can be done.
That's a different footing.
Yes, but somebody given a patta, possession follows, thereafter dispossessed. Thereafter, recovery of provision, there is no enabling provision under the Act.
The tribunal is acting as a first authority to grant a decree of recovery of possession.
Yes. So that cannot be done. And Milord, so far as I had made extensive submissions, so far as the issue of non-joinder of parties, suppression of the civil suit, and the issue that the tribunal could not have nullified the order of the civil courts, Milord.
So we have recorded 4 things. all are sub points of the same points.
Yes, please.
One is civil court's decree has not yet been challenged before any forum. Secondly, that has been held by a nullity by the tribunal without jurisdiction. Thirdly, non-joinder of the rightful owners at any stage of the tribunal proceedings. Fourth, in the notice of possession, you have stated that names of petitioners are there.
Yes, in petitioners of the next item.
5, those are not there.
Not there in the impugned order also.
Oh, not there in the impugned order, but in notice of possession, they have been included.
Yes.
Right.
By the executing authority.
By the executing. And now you say that there is no provision also.
Yes, there is no enabling provision. Look, just I'll refer to just one judgment will be sufficient of a coordinate bench.
Yes.
But this is reported in 2004, volume 1, CHN 387. 2003 2003 Sir, copies. 2003 I'm so sorry. It also deals with the bar content under the act that civil court does not have jurisdiction on that aspect. It has also been covered. Para 8 would be relevant, the first paragraph. Coordinate bench judgment. We have been taken through the judgment and order passed by the tribunal. From the judgment of the tribunal, it appears that the tribunal has made an effort to pass an order bypassing the binding judgment and decrees and the orders of this court. In that matter, there were appeal and second appeals also that were filed. The tribunal has held that the decree will abate so far as it relates to matters specified in clauses such and such of that act, since the said suit was instituted with a prayer for declaration that the subject lands has not vested in the state and ended with a declaration that would lead to alteration of the entry of the record of rights and affected the vesting of the subject land, the decree will abate. Thereafter, the court is of the opinion that the aforesaid stand taken by the tribunal is not correct, either on fact or on law. Thereafter, kindly have para 10, where the earlier judgment 93 CWN has been discussed. I'm not reading out the entire thing. They have just quoted the judgment. And para 11, that is another earlier judgment of this honorable court. And para 12 is the conclusion. 2002. And Sudharani Maiti as referred in, I'm sorry. I have also taken out Sudharani Maiti as referred in para 11. This is Sudharani Maiti. This basically also holds that if the action of the revenue officer is affected by principle or not following principles of natural justice, then the civil court will have jurisdiction. And hence, if the decree of the civil court is passed, it is binding upon the...
Depends on the principal relief, actually.
Yes.
That's settled more.
Yes, para 3, the formulation of the issues are there. And thereafter, para 5 is relevant. Para 3 is where their lordships decide that if the issue of principles of natural justice is there, then also the suit is maintainable. One does not have to go before the authority.
Exactly, this is what we are saying. If the principal relief is for declaration
Yes.
of title,
Yes.
then the other reliefs are consequential, and tribunal doesn't have the power to declare title. Can we see your prayer, the prayer in your plaint?
Yes, minutes. Because
That is-
plaint starts at page 100 minute of the WPLR 3 minutes. That has all the documents.
Prayer is at page 106.
Yes, minutes.
Probably starts from the starts at 105.
At 10.
Yes, as we pointed out yesterday, number
Yes.
1 at para 10 is ইজমাল সত্য সাব্যস্ত ও দখল।
And also the decree also, it's a declaratory decree for right, title, possession, and also confirmation of possession. Decree of declaration of the right, title, and interest, as well as confirmation of possession of the Core 1 scheduled property. Core 1 is the disputed property.
Which page?
Minutes, 112 minutes. Certified copy of the decree.
Yes.
Because there is one other concept that I just want to highlight. Being a welfare state, my lord, the state could not have done anything which is contrary to a judicial decision. A judicial decision which has attained finality, where they were parties, have filed their written statements.
What does it have to do with a welfare state concept?
But because, my lords, they were duty bound to follow the judicial decision. And these reports that were given before the tribunal,
even if it was not a welfare state,
it is a welfare state.
Maybe it's no.
They were duty bound to.
Welfare state has nothing to do. It's a different concept.
Probably
you may say it's a the common law prevails here.
Yes.
That you may say.
They
It's a
could not
common
have.
law, we have a common law system also.
Probably I've used the wrong expression or the adjective, my lord, but they were duty bound to follow the dictum of the civil court, my lord. And the civil court has come to a decision after taking evidence. But they were parties, their written statements were on record. Those are my respectful submissions, my lord.
Just impugn order, let us just.
Yes, my lord. And I'll just, at the cost of repetition, my lords, the way in which the tribunal has dealt with the judgment of the civil court, my lords, they have purportedly found out a distinction between a decree and an execution thereof at internal page 3. The decree is not appreciated only when there is an order in execution under order 21, then only possession can be parted, etc., etc.
Let us see that.
The tribunal has considered at internal page 3 minutes. The tribunal has considered the submissions advanced on behalf of the private respondents. It is noted that while a civil decree has been passed in favor of certain Boshak family members, the said decree has not been executed by recourse to due process prescribed under the Code of Civil Procedure. There is no material to demonstrate that the decree was put into execution, nor is there any delivery of possessions recorded under Order 21. It is well settled that a decree of declaration of title does not ipso facto terminate possession recorded under a statutory regime unless followed by a lawful execution proceedings. I have failed to comprehend the meaning of this, but this is what has been held. Further mutation and patta entries are not annulled by implication and can only be cancelled by statutory process before the Land Reforms Authority. But the chain of the facts of my clients are they purchased in 1988. Their names were there in the records. They had paid taxes thereof. Suddenly it was removed. They were constrained to file a suit. Suit decreed. Thereafter, Section 50 application filed before the authorities for correction pursuant to the decree. That was not considered. OA filed by the petitioners in the second item. That OA stood allowed, basically an expeditious disposal prayer, directing the authorities to consider my prayer for correction with a limited period.
That was filed by the owners, the
petitioners in the second matter. If your lordship so wants, just have that order once, just for the record, because that has to be recorded, at page 92.
Of the first one.
Of the first one. First one has all the documents. 92 is the earlier OA filed, millets. And order is at page 135.
No, then what happened?
So not considered thereafter.
OA allowed, directing.
OA allowed, Thereafter also my section 50 not disposed of. In the meantime, this OA filed by the private respondent herein before the tribunal.
Asking for?
Asking for that I should be evicted and she should be, I as in only the petitioner in the first item, should be evicted and she should be put into possession.
What is the prayer of that OA?
Yes, Mills. The OA starts at page 26. The prayers are at page 36. Paragraph number 7, relief sought for.
Recovery change, recovery করেছেন ঠিক আছে।
I've checked up, subject to correction, Millets. I've checked up the rules, even the other rules. There is no provision under law.
What is 28(3)(b?
Let's 28(3)(b) is the rule as to how the patta is to be given.
West Bengal LR rules?
Yes, Millets.
Rules to the. ওই সাবেকটা দিতে হবে। No, 28(3)(b) says collector or district land DLLRO within whose jurisdiction land is situated shall deliver possession of the land
once
to the
first
person
time
with whom it has been settled.
Yes.
But that is a corollary of the previous provision.
Yes,
where the settlement is given for the first.
Yes. So the patta is followed by the possession. Till that there is jurisdiction. But I had specifically mentioned.
Obviously, patta, if the patta is given to somebody, but the patta, if patta is given to that person, has to be in possession also.
Suppose today the patta has been given for the first time, the rule says that that person has to be put into possession. But tomorrow, if that person is dispossessed, then there is no jurisdiction under law. Then common law, civil law applies. That is because their case is restoration of possession. That I was in possession, I was removed by the private respondent, restored my possession.
Manual to the let us see 295 once. Appendix 9 actually.
295 manual. Then becomes manual.
Appendix 9.
295 আছে না নেই?
Manual sir. Appendix 9.
Last page, man.
Yes.
295. Para 8, my lord. If you not, you will see. First Borgada, next part out.
You have these on your fingertips. Yes. Then you also know what is coming for you. It's privacy and non-eligible person. This is what. This does not probably come in. There is evidence that he is in actual. Anyway, we'll consider it. Yes. So let us hear the other side.
Yes, but I did not want to go into the patta. If required in reply, just indicate the problems with the patta.
Ultimately, eviction has been granted by this.
Yes.
Yes. Mr. They will hear you. Mr. Ghosh, yes, absolutely. Mr. Ghosh is for the private respondent.
Yes.
Because actually, it's the state who has to answer ultimately.
Yes.
But Mr. Ghosh, yes, we'll hear you definitely.
Lord, you kindly consider what is the nature of the suit.
He is relying upon the degree of the civil code. Nature of the suit, not the very beginning, I can say that the property was vested property. And Lord, kindly see their plaint. Your Lordship, kindly come to page 101. It starts. There was a big riot case and Gitarani Singh's property was vested. Thereafter, Gitarani, your Lordship, kindly come to page 102. I am reading from paragraph 1. গীতারিণী সিংহ স্বামী অজিত সিংহ রেকর্ডের যথারীতি বলবৎ উক্ত উল্লেখ থাকে যে তদ্রূপভাবে এলআর ম্যাপে অন্যান্য সম্পত্তি সহ আরজির ক তফসিল অন্তর্গত ক1 তফসিল সম্পত্তি উক্ত গীতারানী সিংহ রায়ের নামে 58 অংশে 12 শতক সিংড়াপুর মৌজা এত নম্বর কৃষি খতিয়ানে রেকর্ড হয় ও বলবৎ না। নেক্সট, আরজির ক1 সম্পত্তি উক্ত গীতারানী গত কাইন্ডলি নোট দি ডেটস 8/4/88 তারিখে গোঘাট সাব রেজিস্ট্রি অফিসের 1270 নম্বর দলিল মূলে গ্রহণে বিক্রয় করিয়া দিয়া কালীপদ বসাক মহাশয়কে দখল প্রদান করেন। কাইন্ডলি নোট দি ডেট 8/4/88। নেক্সট, দেন কালীপদ মন্ডল গীতারানী টু কালীপদ on 8/8/88। thereafter কালীপদ বসাক মহাশয় আর্থিক প্রয়োজনে তফসিলের সম্পত্তি নিমাইচন্দ্র দাস মহাশয়কে 9/4/88। নেক্সট ডেট, it was transferred on the next date, on the very next date. Then Lord, the third transfer Kalipad Bashak and the Ukto Nimai Das Kalipad Bashak ইংরেজি 9/4/88 তারিখে সম্পাদিত গোঘাট সাব রেজিস্ট্রি সাপওয়ালা দলিল বিক্রয় করিয়া দিয়া তফসিল সম্পত্তি তাহার দখলে দেন। উক্ত নিমাই দাস মহাশয়, নিমাই দাস from Kalipad and then Nimai Das, this is not kindly note the date, just after 3 days thereafter 11th April সম্পাদিত এবং গোঘাট সাব রেজিস্ট্রি অফিসের রেজিস্ট্রি দলিল মূল্যে 3000 টাকা মূল্যে কালীপদকে বিক্রয় করেন, এই বাদীগণকে বিক্রয় করেন। বাদীগণ শুনলে it appears that they are heirs of কালীপদ, দখলে দেন। উক্ত তফসিল মূলত দ্বাদশ বিংশ বছর ঊর্ধ্বকাল দখল দেন। তৎপর বাদীগণ কয়ের এক তফসিল সম্পত্তি দ্বাদশ বিংশতি বছরের ঊর্ধ্বকাল যাবৎ অর্থাৎ গত 11/4/88 তারিখ হইতে অদ্যাবধি ক তফসিলের 2 আনায় 25 শতক মধ্যে পূর্ব দিকে 12.5 শতক অর্থাৎ ক1 তফসিল খাস দখলিকার হয়েও আছেন। আরজির ক1 তফসিল সম্পত্তি কাগজ প্রার্থীদের প্রশ্নকালে কোনরূপ অংশ সত্য দখল অধিকার ছিল না বা আজও নাই। দ্যাট ইজ 1 to 3 আর পাট্টা হোল্ডার্স। ইংরেজি 11/4/88 তারিখ হইতে বাদীগণ তফসিল সম্পত্তিতে এজমালে নিজ নিজ সত্য অন্যের সত্য সম্ভব রহিতে নিরবিচ্ছিন্নভাবে। Now Lord, can you what the cause of action? 4 ও 5 নম্বর প্রতিবাদীগণ 1 নম্বর 3 নম্বর প্রতিবাদীগণের সহিত যোগে আছেন। নালিশি ক1 তফসিল বাদীগণ রায়তি সত্ত্ব পশ্চিমবঙ্গ সরকারের অধীনে প্রজাসত্ব রূপে রেকর্ডের নিমিত্ত they approached when they found that it has been recorded in the names of the patta holders. My learned friend was submitting that when for correction of record of right they did. That is not. After suit, after the degree, he said that on the basis of the degree they approached the revenue officer. That is not correct. Their cause of action is they found that the record of right is standing in the name of these patta holders. Then they filed the suit. Very initial stage it will appear that the property was vested to the state and vested lands are disputed to the patta holders. Government cannot distribute the land of a riot to patta holders. Distribute cannot do it unless it is vested. And from the report, an ultimate prayer is not kindly see if the entire prayer is read. Your Lordship kindly see these prayers. Your Lordship has pointed out it. আরজির অন্তর্গত ক1 তফসিল সম্পত্তিতে বাদীগণের তুল্য এজমাল সত্য সাব্যস্ত হয় ও দখল কায়েম ও বলবৎ থাকে। They were not in possession as it appears from the record of right, at least from the date of filing of on the date of filing of the suit, they are not in possession. It was recorded in the names of patta holders. Then that cannot be done, Lord, without praying for recovery of possession. Then Lord, kindly see paragraph প্রেয়ার টু আর্জির তদন্তর্গত ক1 তফসিল সম্পত্তিতে 1-3 নম্বর প্রতিবাদীর কোনো সত্য না থাকা সাব্যস্ত, that is negative declaration, and ও 1 নম্বর প্রতিবাদীর ক1 তফসিল সম্পত্তিতে বাদীগণের সত্য দখলে কোনরূপ বাধা সৃষ্টি করিতে না পারে তন্মর্মে মোকদ্দমা পেন্ডিং থাকা তক ও পরবর্তী সময়ের জন্য স্থায়ী ও অস্থায়ী নিষেধাজ্ঞা হয়। নেক্সট, আর্জির ক1 তফসিল বর্ণিত সম্পত্তি সম্বন্ধে হাল এলার পর্চায় 1-3 নম্বর প্রতিবাদীর নামে উল্লিখিত অংশে পাট্টামূলে দখল রেকর্ড ভয়েড ইন্টিগ্রাল। This declaration that is there already there when the suit is being filed, that is, my lord, our possession has been recorded as patta holders. They sought for declaration that this is void. And now, my lord, kindly see what is the judgment, the operative part of the judgment they have annexed, and degree is otherwise. Kindly come to me, page 109. Lord, at the bottom, the plaintiffs have challenged the vesting of schedule q1 property as well as question of patta with respect to the same in favor of the defendant number 1, 2, 3. Permanent injunction from disturbing the plaintiff's possession over the schedule q1 property. The plaintiff also get a degree for declaration that LRR in the names of defendant number 1 to 3 is erroneous and illegal and not binding upon them. Now kindly see that then degree is otherwise. This is the judgment. They declare that pattas are not binding upon them. LRR are recorded in the names of defendant number 1 to 3. Lord, the suit at first point, Lord, the civil court has no.
Why is the decree otherwise?
Lord, kindly see. Next.
Degree is the same.
No.
Without the other different.
Lord, kindly come to page 112. Here, I am reading the operative part of the judgment where this is not there. Then the suit be and the same is degree ex parte, but without any order also. Therefore, the plaintiffs get a degree of declaration of their right, title, and interest, as well as confirmation of possession over q1 scheduled property. Accordingly, defendant number 1 to 3 are hereby restrained by an order of permanent injunction from disturbing the plaintiff's peaceful possession over the scheduled q1 property. The plaintiff also get a degree of declaration that the LRR in the names of defendant number 1 to 3 is erroneous and illegal and not binding upon them. Not totally different. Only portions have been.
No, but at page 109,
yes,
the court records in a peculiar fashion, but that was the intention. The plaintiffs have claimed their right, title, and interest over the such and such property, by which has been marked. Fact remains no porcha. Plaintiffs have challenged the vesting of schedule q1 property in respect of such and such. And something appears to be missing here. And then because suddenly after footstep it starts from permanent injunction. Do you have the original of the judgment?
I will have to seek
There's something
instruction.
missing here.
Probably, my lord,
I
because
think
it then goes on to permanent injunction from disturbing the plaintiff's peaceful possession.
probably our entire page is missing, is what I understand.
Must be, but we have the decree with us, Mr. Ghosh. We are not sitting in appeal over this judgment. You have never preferred to challenge. So this decree is there.
Yes.
For all practical purposes. It has attained finality because none of you have challenged, neither the state nor you. So, Mr. Ghosh, you know the effect. Civil court's decree.
First point is.
Can the tribunal say even that it is a nullity? Because civil court did not have jurisdiction. You appeared, you did not contest, and can the tribunal say this?
Lord, that I have.
There'll be judicial anarchy,
Lord,
Mr. Ghosh.
that I have seen, Lord. But Lord, if it is void, the land is vested land. They acquired nothing by purchase. And Lord, these Lord successive
You could have argued these things in an appeal against the decree, but not before the tribunal in a proceeding for obtaining possession. Under which provision do you get possession?
Lord, I have got possession on the basis of the patta.
That was the first stage.
Yes.
That could have been done under the rules and whatever.
That could be annulled under the provision of the West Bengal Land Reforms Act. That has not been annulled.
Take this point in an appeal against the decree. You have never preferred any challenge. The civil court's decree is binding on you and the state. Civil court's decree, Mr. Ghosh, says that they have got title and that patta is bad. Maybe a bad decree, maybe a decree without jurisdiction, but these points have to be taken up in appeal.
Lord, my case is that Mondal,
not by the tribunal.
Lord, Durga Mondal has dispossessed me.
Then, Mr. Ghosh, just imagine the scenario: a civil court will pass a decree, and the tribunal tomorrow will say that's a nullity. I am nullifying that. and granting possession.
But it is.
Both the reliefs granted by the tribunal are bad. One is holding the decree to be a nullity. Secondly, granting recovery of possession on an independent footing. Because this is not, if the patta was granted to you and you are put in possession, then it would come under the rules, which have been quoted by you, rightly. But here, your case is also that you are in possession, but you have been dispossessed.
Yes.
Now, because obviously you have been dispossessed, otherwise you could not have sought for possession. You say you have been dispossessed illegally. So now, once you are given possession on the strength of the patta and then dispossessed, it's a subsequent cause of action. You go and file a civil suit, section 6 or whatever. I mean, you can file a regular suit also.
And well, that apart, your lordship can see, your lordship knows that this matter, whether the civil court's order, whether it is a nullity or not, is binding upon the forum or the BLRO and these officers. Well, there is a conflict of decision, and well, the matter is referred to the larger bench for decision. Well,
Till date, we have to follow a particular view.
Lord, so far, yes, Lord, so far, Lord, one case is concerned, but same order was passed. Honorable Justice Subramanian Mukherjee division bench not allowed. They preferred an appeal before the Honorable SLP, before the Honorable Appeals Court, that has been stayed. Similar question, the degree of the civil court.
Justice Mukherjee held what?
Lord, held Lord allowed us our petition.
That civil court degree
court
can
degree
be.
is valid, and that is challenged and stay order has been granted.
No, Justice Mukherjee held that tribunal can say that.
No.
The otherwise.
Yes, otherwise. Lord,
which is the traditional view.
That is natural view.
Your view would also be that if you sat here.
Lord, I know.
And Mr. De's view would be similar.
But what happens, Lord, that when the matter is before the larger bench, this issue should be, Lord, settled first.
Let it be settled. Till then, let this be set aside.
Then, Lord, our patta holder, I am landless person. Lord, my case is that I am still.
Know your remedy. Why didn't you prefer a challenge against this decree when it was disclosed to you?
Lord, that state was also didn't challenge.
Catch the state. Catch hold of Mr. De. Let him give you a treat.
And
but you cannot catch them.
State was also a party there. They didn't
you are affected. Why should the state go? State will not be advised. State is a bystander here.
And Lord,
you are the affected party. Your patta, your possession. What will the state? State has given you patta. State has washed its hands.
Lord, two other patta holders are still there.
We cannot go into this question. Neither could the tribunal.
The tribunal has made a mistake that set aside the degree of the test.
That is the difficulty.
But Lord, your lordship, if it is void initially, there is vested land. They can it be declared that is.
If the tribunal could not say that, we cannot say that because we are sitting in challenge over the tribunal's order.
Yes.
And our jurisdiction is more restricted into 26 because we are a cylinder, like a cylinder. Even like not a cylinder, pyramid. Becomes stricter as you go up. So what the tribunal could not do, Mr. Ghosh, we cannot do. We are not sitting in appeal over this judgment. Maybe if you sat in appeal over this judgment, the first argument you would make is what you are making now. But then also there is some doubt, Mr. Ghosh. You know there are several lines of judgments. You also cite in so many cases that if the primary relief is for declaration of title, you may argue that we won't tell your arguments to you. You make your arguments in the appeal. There are alternative arguments also. That this was a sham. I mean, this.
Yes, that
relief.
That I what I
primary,
point out that.
But we cannot go into that. If this was an appeal, we could go into that.
Lord, I want to point out that by pointing out that the nature of transaction and other things. But possession was never there with them. Because Lord, 3 successive transfer.
After the civil court declared possession
within 5 days.
Granted injunction, we cannot do that. And now you are admitting that they're in possession.
No.
Yes, you have asked for recovery of possession before the tribunal.
I have been dispossessed and thereafter I have been put in possession.
Illegally, you say. But you admit that you are not in possession.
I have been put in possession.
We'll have to set aside that. That possession was illegal. By virtue of the order of the tribunal.
In their presence, I have been put in possession.
We'll negate whatever has been done by the tribunal. You go up in appeal and do whatever.
But
set aside, get this degree set aside.
Question of limitation would.
Precisely. Should have been properly. When they came to you, Mr. Ghosh, why didn't you advise them?
I have been given here.
Anyway, that's personal view.
Yes.
Whatever. We'll hear Mr. De because he's there. You can add something to it. Problem with people like you, Mr. De, senior people, is that you, after a limit, you cannot argue.
Well, that, no.
We always take advantage of that. We know that after this, you won't go. But we'll record your submission. First of all, that your submission that this is a nullity. Decree is a nullity. And what else? That
And Lord,
you are disposed illegally
Lord,
also.
I have some judgment, apex court judgment, Lord, when this is patta, if it is transferred to another person, that is not valid.
Patta transferred to another person. The transfer is bad.
Yes.
The patta was subsequent.
Subsequent, but it is not vested land. Vest is
That is their plaint case, Mr. Ghosh. You have seen the next paragraphs that they were never given any notice. They were the position was never taken from them, and therefore they challenge the basis of the patta also. But whether they can challenge that in a civil suit, we have our doubt.
But the relevant date is not when the nobody has disclosed when the property was vested. Property was vested much earlier. At the time of Gitarani Singhara, he was a big riot.
These
If that be
questions
so, here they have
entirely
purchased
beyond
nothing.
the domain of the.
Lord, they have not purchased anything. It is vested land. How the Gitarani Singh transfer? That is the basic thing.
You know what you should have done after appearing in the suit, Mr. Ghosh? You should have filed a counterclaim. We won't say go beyond. Yes, let us hear Mr. De. Yes, Mr. De. Wanted to add something.
My lord, your lordship will 49 is the, my lord, I am starting from.
Obviously, because you are the state, you'll have
Yes,
to argue,
madam.
focus on these. Yes, Mr. De. 49.
49, my lord, 49, 3 and 3A, my lord, after that. When a revenue makes an order under subsection 2, annulling settlement or both the settlement and the transfer of any as the case may be, the revenue officer shall enforce delivery of possession of such land to the collector by using such force as may be required after evicting the person in actual occupation of such land. My lord, 3A, for the purpose of enforcing delivery of possession of any land and evicting any person in actual occupation of such land.
That is for annulment of a patta.
After
Annulment of a.
That is for the purpose of enforcing delivery of possession of any land.
But Mr. De, that is for the purpose of implementing 3, which is connected to 2, which is
Yes.
annulling a settlement.
Yes, my lord.
When a settlement or transfer of land is annulled, then in consequence of that, the revenue officer can do this.
And evicting any person in
They
actual
approach the
occupation of-
tribunal which did this. They approach the
Yes, my
tribunal.
lord.
Tribunal in any event does not have this power first.
No, my lord. Tribunal has not any power, my
And
lord.
secondly, Mr.
Enforcing.
De, it's consequential to annulling a settlement. If the settlement was annulled or transfer of any land was annulled, consequential to that, revenue officer could do this.
Yes,
we
ma'am.
agree with that. But first of all, tribunal could not do it at the first instance. Secondly, this is not a case where a settlement or transfer has been annulled. Here a patta was given to them. They allege that they have been illegally dispossessed.
Dispossessed. Whether that
Comes within this.
Within that provision, my lord.
But these are the only provisions. You are right. Absolutely. 3A. And
Yes,
you are
ma'am.
relying on 4 also.
Yes, my 4 is my lord, any person aggrieved
Oh,
by
that is
from
3 and
that
3.
provision.
3 and 3.
And my lord, in case of my lord, the bona fideness to file a suit, that is a mala fide suit. If your lordship will see
Yes.
page 191. I am not coming into the what is there. Page 191.
191.
Already filed an application before us.
191?
91.
No. Must be wrong number.
Para 8. No. Para 191. Para 8. Dara.
124 is the application under section 50. If my
So you are relying on their plaint.
No, my lord. I am coming, my lord. 120.
Now, what is the document you are relying on? Say we'll find it out for you. What is that document?
Page 191.
No, 191 nahi, sir.
No, 192 obviously. But what is the document you are relying on?
I relying, my lord,
on their
that
plaint.
It is their knowledge that
No, from their plaint you are trying to show
my
us.
lord, yes. Plaint, my lord, why file this cause of action of this plaint?
Plaint is at page 100. It starts from page 100.
The cause of action, my lord.
Cause of action paragraph. Very well. Let us come to that.
Cause of action paragraph.
Which paragraph? Internal page of the plaint you can refer to. Internal page or paragraph. Para 4 or 5 of the plaint. Must be 4.
বাদীগণ তৎপর তারিখ প্রতিবাদ অফিস হইতে দাগের তথ্য
Yes, para 5. Page 104, that is what paper. That is para 5, Mr. Ray is reading para 5. তৎপরে 5-10-12 তারিখে
আগে তথ্য বাহির করে জানিতে পারছে বাদীগণের তফসিল সম্পত্তি প্রতিবাদীগণের নামে জমির পরিমাণ উল্লেখ রায়তের নিরঙ্কলমে পাট্টামূলে একনব প্রতিবাদীর নামে পাছার প্রতিবাদীর নামে এত প্রয়োজনীয় এত রেকর্ড হয়ে আছে উক্ত হাল এবং ইন্টারনেটের ভয়েস এন্ড কাউন্সিলিং হইতেছে my lord their knowledge that the patta was there and land was vested
they
land.
say this was without any foundation. The recording was without any foundation because in the previous paragraph, Mr. Dey, if you come back to the previous page,
Yes,
the last paragraph,
yes,
they starts with উল্লেখ করা যায় যে original owner গীতারানী সিংহ such and such return file করিয়াছিলেন, and last 3 sentences lines আরো উল্লেখ করা যায় যে ইতিপূর্বে গীতারানী সিংহ রায় বা তাহার লোকান্তে তাহার ওয়ারিশ হন বা তৎপরে বর্তমান বাদীগণের উপর 5 নম্বর প্রতিবাদী কর্তৃক দখল লইবার কোনো নোটিশ প্রদান হয় নাই এবং বাদীগণ বিএলএল অফিসে কর্তৃক দখল লওয়া হয় নাই তদ্রূপ কোনো নোটিশ, so they deny the entire process of grant of patta, notice, the disposition, everything.
Vesting order he denied. It is his knowledge that there is a vesting order.
Patta is there, he says. Patta was granted, he says.
Without giving any notice or anything else, he filed.
He says that patta was that recording.
My lord থাকায় উক্ত উত্তরাধিকার বিগত তার মৃত্যুর পর রিটার্ন দাখিল করিয়াছিলেন 1 to 3.
Yes, Mr. There is a very important statement made in paragraph without any foundation, and that is the window through which the civil court.
My lord, I am not on that point. That is, I am only. It is
his knowledge about the patta.
It is his knowledge that there is this is a vested land. This is a vested land, my lord. After that, my lord, I am emphasizing that vested land, and it is his knowledge. And it is also his knowledge that it, according to the provision, my lord, that is at that the vesting order in 57B of the Estate Acquisition Act, my lord, that is the vested will be there is a provision bar of jurisdiction, and Land Reforms Act, my lord, in 14X, my lord, if your lordship.
This was vested under the 53 Act. Estate Acquisition Act.
Estate Acquisition Act, my lord, 57B. If your lordship.
No, what is the vesting under? You have not. What is your written statement stand?
61, my lord. That is if your lordship will come according to Land Reforms Act.
So it was a vesting under the Land Reforms Act,
yes,
according to you.
According to.
Because you have filed a written statement there.
No, it's subject to correction. It is not on record that whether the vesting was under the old act or the new act. It's not on record.
No, they have filed a written statement in the suit. No. State has not.
No, state has filed a written statement.
Order was there. That
no, you filed a written statement. Expertly because you did not appear.
But that written statement is not, my lord, in this.
You must have it. You must have it.
We have not in my lord.
It's good that you have a copy of the writ petition.
Yes, my lord.
That has reached up to you. Mr. Bandyopadhyay is trying to use his height for.
No, my lord. Next matter.
Undue advantage of his long hand of the law. He will suffer if he loses.
They have stated in their manner, this is a government land, this is a vested land. The private.
My lord, if you are 15, my lord, if your lordship will see in item number 14.
14.
There is a, my lord, clear.
Which page?
Page, my lord, 11. 11 to.
It's the same plane.
Rented 4. Inner page.
Inner page of what?
24 page.
This WPLAT 5.
5, my lord.
WPLAT 5.
5, yes, my lord.
Which page?
Page 24.
24.
Yes, 24.
Last paragraph 4, my lord, last 5 lines.
Yes.
এবং নালিশি এক সম্পত্তি শীঘ্র মধ্যে দম্পতি প্রতিবাদীকে পাট্টা প্রদান করা হইবে এক ওমান অফিস হইতে শীঘ্র মধ্যেই দখল লওয়া হইবে তফসিলের সম্পত্তি সরকারের খাস সম্পত্তি হইতেছে জানিয়া 1 নম্বর নাগাদ ও 3 প্রতিবাদীগণ প্রতিবাদী অফিস হইতে সর্বদা ঘোরাঘুরি করতেছে। দ্যাট ইজ এ নলেজ, মাই লর্ড।
শীঘ্র মধ্যে প্রতিবাদীকে পাট্টা প্রদান করা হইবে।
হ্যাঁ, তফসিলের সম্পত্তি সরকারি খাস। This is admission, my lord, সরকারি খাস।
They are not admitting anything. They are saying এবং they came to know from you that it was given out by you that নালিশি কয়েক সম্পত্তি শীঘ্র such and such নাগাদ 3 নম্বর প্রতিবাদীকে পাট্টা প্রদান করা হইবে এবং আমার অফিস হইতে শীঘ্র মধ্যেই দখল লওয়া হইবে। তপল সম্পত্তি সরকারের খাস সম্পত্তি হইছে জানিয়া 1 নাগাদ 3 নম্বর প্রতিবাদী অফিসের নিকট ঘোরাঘুরি করিতেছেন। So this was, they say that when they approached the defendant numbers 1 to 3, they came to know about these things. This was
that is the knowledge, my lord.
That was the knowledge. That was their not knowledge. That was, yes, the defendants told them this, that this is the fact.
Yes, my
So that's why they filed the suit. They say that it has been declared, we have a title deed. There was no vesting at any point of time. We were not given any notice of vesting, nor was possession taken from us. Therefore, declared that the suit is that property is ours. That was their suit.
That is
They
what
deny the foundational fact of vesting.
I want to submit before your lordship. That is the knowledge was there. That is a vesting order.
Very.
There is a vesting.
That vesting.
That
yes.
that is knowledge, and for the vesting, and my lord, according to the provision
If there
of
is
the,
knowledge, 61 applies.
yes, my lord. They knows. They can't say that I am a illiterate man. I am village people. I can't say so. For that reason, my lord, I.
You are sure they can't say that? Are you sure they can't say that? We don't know their profession.
My lord,
They are village people. Okay.
otherwise, my lord, how he filed the suit?
So this is the village area. So they are village people definitely.
Yes, my lord.
But village people are much more intelligent often than the
Yes, in land matter. In land matter.
In land matter definitely. In other matters sometimes.
Only
so
for the
village people, the urban people, that has gone.
And my lord, according to the provision, that they have not any right to.
By occupation cultivator. So
I
they
know,
can
my
take
lord.
advantage.
I am also a cultivator. When I
Yes,
balance
many
village
other people are
yes,
cultivators.
everybody is a cultivator in
The,
village, my
the
lord.
who's who of India, we are telling you, the who's who of India, their profession, declared profession is cultivation,
Yes.
agriculturist,
Yes, my lord.
to get certain benefits. The who's who of India, some magnates.
Only, my lord, so
you don't come in that category even,
La-
Mr. Forget about us. You don't come in that.
my
Even
lord,
you
only
don't
for
come
that
in that.
it is knowledge. Taking knowledge of that is a vested land, and he must go to the file a certified copy and file an appeal before the appropriate authority. That was not done. But
Mr. Dev, who prevented you from preferring an appeal against this judgment and decree?
But-
Just take out a challenge and do this. Now there is a decree
now,
of
my
civil
lord,
court.
if
Good,
my
bad,
lord,
indifferent.
now, my lord, that point was in a larger bench, my lord. That is pending before the larger bench. So I may not want to. Your lordship
What
also.
point is before
in
the larger bench? That
larger
as Mr.
bench, my lord. My learned friend said a larger bench is solely depend whether they can file
Tribunal can ignore. Hold a nullity.
Yes, my lord. That is nullity.
Larger bench of our court.
Yes, my lord. Our larger bench of our court, my lord. Previously, Honorable Justice. My lord, আছে তো এখন।
I am also in the larger bench.
Yes, my
Start
lord.
deciding the point here.
My lord, so my lord, I
Comprise of larger bench comprises Justice Somen Sen,
yes, my lord. Previously,
Justice Kapoor and me.
yes, my lord. Previously,
Justice Tandon's bench.
Yes, my lord.
Tandon was there, your lordship was there.
That larger bench will never take place before all of us retire or go elsewhere. Justice Tandon has gone. Subsequently, who are the others?
There are so many cases, my lord, when
Justice Abhijit Gangopadhyay was also there. That
Yes.
larger bench.
Yes.
Justice Hiranmoy Bhattacharya.
And who is the third?
Ah,
Third judge now.
Now it has become
Difficult to get a third judge.
elevation of my lord Justice Tandon.
so my lord, I may not want to. There are so many cases, my lord, pending. So I may not want
We will
to.
record your and Mr. Ghosh's submission that larger bench reference is pending. We have to record that. And therefore, but therefore, what should the court do? Sit tight, not decide. That is the difficulty, Mr. Dev. Maybe there is a reference of larger bench. In other judgments, it has been held that
My lord, it is
just
up to
because the
your
reference.
lordship, my lord. I may not want to.
No, let us hold here something and maybe
Yes,
we
my
may
lord.
defer there in that larger bench.
It is your lordships. I may not.
Oh, we can do that only after recess.
Yes,
We'll continue after recess. We'll give you a short reply and very.
My lord, right, I pay one balance, my lord, I can 26.
Yeah.
But I am not the appellant because my throat infection, my lord, can you again?
We'll dismiss it. We are waiting for that being called. We'll not grant anything now. You are not there after in the second half.
No, because of throat
No, no.
infection, my lord, I was.
What throat? No, no. Your throat is very fit. When the matter is called on.
Man,
Good.
Plus just 2 minutes, because there was a surgical dissection. Sorry.
Lord, one judgment your lordship may look into. Defend the Supreme Court judgment regarding Lord Civil Court's jurisdiction and fate. Ultimately, my Lord held that leave was granted to prepare an appeal, regular appeal.
1 second. You give the citation to him also.
Yes, yes.
Yes. Occupation. Definitely. Yes, which paragraph is it?
Your lordship, the paragraph 8 and 9. The civil suit was.
There's no 8 and 9 here.
Nahi?
It ends at 7.
But it is SCC.
We will check.
Paragraph 6.
We'll just check up what is the
revenue officer who had earlier been restrained by an interim order. Once again started with the proceeding under subsection such and such, and had order dated 8/2/85 held that out of the total area belonging to the family, land measuring 14.29 acres was excess. The area was declared as hasty in the state, and possession thereof was accordingly taken. The respondent landowners being agreed by the judgment and aforesaid second appeal, accordingly, the respondent landowners being agreed by the judgment aforesaid filed second appeal, the Honorable Court, High Court at Calcutta, and by its judgment dated 24th July 2002, the High Court set aside the order of the district judge dated 12/12/24 and restored the judgment and decree dated such and such for the municipal, and held that there was no surplus area in the hands of the family. At the very outset, Mr. Bhaskar Prasad Gupta, the learned senior counsel for the appellant state, that the state has pointed out that by virtue of section 61 of the Act, the jurisdiction of the civil court was barred in such matters, though admittedly this objection had not been taken at any stage of the civil proceeding, or even in special leave petition filed in this court. He has pointed out that this was a matter relating to the jurisdiction. The appellant state had filed IA number 7 in the present appeal to urge this additional ground, and if this objection was to be taken into account, the very initiation of the civil proceeding by title suit number such and such was honest and outside the purview of the civil court. He has pointed out that, assuming for a moment that this court was not inclined to take cognizance of the question, he was willing to argue the case on merit as to show that the order of the High Court was wrong. But thereafter ultimately held that civil court has no jurisdiction, set aside the order of the High Court, and granted leave to the party to prefer appeal before the authority regarding challenging the vesting. Civil court had no jurisdiction. Volume 17, SCC, page 66. Volume 17, page 66.
So far as this start from this minutes, but firstly, the Honorable Supreme Court was approached from a judgment passed in a second appeal, firstly. And secondly, no declaration of law passed on a concession given by the other side, that let them be given liberty to approach.
In that also.
Yes, my lord. These are the two grounds why there is no declaration of law. So far as, because there has been a surgical dissection of the plaint and the decree and the judgment passed by the civil court, the lordship will very briefly have page 40 of the application once. This is purportedly the patta which has been issued in favor of the private respondent, and I'm only indicating this because this should also be reflected in the order. At least the civil court's decree has a date on which it has been passed. The plaint has a date. Patta does not have any date at page 40 and 41. Firstly. Secondly, village rule 20A of the West Bengal Land Reforms rules postulates that a patta under section 49 can be granted either by the DM or the ADM or by the SDO. kindly have page 41 as to who is granting it. The signature and the stamp on the left hand side is illegible. That is the copy that we have received from the tribunal, also served by Mr. Ghosh's client. But the seal appears to be in Bengali. Normally, DMs, ADMs, and SDO have their seals in English. And on the right hand side, countersigned by the Pradhan. As a witness.
SDO's report is at page 146 of the petition. SDO has given that it is vested land. Page 146 of the writ petition.
Yes. Kindly comes to page 146 minute. That is the next submission that I was going to make.
That is immaterial. Whether civil court has jurisdiction or not.
Yes. As per computerized land record, it is found. That is the source of information. No independent inquiry.
We are not going into those.
So far as, because equivalent, my clients will also have a right to challenge in the event. And the residual consequential prayer would be correction of the record of rights per se the decree of the civil court. Because that issue otherwise will never be addressed, even after the judgment by your lordships.
The decision Supreme Court has said that civil court has no jurisdiction, accordingly set aside. The judge. And directed the party to resort to the provision of the land reform side, appeal or otherwise, and delay has been suggested to be condoned. For taking steps.
Yes. The present challenge has been preferred against a judgment of the West Bengal Land Reforms and Tenancy Tribunal, whereby the learned tribunal directed physical possession of the subject land to be restored to the private respondent after eviction of the present petitioners, who are held to be illegal occupants in accordance in respect of the said land. While doing so, the learned tribunal observed inter alia that while a civil decree had been passed in favor of a certain Bosak family members, the said decree had not been executed by recourse to due process prescribed under the Code of Civil Procedure, and that there was no material to demonstrate that the decree was put into execution, nor was there any delivery of possession recorded under Order 21 of the Code of Civil Procedure. The learned tribunal further observed that it is well settled that the decree of declaration of title does not ipso facto terminate possession recorded under a statutory regime unless followed by lawful execution proceedings. Next para. Being aggrieved by the said judgment, the present two writ petitions have been filed. The petitioners in WPLRT 5 of 2026 were not parties to the original application filed by the private respondent before the tribunal, in respect of which the impugned order has been passed, whereas the petitioners in WPLRT 3 of 2026 were impleaded as parties to the said proceeding. Next para, learned counsel appearing for the petitioners in both the proceedings submits that the petitioners in WPLRT 5 of 2026 had previously filed a suit, inter alia, for declaration of title and confirmation of possession, consequentially seeking a relief that the purported patta granted in favor of the private respondent be recorded to be void, being without any foundation. Next para. Other consequential reliefs such as injunction were also prayed in the suit. It is submitted that although initially the defendant state as well as the private respondent, who was also a defendant in the suit, contested the same by filing written statement. Did both of them file written statements?
So that is what the judgment records. The defendants have filed written statements.
Written statement, comma, because we will record that as your submission. But Mr. They, you say that you had not filed any written statement.
My lord, yes, my lord, I have no any instruction for that reason.
Oh, then we'll.
So, my lord, I may not
Well,
want to.
well. Written statements, comma, subsequently the defendants did not contest the suit. Full stop. Accordingly, an ex parte decree was passed, comma, declaring the title and possession of the present writ petitioners. Declaring the title and possession of the writ petitioners in WPLRT 5 of 2026, comma, who were plaintiffs in the said suit, comma, bearing title suit number 177 of 2012, as well as the consequential reliefs, comma, including that the grant of patta, the purported grant of patta in favor of the defendant stroke private respondent was void, comma, being without any basis or foundation. Full stop. Next para. Next para. However, comma, in the absence of any challenge to the same by any of the defendants therein, comma, the said decree attained finality. Full stop. Despite such state of affairs, comma, it is argued that the learned tribunal, comma, unlawfully, comma, ignored the said decree merely on the ground that the civil court did not have jurisdiction. Full stop. Moreover, comma, the learned tribunal recorded that the said decree was not put into execution, comma, which according to the petitioner, comma, is not germane for the decree to have a binding effect on the parties. Full stop. Next para. Accordingly, comma, learned counsel for the petitioner argues that the learned tribunal acted without jurisdiction in ignoring the civil court's decree and passing an order of eviction. Full stop. Next para. Learned counsel next argues that no provision either under the West Bengal Land Reforms Act 1955, comma, the West Bengal Land Reforms Rules, comma, 1965, or the West Bengal Land and Land Reforms Manual 1991 permit the tribunal, comma, as the first forum, comma, to to pass an order of eviction in favor of any person at the first instance. Full stop. Next para. It is contended that although Section 49 of the 1955 Act envisages eviction, envisages possession to be given to the patta holder at the first instance, comma, after the grant of such patta, comma, in the present case, comma, the private respondent has alleged that although the private respondent was in possession by dint of a patta, comma, subsequently the private respondent was dispossessed unlawfully by the petitioners in WPLRT 5 of 2026. Thus, comma, the authorities as envisaged under the 1955 Act did not have any further power to grant an order of eviction or to put the private respondent into possession, comma, particularly in the teeth of the order of the valid decree of the civil court. So next para, learned counsel for the petitioner cites a coordinate bench judgment of this court in Omuk reported at 2004 bracketer মধ্যে 1 CHN 387, comma, for the proposition that the tribunal had no power to nullify the decree of a civil court. Full stop. Next para. In the said case, comma, the division bench was considering a situation where the tribunal had made an effort to pass an order bypassing the binding judgment and decree of the order of this court on the strength of Section 57 capital B within bracket 2 within bracket capital C of the West Bengal Estates Acquisition within bracket second amendment bracket closed Act, comma, 1973, comma, which contemplates a bar to the jurisdiction of the civil court. Full stop. The learned tribunal, comma, upon consideration of the same, had held in the said case that the decree will abate so far as it relates to matters specified in clauses small a, small b, and small c. Full stop. Next para. However, the division bench went on to observe that the aforesaid stand taken by the tribunal is not correct in law, either on fact or in law. Push up next para. It was further observed, by relying on a judgment of the Honorable Supreme Court in the matter of Union of India versus K.N. Sankarappa, reported at 2001 1 SCC 582, that the Supreme Court, in a slightly different situation, had held that an executive or legislature, without enacting appropriate legislation, cannot set at naught any UGHT. A judicial decree in which the state authorities had taken a plea of maintainability or abatement of the suit in view of the bar under section 57 capital B within bracket 2 of the 1953 Act. Full stop. Next para. Learned counsel appearing for the writ petitioners in both the matters next cites Omuk reported at within bracket 2003 bracket closed 1 CHN 1, in support of the self-same proposition. Push up next para. Learned senior counsel appearing for the private respondent argues that the suit filed by the petitioners in WPLRT 5 of 2026 was not maintainable ex facie in view of the bar contemplated in section 61 of the 1955 Act. Full up, it is submitted that, as such, the same was rightly held by the learned tribunal to be a nullity, irrespective of whether any challenge was preferred to the decree of the civil court. Full up, next para, learned senior counsel takes this court through the pleadings of the plaintiff in the suit filed by the writ petitioners in WPLRT 5 of 2026, and therefrom seeks to impress upon us that the plaintiffs were fully aware of the patta having been granted in favor of the present private respondent. Thus, the suit was not maintainable in law from the inception. Next para, it is further argued that since a valid patta had been granted in favor of the private respondent, the civil court's decree could not nullify the same. Furthermore, the private respondent contends that in aid of the said patta, the tribunal was well within its jurisdiction to direct possession of the property to be handed over to the private respondent, since the writ petitioners had dispossessed the private respondents in the first place. Next para, sorry. Learned senior counsel next cites a judgment reported at such as AIR 2000, 2008 17 SCC 66, State of West Bengal versus Harimohan Dana. In the said judgment, the Honorable Supreme Court was considering a case where, despite a proceeding being initiated by the revenue officer under section 14 capital T within bracket 3 of the 1955 Act, a civil suit was filed in the court of a munsif for a declaration of title and permanent injunction. Next para, the Honorable Supreme Court, in the ultimate analysis, held that the very initiation of the civil proceedings by the title suit were non-est and outside the purview of the civil court, and as such, allowed the challenge against the judgment passed in the second appeal, granting liberty to the appellant therein to prefer a challenge against the order of the revenue officer. Next para, relying on the said judgment, learned senior counsel submits that in similar circumstances, since the Honorable Supreme Court had observed that the civil court does not have jurisdiction to adjudicate on a suit for declaration of title and consequential reliefs where there is a specific bar under the appropriate provisions of the governing land statute, comma, the same proposition ought to be applied in the present case as well. Full stop. Next para, learned additional government pleader, comma, appearing on behalf of the state, comma, argues that under section 49 within comma subsections 3 and theta bracket and upper bracket 3 capital A bracket close of the 1955 Act, comma, ample authority has been given to the revenue officer to enforce delivery of possession. Full stop. Next para, thus, comma, it is argued that the tribunal did not travel beyond jurisdiction in directing such possession to be granted. Full stop. Next para, learned additional government pleader next argues that the suit filed by the writ petitioners in WPLT 5 of 2026 was a patently malafide one, comma, since the plaintiffs therein had admitted in the plaint regarding their knowledge that the subject plots are comprised of land vested in the state government. Full stop. Next para, as such, comma, it is argued that that there was no error on the part of the learned tribunal in holding that the suit was not maintainable and the decree did not operate as a bar to the tribunal passing the impugned order. Full stop. Next para, learned additional government pleader reiterates that under section 61 of the 1955 Act, comma, there is a specific bar of the civil court assuming jurisdiction in matters which fall within the domain of the authorities under the 1955 Act. Full stop. Next para, a valid patta having been granted in favor of the private respondent, comma, it is submitted that the civil court's decree was a nullity. Full stop. Next para, upon a careful consideration of the arguments of the parties, comma, we find that there are two major issues which are required to be adjudicated for a complete adjudication of the present LIS. Full stop. The first of the said questions is whether the learned tribunal was justified in ignoring the civil court's decree on the grounds as recorded in the impugned judgment of the tribunal. Full stop. Secondly, comma, whether the tribunal had the authority in law to pass a decree, pass a direction regarding reinstatement of the private respondent in khas possession, in physical possession of the subject properties. For the next para, taking first things first, comma, it is well settled that a decree passed by a civil court is binding between the parties and conclusive. Full stop. Even going by the definition of a decree in section 2 of the Code of Civil Procedure 1908, comma, it is amply clear that the decree depicts a conclusive determination of the right, title, and interest between the parties to the suit in which the same is passed. Full stop. We cannot lose sight of the fact that in the suit filed by the writ petitioners in WPLT 5 of 2026, comma, not only the private respondent but also the state was a party. Full stop. The defendant stroke respondents, comma, although initially having entered appearance in the suit, comma, failed subsequently to contest the same, comma, due to which an ex parte decree was passed in the same, comma, which has not yet been challenged by any of the defendants, comma, either the private respondent or the state authorities. Full stop. Thus, comma, as of today, comma, the said decree has attained finality. Full stop. Next para. In our view, comma, which is strengthened by the ratio laid down in Sudharani Maiti Supra and Kshitish Chandra Kamila Supra, comma, the learned tribunal acted without jurisdiction in defying the civil court's decree, comma, which conclusively determined the rights title and interest between the parties and proceeding to pass directions for eviction of the writ petitioners. Full stop. Next para, the learned tribunal, while doing so, observed in the impugned judgment that while a civil decree has been passed in favor of double inverted certain Boshak family members, double inverted close, the said decree had not been executed by recourse to due process prescribed under the Code of Civil Procedure, thereby ignoring the fact that the final and binding nature of a civil court apostrophes decree is not dependent upon whether it is executed or not. Full stop. The civil court's decree inherently has a finality, which shines in its own light, with or without any execution taking place. Full stop. Next para, hence, the consideration of the learned tribunal as to whether the decree was put into execution was entirely beside the issue. Full stop. Next para, secondly, insofar as the judgment cited by learned senior counsel appearing for the private respondent is concerned, conspicuously, the said matter went up to the Honorable Supreme Court in a challenge against a decree passed by a civil court. Full stop. As held earlier, the parties aggrieved with a civil court's decree have every right to challenge the same by way of a regular appeal before the appropriate court. Full stop. In the case of in Horimohan Dana Supra, it was a civil court's decree which was challenged up to the Honorable Supreme Court, in which context only the Honorable Supreme Court held that the civil court did not have jurisdiction in view of a bar of law as embedded in section 61 of the 1955 Act. Full stop. As opposed thereto, in the present case, the precise contention of the writ petitioners, which is justified according to us, is that the civil court's decree has never been challenged by any of the defendants / respondents herein. Full stop. Having not done so, the decree was permitted to attain finality. Full stop. Even going by the judgment of Horimohan Dana Supra, the civil court's decree had to be challenged for the Honorable Supreme Court to finally hold that the decree was non-est. Full stop. Without being set aside by any appellate court and or being held to be non-est, the civil court's decree cannot be bypassed by the learned tribunal, as reiterated time and again in Sudharani Maiti Supra and Kshitish Chandra Kamila Supra. Full stop. Next para. Secondly, in the case of Horimohan Dana Supra, the respondent therein had not double inverted seriously disputed double inverted close the arguments based on section 61 of the 1955 Act relating to the bar of the civil court. Full stop. Thus, in the light of such concession, the Honorable Supreme Court proceeded to adjudicate on the said issue. Full stop. Although we are conscious of the fact that irrespective of the consent on law, the judgment of the Supreme Court would otherwise be binding on us, in view of the factual distinction, inasmuch as the Supreme Court's judgment was rendered in the context of a challenge against the civil court's decree itself, we find that the said judgment does not come to the aid of the respondents in the present case, where the civil court's decree has not been challenged before the appellate court, but has been held by the learned tribunal, entirely without jurisdiction, to be a nullity. Next para. It is to be considered further that in circumstances where the primary relief sought in a suit is the declaration of title and possession of the plaintiffs, and only as a consequential relief, a challenge is thrown to the recording of names in the records of rights or grant of patta or other settlement, it is the primary relief which has to be looked into to assess whether the suit is maintainable or not. Full stop. Next para. Proceeding from such perspective, comma, since the primary relief was declaration of title in the suit filed by the writ petitioners in WPLRT 5 of 2026, comma, the said relief, comma, not being able to be granted by the tribunal or any authority under the 1955 Act, comma, could not be said to have been barred before the civil court. Full stop. Consequentially, comma, any ancillary relief granted by the civil court in aid of the said primary relief could not also be held to be not maintainable. Full stop. The position would have been otherwise if the sole or primary relief sought before the civil court by the plaintiffs was a correction of the records of right, comma, in or a cancellation or annulment of the patta, comma, in which case, comma, it might still have been argued that Section 61 of the 1955 Act operated as a bar to the civil code. Full stop. Thus, comma, from the above discussion, comma, we find that the question as to whether the civil court had jurisdiction in the facts and circumstances of the present case is at least arguable. Full stop. Hence, comma, unless a competent appellate court set aside such decree on the ground that the same was without jurisdiction, comma, the decree of the civil court could not be ignored at the drop of a hat by the tribunal or by any other forum or authority. Full stop. Even otherwise, comma, the learned tribunal does not have the power to declare the title or possession of a person. Full stop. Hence, comma, proceeding from such premise as well, comma, it cannot be prima facie held that the civil court jurisdiction was barred by operation of Section 61 of the 1955 Act without any scope of arguability. Full stop. Next para. Coming to the second question, comma, we do not find any provision within the four corners of the West Bengal Land Reforms Act 1955 or the corresponding rules or the 1991 Land Manual empowering the revenue officer or the tribunal or the land tribunal to grant, to direct eviction of a person and enforcement of possession of any patta holder, comma, except at the first instance, comma, when a patta is annulled. Full stop. Subsection 3 of Section 49 of the 1955 Act, comma, relied on by the learned additional government pleader, speaks of a situation where an order has been made under subsection 2 of Section 49, comma, which is for annulment of the settlement or both the settlement and the transfer where the criteria stipulated in the said subsection are satisfied. Full stop. Only in case of such annulment of settlement and stroke or the transfer, comma, subsection 3 of Section 49 comes into operation, comma, by dint of which the revenue officer may enforce delivery of possession of such land to the collector by using such force as may be required after evicting the person in actual occupation of such land. Full stop. Next para. Subsection 3 capital A of Section 49 is in furtherance of the provisions of subsection 3, comma, providing that for the purpose of enforcing delivery of possession of any land and evicting any person, comma, the requisite the written requisition and other modalities for police help can be resorted to. Full stop. Next para. However, comma, such scheme of Section 49, comma, subsections 2, comma, 3 and 3A subscript bracket is not applicable when the patta holder was put in possession in the first place, comma, as is the case of the private respondent, comma, and was allegedly dispossessed subsequently. Full stop. In case of such subsequent disposition, comma, nothing in section 49 empowers the revenue officer to grant further possession, to enforce further possession in favor of the patta holder, comma, ad infinitum. Full stop. Next para. In such a situation, comma, the appropriate remedy before the patta holder, comma, if a valid one, comma, would be to take resort to appropriate provisions before a competent civil court under section 6 of the Specific Relief Act 1963 and or by filing a regular civil suit. Full stop. Next para. The rules referred to by the tribunal are also not applicable in the present case. Full stop. Next para. Rule 20 capital A of the West Bengal Land Reforms Rules 1965 speaks about terms and manner of settlement of lands at the disposal of the state government under section 49. Full stop. Next para. Under clause 3 small b within bracket small I of rule 20 capital A, comma, the collector or the district land and land reforms officer or the subdivisional officer, comma, within whose jurisdiction the land is situated, comma, shall deliver possession of the land to the person with whom it has been settled, and if necessary, after evicting the person in actual occupation of such land in the manner laid down in subsection 3 of section 49. Next para. Thus, comma, on a plain reading of the said provision, comma, it is clear that that rule 20 capital A operates within the aegis of subsection 3 of section 49 of the parent statute, that is the 1955 Act. Full stop. Next para. Since we have already held that section 49(3) itself is not applicable, comma, there is no question of rule 20 capital A being attracted as well. Full stop. The tribunal apparently resorted also to the provisions of the 1991 manual, comma, which are also not germane in the present context. Full stop. Next para. Thus, comma, the second issue is also decided in favor of the writ petitioners, comma, to the effect that the revenue officer or the tribunal, the revenue officer, comma, within the four corners of the 1955 Act, comma, or the corresponding rules or land manual, comma, has no authority to evict a person and restore possession to an alleged patta holder, comma, after except after annulment of a settlement or transfer. So next para. Moreover, comma, it is the tribunal which granted eviction in the present case at the first instance. Full stop. No provision within the contemplation of the 1955 Act empowers the tribunal, comma, in any event, comma, to do so. Full stop. The tribunal, comma, it is to be remembered, comma, is not the revenue officer and in any event cannot usurp the jurisdiction of such officer. Full stop. Next para. Apart from the above two issues, comma, there are certain sub-issues which cannot also be glossed over. Full stop. For example, comma, the petitioners in WPLRT 5 of 2026, comma, who were the decree holders in the suit, the comma, the decree of which was ignored by the tribunal, comma, were never included in the original application before the tribunal, comma, which, comma, in any event, comma, rendered the original application bad for non-joinder of necessary parties. Full stop. However, comma, in an oblique manner, comma, the said writ petitioners, comma, who were plaintiffs in the suit, comma, were named in a subsequent notice issued pursuant to the impugned order of the tribunal. Full stop. Such exercise itself speaks of malafides. Full stop. Next para. Secondly, comma, the writ petitioners in WPLRT 3 of 2026, comma, who were not even parties to the suit, comma, were impleaded in the original application, comma, which was also erroneous due to misjoinder. full stop, next para, be that as it may, comma, since we have held that the exercise of jurisdiction by the learned tribunal was palpably dehors the law and without jurisdiction, comma, there is no necessity to further dwell on the other issues. Full stop. In view of the above observations, comma, WPLRT 3 of 2026 as well as WPLRT 5 of 2026 are allowed on contest, comma, thereby setting aside the impugned judgment dated December 2, 2025, passed by the third bench, comma, West Bengal Land Reforms and Tenancy Tribunal in OA 2177 of 2023 within bracket LRTT. Full stop. Any action taken in pursuance of the said judgment, comma, including eviction of the writ petitioners, comma, stands hereby reversed, full stop. The respondents shall take immediate steps to ensure that the possession of the writ petitioners in respect of the subject plots are restored within a period of 90 days is the appeal period from our order, within a period of 90 days. Full stop, next para.
Disposition within 2 weeks, my lord, restoration 90 days.
You'll have to give them the appeal period.
The correction of record of rights in my favor, my lord, because that issue will never be adjudicated thereafter.
That was not the subject matter of the tribunal.
But my section 50 application was directed to be disposed of by the tribunal. That was never adjudicated upon. And after the civil court's decree, my lord.
No, but here we are deciding only on the on their application to dispossess you.
But my lord, as a residual,
that is no. That is a different proceeding. That there is a standing order of the tribunal. You implement that. You file a contempt before the tribunal for that.
2018 order, my lord.
Yes, but that is not the subject matter of the challenge before us.
Only one thing, Lord. Lord, only one. Your Lordship has recorded that for the first time the tribunal has directed, Lord, eviction. That is not authority directed eviction. That is implementation. Because he has not annexed this. Lord, this is the.
That will be another ground of issue.
No, Lord, not that. Your Lordship has recorded it. It is not correct. This is not the grateful factual aspect. Lord, your Lordship kindly grant us some liberty to take.
90 days we have been given.
No, that is not against regarding limitation. Regarding limitation, Lord.
That has attained finality. Yes.
Item number 25.
Yes. Yes, what is the motion about? Who is appearing? Yes, what is the matter? Yes, Mr. Chattopadhyay, what is the matter?
My lord, last occasion, I pointed out, my lord, one of the respondent, my lord, expired. And my lord, it was my mistake, my lord, to point out, my lord, another Sebaith was also a party to the proceeding, my lord, and he was not served. This time I have served, my lord. He has received. There are two Sebaiths, one expired, my lord, another, my lord, Lordship Director, my lord, oblique, my lord, existing Sebaith. That is done.
There is a surviving Sebaith.
Yes.
He is named in this petition.
Yes, Lordship, he is, my lord, so kindly come to page 5 of the writ petition.
Yes.
My lord,
Sebaith
and Prosenjit Sahu.
Acha, Jagadish died.
Jagadish died. Prosenjit Sahu, my lord, is a surviving Sebaith.
Very.
He is, sir.
What is the matter?
No, my lord, I must say, my lord, our purpose has been served. My lord,
so then you are disposing
54
as infructuous. Thank God.
No. 54 appeal was order was challenged before the original application tribunal. Now, my lord, that is set aside, and matter has been remanded.
Remanded to the appellate authority.
You have challenged the remand.
That part, not remand part, my lord. We are satisfied that the matter has been order has been set aside, matter has been remanded back. We have challenged, my lord, while remanding the matter back, my lord, certain observation, my lord, normally Lordship also done, my lord, without going into the merit of the matter, without being influenced any of the observation, that is not done. On the contrary, my lord, certain observation has been made. My lord, really, my lord, what we apprehend, my lord, will affect, my lord, the further adjudication of the appeal.
Mr. Chattopadhyay, what is the genesis of this matter? It started from what?
Started, my lord, a portion of the land was recorded in the name of, my lord, the Sebaith.
Idol.
DT. Now, my lord, that was challenged. My lord,
sought for a correction of the record.
Correction, my lord, that was not allowed.
we have preferred an appeal. Appeal court, my lord, affirm the order of my lord BLLRO.
So to prefer the challenge before the tribunal, tribunal remanded why?
Remanded, my lord, recorded, my lord, it's absolutely bad order, this, that, and remanded the matter.
What are the findings which pinch you?
My lord, lordship kindly come to page inner page 10 and 187.
Can there be any challenge against findings only?
No, not finding. What I am on, my lord, only record, my lord, without having been influenced any part of, my lord, the adverse remark on the part of the tribunal.
So, Math, what do you say to that?
My lord, only 2 or 3, my lord.
The very recent order by the tribunal, it has detected that what are the wrong committed by the appellate authority and remanded.
Yes, that part.
Let us first see what Mr. Chottalu, what are the findings?
187, page 187.
Refer to the internal pages of the
10, internal page 10 of the order under challenge. My lord, running page 187.
Yes.
Considering all the attending facts and circumstances, we do conclude that the amendments incorporated in the original application are full of confusion of perfunctory drafting.
Your application.
Yes. Now, there are certain, my lord, observation why it is made perfunctory, that is not there. My lord, I am referring, my lord, to the paragraph starting by non-application. Non-application of mine by the appellate authority under section 54 of the WLR Act reads large from the order challenge and taking advantage of such erroneous order of the appellate authority, the applicants had preferred the instant original application with confusing averments and prayer. Such original application is practically devoid of any merit. On one hand, my lord, he is setting aside the order under challenge, and on the other hand, my lord, making this observation. I mean, when this matter,
how does it affect you? It is not on the merits of the case. Even.
No, not on, but that is why my
on your drafting. You drafted badly and it is.
that is recorded.
Either you or you.
Only one thing, my lord. Lordship kindly, my lord, dispose of, my lord, directly, my lord, the appellate authority, my lord.
There is no finding against you.
No.
Just that the application was the averments were confused.
His observation, my lord, will ultimately, my lord, he will be, my lord, my responsible submission. He might be, my lord, might take.
No, we don't find any reason to interfere.
So, my lord, I'm not, my lord, inviting you, lordship.
Cost of 1 rupee on it.
So only one thing, my lord. Let the appellate authority, my lord, take a fresh decision on the basis of the available materials before.
Not add anything to the order. The order is perfectly fine.
Order perfect, my lord. I'm not on that, my lord. These observations is, my lord, suffering.
And particularly under 183, the decision, the first reasoning.
Yes, we are seeing that so many beautiful.
Very good reasoning.
Decision, my lord, started, my lord.
You just see internal page 6 onwards.
Inner page 6, page 83.
Appellate authority did not consider relevant deeds of ownership.
6, my lord.
It has been actually passed in your favor.
Yes, my lord. 6, my lord. The grounds we have made in the original application that has been set out, my lord.
Everything
is there.
Record that this does not affect you in any manner.
My lord. My lord, this will not be taken note of by the appellate authority. My lord,
that will not. Mr. Mahata, we are not interfering with the imperial order. We are just saying that in any event, we don't accept his argument that this will affect him. We'll say that. So that will serve his purpose also. If he, the present challenge is on a very limited conspectus. Full stop. The writ petitioners, complaining that the records of rights ought to be corrected, having erroneously depicted the name of the private respondents as the recorded owners, the said application was rejected by the revenue officer, being aggrieved by which an appeal was preferred under section 54 of the West Bengal Land Reforms Act 1955. The appellate authority affirmed the findings of the first forum, upon which an original application was preferred by the writ petitioners before the West Bengal Land and Land Reforms Tribunal, giving rise to OA number 1446 of 2022 (LRTT). Bracket close, full stop. Next para. Learned counsel for the writ petitioners submits that although the writ petitioners are otherwise not aggrieved by the conclusion of the learned tribunal to the effect that the matter was remanded to the appellate authority for a fresh adjudication on merits on the grounds as mentioned in the impugned judgment, some of the observations in the impugned judgment may adversely affect the interest of the writ petitioners. Full stop. learned counsel for the writ petitioners takes us through certain observations made in in page number made at internal page number 10 of the impugned judgment, to the effect that the original application of the writ petitioners before the tribunal was made with confusing averments and prayers, and the same is practically devoid of any merit. Full stop. Next para. It was further recorded that the averments incorporated in the original application are full of confusion because of perfunctory drafting. Push up next para. However, we are unable to agree to the contention of learned counsel for the writ petitioners that such observations affect the merits of the contentions of the parties and or the interests of the writ petitioners in any substantial manner. Full stop. Comments of the learned tribunal on the unhappy drafting of the original application and that the same was devoid of merit did not have any effect on the outcome of the original application, since the learned tribunal, in any event, jotted down categorically the specific points where the appellate authority went wrong, and on such premise, remanded the matter to the appellate authority for a disposal afresh by a reasoned order by considering relevant factual aspects and documents brought on record by the interested parties. Thus, there was no error on the part of the learned tribunal. Moreover, no legal right and or interest of the writ petitioners have been infringed merely by the findings which are with which the writ petitioners are aggrieved. Hence, there is no scope of interference with the impugned judgment. Accordingly, WPLRT 199 of 2025 is disposed of without interfering with the impugned judgment dated August 14, 2025, passed by the fourth bench, West Bengal Land Reforms and Tenancy Tribunal in OA number 1446 of 2022, within bracket LRTT bracket close, in the light of the above observations. No orders to cause certain settlement. প্রথমেই একটা করে দেবেন যে ওই affidavit of service filed to be kept on record. Despite service, none appears for the private respondents, although the petitioners and the state respondents are represented through counsel.
Item number 26.
Yes, sir. You are asking for time in this matter, but you are there on some other ground.
Well, because of third instruction, I am.
You want to come back on a subsequent day?
If it is my lord, right?
Due to the indisposition of learned counsel appealing for the appellants, let the matter stand adjourned for the day. So, your throat infection is not related to the merits of the matter.
No, it will be admitted.
You're confident?
Admitted on two grounds.
Well.
And Mr. Rai was also today is not there.
Mr. Devashish
Rai, the advocate on that.
Oh, very good. Let us come back to
Item number 27.
27, this is my application.
Yes.
This is against the impugned order of 13th March 2024. The ad interim has been.
Condonation been allowed.
Has been allowed.
Nobody appearing for the other side. You have...
Nobody.
There is no caveat.
No caveat.
Yes. What is the matter?
Main order, my lord, we have filed a suit for declaration. I am a tenant. I have sought for declaration that I am a rightful tenant. The my lord, ad interim granted. Thereafter, in the year 2021, thereafter in the March 2024, this impugned order has been passed by rejecting the interim order, Order 39, Rule 1 and 2. Now, only on the issue is that, my lord, I have failed to provide two documents, necessary documents of that I am a tenant. I have annexed the rent receipts and also the trade license respect of the property. Now, what happens, my lord, I have been informed by the respondent number 1 bank that SURFACE proceedings has been initiated and you will soon be evicted. No proceedings per se have been filed against me or any eviction suit pending. I have only filed.
Oh, you produced rent receipt, trade license, but it was observed by the court that
Yes.
current ones have
Current
not.
ones is not.
And what about the surface? Let us see.
Yes,
Defendant
surface,
one
yes.
submitted is at liberty to approach DRT for relief. Why 13.4 as steps have been taken?
That I have no knowledge with that.
Was it disclosed? Was any objection filed by the other
Objection
side?
filed. Can you see
Did
the
they give any number of the or any annexure regarding the 13.4? Where is the objection?
objection? I can only see from the order.
No, why didn't you annex the objection of the other side?
Objection has not been annexed.
Objection has to be annexed.
May I come back with that supplementary by annexing all the documents, because we have annexed the suit, not the annexures of the suit, before your lordship. The impugned order only relates to two parts, that I have failed to produce documents of rent receipts.
Surface was also recorded.
Yes, recorded, but lordship, the meaning of the purport of the order, if I can try to.
So who is the respondent number one? Bank?
Bank. UCO Bank. The suit is still maintainable.
Let's see what is their case.
Yes. Now their case, as pleadings of the order, I'm sorry, not pleadings, that the order dictated, it has been taken that first para, it states that the case of the plaintiff is a tenant under such and such. I'm skipping the first para. Second para speaks about the defendant number one appeared and contested the claim by filing written objection.
Have they stated when the mortgage was given?
No, my lord. And created a mortgage.
You don't have a copy of the written objection. How do you know? How do you know? Do you have a copy?
I have a copy now.
Give us a copy.
Sure, my lord.
Give us that.
But I have only, my lord, one copy.
Very well. Give us whatever. We'll ask you later to file copies. Pre-mortgage tenant post-mortgage হলে difficulty. Executed 16. According to your plaint, since when you were a
2001.
2001.
2001.
We are admitting the present challenge. We are admitting the present challenge has been preferred against an order whereby the learned trial judge dismissed the temporary injunction application of the plaintiff stroke appellant in a suit filed by the appellant inter alia for declaration that the appellant is a tenant in respect of the suit property. Where is the plaint?
The plaint is, my lord, in page number. Sorry, my lord. Page. It starts with page number 10 of the stay application.
Tenant in the suit property is a bona fide tenant in respect of the suit property and for consequential reliefs, including permanent injunction. Full stop. Next para. In the plaint, comma, the plaintiff stroke appellant has alleged that the defendant stroke respondent number 2 inducted the plaintiff stroke appellant as a tenant in respect of the suit property in the month of October, 2001. Full stop. On the other hand, comma, the respondent number 1 bank, comma, by filing a written objection to the injunction application, comma, disclosed that the defendant stroke respondent number 2 had stroke owner had entered into a mortgage and consequential guarantees against a loan, comma, executed in the month of December, 2016. Full stop. Thus, the learned trial judge, while passing the impugned order, took into consideration that in view of the defendant number 2 having approached the debts recovery tribunal concerning disputes between the defendant number 1 and the defendant number 2 under the provisions of the SURFACE Act, and as the plaintiff stroke appellant failed to produce current rent receipts and trade license, no injunction could be granted in favor of the plaintiff stroke appellant. Full stop. Next para. However, prima facie, it transpires that as per the pleadings of both the parties at the present stage, the plaintiff stroke appellant is a pre-mortgage tenant in respect of the suit property, and as such, is entitled to protect his possession its possession irrespective of subsequent mortgage having been granted by the landlord stroke respondent number 2. Full stop. Thus, the provisions of the SURFACE Act prima facie may not operate as a bar to the institution of the suit, since the relief of declaration sought in the suit could not be granted by the Debts Recovery Tribunal within the contemplation of the SURFACE Act. Next para. Secondly, it is well settled that if a landlord-tenant relationship between the parties is shown to exist, the onus lies on the person alleging that such relationship has ceased, ceased, to prove such fact. Full stop. Thus, there is a presumption of continuance of landlord-tenant relationship under the provisions of the law of evidence in India, in circumstances where the existence of such tenancy at any stage is proved. Hence, it was sufficient for the plaintiff stroke appellant to produce rent receipts up to December 2020 and previous trade license for the year 2020-21 to establish prima facie that the plaintiff was in possession of the suit property as well as a tenant thereof. In the absence of any rebuttal thereto, it ought to have been presumed by the learned trial judge that the tenancy of the plaintiff still subsists, thereby making out a strong prima facie case for grant of injunction. Next para. Accordingly, FMAT 397 of 2024 is admitted to be heard on the above grounds and the other grounds taken in the memorandum of appeal. Next para. On the prayer of the appellant, leave is granted to the appellant to file a supplementary affidavit disclosing the written objection filed in connection with temporary injunction application and or other relevant documents, if any, in connection with the present matter. Such supplementary affidavit shall be affirmed within a week from date. The appellant shall serve copies of the injunction application as well as advance copy of the supplementary affidavit on the respondents, indicating that the application shall next be listed for hearing in the monthly list of March 2026. The appellant shall file an affidavit of service to that effect on the returnable on the next date when the matter is taken up for hearing. Next para. The respondents stroke opposite parties shall remain restrained by an order of injunction from dispossessing and or disturbing the peaceful possession and enjoyment of the appellant stroke petitioner in respect of the suit property without due process of law till disposal of Can 2 of 2024. Can 2 টা সার্ভ করতে বলেছে কি? সার্ভ হিসাবে Can 2 টা, নাহলে যদি অ্যাপ্লিকেশন করতে তো অ্যাপ্লিকেশন injunction. This much.
Great.
এটা একটু ফেরত দিয়ে দিন প্লিজ, annex this to the supplement.
Number 28. Next matter. But in this matter, the service has not yet been completed.
You directed you to serve. Appeal was admitted. Oh, we wanted to dispose of the appeal. Why not affected? When did you send?
And I have sent it on 22nd of January.
Still not come back.
Lordship, no.
What is the track report?
It is showing that item dispatched.
Acha, very well. Learned counsel for the appellant submits that although the copies of the applications and the memorandum of appeal were sent to the respondents on January 22, 2026, about 8 days after the direction being given in that regard, the postal track reports do not indicate service to have been effected till date. Full stop. Next para. Accordingly, on the prayer of the appellant, let the matter stand adjourned till February 16, 2026, when it will be listed under the same.
Item number 20.
29, my lord, I appear for the appellant.
Yes, please.
Yes, my lord, I appear for the appellant, but my lord, I seek to withdraw on the want of pecuniary jurisdiction. My lord, this is a partition suit valued at rupees 70,000.
Oh.
Right.
Learned counsel for the there's a section 5 application also.
Yes, my lord, there's a section 5. My lord,
So we'll say that is dismissed for non-prosecution. Consequentially, the others. Very
yes,
well.
my lord, lordship will grant me liberty to file it before the appropriate court, my lord.
Very well. Learned counsel for the appellants, at the outset, submits that after filing of the appeal, it was detected that this court does not have pecuniary jurisdiction to take up the matter. Who's up accordingly on the prayer of the appellants, FMAT 496 of 2024, along with Can 1 of 2025 and Can 2 of 2025, are dismissed for non-prosecution with liberty to the appellants to prefer an appeal against the impugned order before the appropriate forum having pecuniary jurisdiction, subject to the legal provisions as to limitation. Full stop. Next para. Liberty is given to the learned advocate on record for the appellants to take back the certified copy of the impugned order upon furnishing a photocopy thereof for the records. No address.
Grateful to your lordship.
Item number 30.
May please your lordship.
Yes.
I am appearing for the plaintiff appellant.
Acha.
Section,
Can 1 was section 5?
No, section 5 is allowed.
Yes, that was Can 1.
That was Can 1.
Can 1. So now the appeal is for order for
Yes. And this is a suit for declaration of title and other consequential relief and permanent injunction filed by the plaintiff. And the facts of the case is that
he lost in both courts.
Yes, he is with me.
Lost in both courts?
No, I have also lost in the trial court and in the first appellate court. That is partly allowed. My appeal is partly allowed.
Achha.
My lord, kindly come to the facts. Under the plaintiff appellant, my lord, files a suit for declaration of title and other consequential relief and permanent injunction against the defendants. My lord, the plaintiff's case is that one Jadulal Sardar, Jadu Sardar, was the father of the plaintiff. Jadu Sardar was the recorded of CS record of rights, recorded owner of CS record of rights. And my lord, Jadu Sardar died intestate, leaving behind his wife only Moni Sardar, and Monibala Sardar died intestate, leaving this petitioner, the plaintiff appellant. On the other hand, my lord, the defendant's case is that Jadu Sardar was the recorded owner and his name was recorded as the Rayat in the CS record of rights. And after that, Jadu Sardar died intestate, leaving behind his wife Monibala Sardar and mother Roti Sardar. And Monibala Sardar transferred the said land, my lord, by way of execution of deed of sale, that is deed of by way of settlement, to one Goti Sardar in the year 1939. And thereafter
is an outsider or the mother?
Mother, both mother and.
You say Jodu left only his wife.
Jodu left only his wife.
Whom you claim.
Yes.
And the other side says
Other
Jodu
side
left
says,
wife and mother.
Yes.
Wife sold to somebody else.
Somebody else, Goti Sardar.
He's a third party to the family.
Yes, third party to the family. Thereafter, Goti Sardar also retransferred the said land to Monibala Sardar and Roti Sardar again. on the same date, that is 6th January 1940. On the same date, my lord, the said
So it
Monibala
came back to the wife.
yes,
Came back to the wife.
I came back to the wife.
Then?
Came back to the wife. Then on the said date, my lord, on 6th January 1940, two deed were executed, that Monibala Sardar and Rotiwala both executed the suit plots to one Umullah Sardar and Fatik Sardar, the predecessors in interest of the defendants.
Rotiwala was the mother.
Yes, Rotiwala is the mother.
So on
She
the same day sold to third party returned and
Yes.
again sold to fourth party.
Yes, they sold to fourth party.
Very good.
Thereafter, my lord.
He did not sell back? The fourth party did not
No,
sell?
the fourth party is the legal predecessors in
Predecessor of these
interest of the
defendants.
defendants.
Right. Then
Predecessors in interest of the defendants. Then, my lord, kindly come to the, my lord, decision passed by the point for decision with reason.
so what was the finding of the trial court? Believe their case. Dismiss your suit.
Yes, dismiss the issue.
And how did the what did the appeal court do? Tell us, then we will go to the
Appeal court, my lord, kindly see. Appeal court did not make any kind of observation.
What is the partial degree
with
granted?
the appeal court, my lord, partly allowed only that these property, some of the property were not sold. Out of that execution of.
Why is that wrong?
Wrong is that, my lord.
The sale deeds were before the appeal court and the trial court.
Wrong is that, my lord, the my lord, mother
Yes.
of the plaintiff was a rustic village widow, and she had no capacity to understand about the transaction of the sale being settlement of patta to a third party. That is, my lord, established, my lord. I am relying on the basis of the 1962 Supreme Court decision, when a rustic village widow has no capacity to understand regarding transaction of the
Did
soul.
you take this point before the
Yes,
trial?
I have taken this point.
So did they prove how did the courts deal with this?
No, court did not deal with this.
Read over and explain
Yes.
was not proved.
Even trial court and as well as the appellate court did not deal with this.
Did you take the point at all?
Yes, I have raised the point at all.
Show us
in
that.
the trial court.
Show us that you have raised the point.
Kindly come to the, my lord, page, inner page, before the, my lord, last page of the trial court, before one page, inner page. Learned lawyer for the plaintiff verbally submitted in his argument that as per the Dayabhago system of Hindu law, only the wife could inherit the property of the husband, and that inter alia it is not possible that a tribal lady shall acquire property and sell it on the same day through the deeds have no value at all.
Tribal lady shall acquire property. Not possible that a tribal lady shall acquire property.
Tribal lady, they she is belong to tribal community.
Tribal lady does not mean she was illiterate or she was Pardanoshin or whatever. Tribal lady may be very, acquainted with day-to-day affairs also.
My lord, furthermore, there is another thing, my lord. That, my lord,
A tribal lady is leading our country now, Mr. Adhikari.
Tribal lady.
She's the head of our country. So tribal lady means nothing.
No, my lord.
Sorry.
She is, my lord, the.
There has to be a specific averment that she was illiterate or rustic.
Yes, she was, my lord, illiterate and rustic.
Not even any averment. So why should you interfere in second appeal?
My lord, kindly see.
Tribal does not necessarily mean otherwise. We associate the two, but that's our notion, typical urban notion.
My lord, it is the decision of the trial court.
Yes.
That the plaintiff has not able to prove that she is the daughter of, my lord, Jodu Machi. But, my lord, here the plaintiff clearly stated in her plaint that she is the daughter of Jodu Machi, and the, my lord, the deed of execution of settlement by the, my lord, Monibala Sardar and Roti Sardar, there is clear averment that Monibala Sardar was the wife of the my lord Jodu Sardar. Now, kindly come to the my lord. This point, it is my lord decided by the learned trial court. It is, my lord, kindly come to the page 15, inner page 15. My lord, issue number 7. My lord, I am reading. The suit plots transfer, retransfer the same to Moni and Torirasi. Thus, as against this case of the defendants, the
We can't find paginations. We can't find the paginations.
Resignation, my lord, that is, my lord, inner page 15, that is written handwriting, inner page 15.
In our certified copy is not there. No,
Page 13, thereafter blank, no number, page 13, kindly see page 13.
16. তার আগে এখানে নেই দেখুন এখানে 13 আবার লেখা issue number 7 issue number 7 in our my copy is page 12.
Issue number 7.
And it starts with issue number 7, a gist of the plaintiff.
My lord, kindly come to the page, my lord, that is page, my lord, 15. Page 15.
It starts with what? The page starts with?
Yes, issue number 7 starts with page 12. Thereafter 13. Thereafter, no, my lord, page number. Thereafter, my lord, page number 14. Thereafter, my lord.
Thereafter comes 15, after 14.
After 14, my lord, no page
and
number.
Thereafter 16 will come.
Thereafter 15.
So we stop at 15.
Yes.
Exhibit 1, the middle paragraph says Exhibit 1 reveals.
Exhibit 1, from the Exhibit 1. The Umesh Chandra Vishwas and other are landed of the some property, landlord of some property in the suit dogs, respective dag number 379. The Exhibit 1 nowhere reveals any possession or acquisition of land by Jodu Sardar. My lord, this is, my lord, where the Jodu Sardar's name had been recorded in the CS record of right as Rao. Therefore, he has the title. And my lord, the plaintiffs did not produce any land document to show that Jodu Sardar are produced these suit lands. Moreover, the case of the defendant 1 to 3 is that the plaintiff is the daughter of Goti Sardar, not Jodu Sardar, who that is which Goti Sardar, after getting the same and in some of the suit plots.
We don't understand this. Jodu Sardar's title is admitted by them also.
Yes. Yes.
Jodu Sardar's title is admitted by everybody.
But, kindly come to these findings that this plaintiff is not the daughter of, according to the my lord written statement, the defendant stated.
What proof of daughterhood did you produce? What did you produce? What document did you produce to show that you are the daughter?
My lord, it is the onus of proving lying upon the defendants, my lord, because of they have, my lord, raised the question.
You file a suit claiming title through your father.
Yes.
You don't have to prove that you are his daughter.
That
you stand or fall on your own case.
That is, my lord, Exhibit 2, the LR record of rights, some of the plots of lands also devolved upon the plaintiff.
No, to show that you are the daughter of Jodu Sardar, what have you produced to show that?
That is, my lord, the LR record of rights, Exhibit 1.
That says that you are the daughter.
That the properties belong to the Jodu Sardar devolved upon, and her name was recorded against those property.
Your name was recorded?
Yes. That is Exhibit 1.
In Exhibit 1?
Exhibit 1, Exhibit 2. Exhibit 1 is also CS record of rights.
Exhibit 1 is Umesh Chandra Vishwas and others who are landlords.
That is, my lord. That is, my lord, dictated in Umesh. Kindly see. This is, my lord, Exhibit 1.
No, we cannot look into that. We have to go by in second appeal order for turn. We won't look into any document. We'll just look at the findings. The exhibit list must have been referred to by the trial court. Let us see the exhibit.
My lord, kindly see. This is the CS record of rights.
No, we'll first see. We won't see anything. How do you know that was produced in the trial?
Yes, exhibit.
Sorry, we'll go by the trial court.
Kindly see exhibit.
Please come to page 10. 10 of the trial court judgment. There the exhibits have been referred to.
Exhibit, yes.
One is CC of certified copy of CS Khotian 98.
Yes,
Two is
CS
CC of LR Khotian
98.
151.
98, this is CS Khotian. But in CS Khotian, the name of Jadu Sardar had been recorded as the Rao under the upper Tumesh Chandra Vishwas.
And
Can you see?
LR Khotian?
And LR Khotian, the LR Khotian is it? LR Khotian, my lord, that is Khotian number 88. My lord, that is, my lord, in the name of my lord Thupubala Dasi, wife of Potul Sardar. My lord, from this LR Khotian, it is purely evident that the CS plot
देखिए तो की दिख
that the CS plot of land, এটা দিন, এটা CS Khotian.
भी वाला है ये plenty.
That the CS plot had been recorded, my lord, in the name of Jadu Sardar under the upper Rayat
Jodu कोথায় है?
Umesh Chandra Vishwas. And this is, my lord,
Where is
wrong
Jodu?
finding of the
We can't find Jodu. This is Umesh.
23rd column. Upper column, my lord, Umesh Chandra Vishwas. Some of the plots are there, which are not the suit plots.
Joduর নাম কোথাও এই আছে এইখানটা Jodu কোথায়
Plot number 446, plot number 390, 446, 557, 463.
Jodu কোথাও দেখছেন
These plots were appearing.
জাদুর গায়ে হাত বুলোচ্ছে Find out Jodu for us. Put a pencil mark and show her officer. Jodu দেখে নিন আপনি Jodu দেখে আমাদের Jodu খুবই ভালো নাম রয়েছে এখানে এইসব কি আমরা এখন second appeal we shall consider the evidence reappraise the evidence Mr. Adhikari. Are we supposed to?
Yes,
Can we
but evidence, there is evidence.
Yes, evidence, but no consider.
No consider. Evidence, there is, my lord, evidence today.
না এখানে বলছে exhibit 2 shows that plaintiff has এই পাতা 15 পাতা
Kindly see the, my lord, cross examination.
নিজেরা দেখুন
এটা দেন, এখানটা দেখুন। Cross examination
এখানে
of
বলছে
Thupubala Sardar.
two documents marked as exhibit 1.
My lord, my father died. Kindly see the
Is a
cross.
new document. What about that document? Where is Jodu's name?
Jodu's name. Kindly see the cross.
It's a new document. You submitted a document. We returned it to you. You say Jodu's name is there. Where is that?
Yes. এই যে জাদু পিং নন্দলাল সর্দার
ওই জায়গাটা দেখান
জাদু পিং নন্দলাল
সবচেয়ে এলিজিবল জাদুই This is whose cross examination? Your?
Yes.
Why are you relying on your cross examination? Why are you relying on your cross examination?
Cross examination because of, my lord, she has stated clearly that Jodu Sardar is my father and, my lord, আরেকটা আছে তো, and I was, my lord, in the home when my father died. Kindly see this cross examination.
No, we don't find anything. In second appeal, we won't consider these things.
My lord, so far as, my lord,
This is a factual appreciation of evidence by
my lord, so far as, my lord, this is not clear finding of the learned trial court.
No.
So far as, my lord, defendants, my lord, stated in their, my lord, written statement that the, my lord, rustic village widow, my lord, transferred the
rustic village we don't find anywhere. Only tribal lady.
a tribal lady here, my lord.
Tribal
but
lady
there
has to be rustic village widow.
Because of, my lord, in the year 1940, my lord, Monibala Sardar.
All the deeds are of 1939-40. Everyone was rustic then.
Yes, but
Jadu Sardar was also rustic.
On the same date, my lord, kindly see on the same date, 6th January 1940.
Saying she was a tribal would do. All of the parties were tribals.
Yes.
And still are tribals.
I'm not coming to that point. I'm coming only this point, my lord, kindly
So
see.
why are you repeatedly saying rustic village woman?
because of
All
my
of
lord,
them are rustic village people at that point of time.
Because of my lord, in the year 1940, my lord, on the same date, 6th January 1940, my lord, she has executed the deed, both Monibala and Toribala. And my lord, when the child was born in the home, my lord, according to the cross-examination, she had the interest over the property. So they
She was in the womb then?
Yes, home, that is one. That is, my lord, clearly in the cross-examination. It is appeared in the cross-examination. She was in the home of her mother. And from the, my lord, the deed of execution, there is clear statement that Monibala Sardar was the wife of Jodu Sardar. Therefore, my lord, she had no capability to understand about the transaction on the same date. But this is the collusive transaction in favor of the, my lord, defendants, my lord, predecessors in interest.
There are no, in case of collusive or fraud, you have to specifically aver under Order 6 Rule 4. What are
My
the
lord,
specific
because of, my lord, after the, my lord, filing of the plaint, the written statement, my lord, were submitted by the defendant number 1 and 1 to 3, and other defendant did not submit any written statement. My lord, in that written statement, it is, my lord, appeared. Therefore, my lord, this could be considered by the learned trial court whether this transaction is, my lord,
That's a pure question of fact, no question of law at all. Both courts considered and came to a finding. No question of law.
There is no finding. Why not? It should be decided with finding by the learned trial.
So why are you citing this judgment, Mr. Adhikari? For what proposition? You have cited this judgment, or it was?
Yes, Sonia Parsin. Another judgment is Sonia Parsin.
No, this judgment. Why did you cite? For what proposition?
Proposition, my lord, a village rustic widow.
Which paragraph?
My lord, paragraph number 5, 6, 7, 8. This is clearly, my lord. And my lord, this is.
Have you seen the first sentence of para 5? Please read it. In this case, Khorbuja case, para 5, please read the first sentence. Very first sentence of para 5.
It is settled law that a high court has no jurisdiction to entertain a second appeal on the ground of erroneous finding of fact.
We rely on that. We rely on that.
But in the, my lord, instant case, my lord, kindly see in the instant court, learned Munship and on appeal.
There it was a case of Pordanoshin lady. Pordanoshin lady, that principle was definitely Pordanoshin illiterate lady.
She was, my lord, Pordanoshin lady. This is, my
She
lord,
became Pordanoshin also. She was a tribal previously.
tribal previously.
There are very few tribal Pordanoshin ladies. Do you know that?
Yes, Pordanoshin lady.
There are very few tribal ladies who are Pordanoshin.
No, I am
not any idea of tribal people.
But my lord, she was, my lord, at the time of execution, she had no capacity to understand because of
If you
lady.
If you have your say, then you will make her illiterate, Pardanashin, what not. We cannot improve things. I mean, it's a factual finding, and we rely on this first sentence of para 5 of your judgment.
One will kindly see the appellate court judgment. Appellate court, my lord, did not deal with trial court's judgment. Kindly see the appellate court judgment. Appellate court, my lord, clearly stated that, kindly see, did not deal with any kind of, my lord, observation passed by the learned trial court. Appellate court passed. আগের দিকে কোথায় দিস কেন? Kindly, my lord, kindly come to the.
You did not argue 1 to 6. Issue number 1 to 6. 1 to 6 included is a schedule of the suit property. The appended is vague. Oh, very well. Those are on ancillary issues. So 7 is whether plaintiff has any right title. Let us see how it is dealt with.
In the appeal court issue. Is the plaintiff entitled to get a decree as prayed for? When you kindly see the order passed by the learned appellate court. Paramount 13, TS ROR is in favor of Jodu Sardar. The registered deed of patta dated.
Your right title interest has been declared in respect of a part of the property which was not the subject matter of those deeds.
My lord, kindly see that page number 4, paragraph 15.
Yes.
It is, my lord, whispered that, my lord, these the quantum of lands are not sold. This is the observation.
Your title has been declared in respect of those.
Yes, but these quantum of lands are not sold. Kindly see this paragraph.
These were not sold. That's
These,
why
yes.
those remained with your father, and therefore your title has been declared in respect of those.
In respect of those, but not, that was not dealt with the, my lord, deed of execution of for the year 1940, and also finding of the learned trial court.
The plaintiff did not raise any objection as regards registered deed of settlement executed by Munidashi and Tadidashi in favor of footing and Amul.
That is, my lord, appeal court's decision. That is, my lord, that is,
yes.
That is, my lord, appeal court's finding. But that, my lord, finding did not deal with the trial court's finding. Kindly see that did not deal with the trial court's finding. The trial court's finding was first finding at that Monibala Sardar. It is admitted fact by both the party that Monibala Sardar was the wife of Jodu Sardar, and Monibala Sardar executed, my lord, a deed of sale in the year 1940. On the same date, my lord.
So what is your argument? We don't understand. What is your question of law?
So far as my lord, argument is that, so far as Monibala Sardar at that time, my lord, Monibala, it is not possible to understand her about the execution of the sale deed.
Why?
Because of, my lord, she is purely Pradhanshin lady, and she had no capacity to understand.
There is no averment that she was Pardhanoshin.
Because of, my lord, the plaint was filed.
There is no averment in your plaint that she was Pardhanoshin.
No, there is no.
Or illiterate.
There is no. What this is, my lord, simple, my lord, the averment of the plaint. Simple averment.
Is it averred in your plaint? She is illiterate, Pardhanoshin, suit is bad, declaration that the deeds are bad for that. Is there any such averment?
No, there is no averment. But, my lord,
you seek a declaration simplicity of your title. Do you seek a declaration that those deeds are void?
No, there is no, my lord, declaration of the deeds are void. Because, my lord, she had no knowledge about the execution of the deed for the year, my lord, 1940.
No. The present challenge has been preferred against the order of the First Appellate Court, whereby the judgment of the trial court, dismissing the plaintiff stroke appellant's suit for declaration of title and permanent injunction was dismissed. Full sub next para, learned counsel for the appellant argues that the learned First Appellate Court failed to take into consideration the fact that the wife of the original owner Jodu Sarkar, namely Monibala, was a rustic, illiterate, and Pardhanoshin lady at the relevant point of time, and could not have executed the transfer deeds on which the defendant stroke respondents relied on. For sub next para, moreover, it is argued that the learned First Appellate Court did not advert to all the findings of the trial court. For sub next para, it is contended that since the name of Jodu, the original owner, finds place in the records of in the CS records of rights, the declaration as sought by the plaintiff, in the capacity of the daughter of Jodubala, ought to have been granted. For sub next para, however, we find from the findings of both the courts below that the plaintiff nowhere pleaded in the plaint that the said Monibala was either a rustic or an illiterate or Pardhanoshin lady. For sub next para, only during arguments, a cursory reference was recorded by the learned trial judge to the effect that Monibala was a tribal lady, close full stop. However, the said averment is not sufficient to raise the presumption applicable to Pardhanoshin and illiterate ladies, in which case a reverse burden of proof is cast on the person relying on any deed executed by such a lady to show that the contents of the documents were read over and explained duly to the said lady. Full stop. However, in the absence of any such averment in the pleadings of the plaintiff stroke appellant, we do not find any illegality on the part of the courts, either of the courts, not to advert to such submission. Full stop. Next para. That apart, the relief sought by the plaintiff was a declaration of a title simpliciter along with consequential relief of injunction. Full stop. The title deeds executed in favor of the defendant's predecessor was never challenged in the suit at all. Full stop. Thus, we do not find any error of law committed by either of the courts below. Full stop. In fact, the first appellate court adverted to all the materials on record and granted a partial decree in favor of the present plaintiff stroke appellant. Full stop. Accordingly, we do not find any question of law, let alone any substantial question of law, involved in the present appeal. Hence, SAT 11 of 2025 is dismissed under order for Rule 11 of the Code of Civil Procedure. Consequentially, Can 2 of 2025 is also dismissed. No address to cause urgent certificate.
One thing is to be
It-
considered, my lord, that after the death of my lord Jodhu Sardar,
Yes.
both Monibala and my lord the plaintiff
What will they do?
become the co-sharer and inherited the property with
Yes, but the
equal share.
title deeds are there, Mr. Adhikari. So, therefore,
No.
next matter.
Number 31.
Yes.
Challenge করুন। আচ্ছা।
Yes. They appear to challenge, yes. None appears for the parties at the time of call. Full stop. As a last chance to the appellants to argue the matter. The same is adjourned for the day.
Item number 32.
32 Mullet in this matter, I am appealing for the plaintiff appellant. Suit for declaration of title and permanent injunction. Judgment of affirmance, my lord. Trial court dismiss the suit as it is barred under section 34 of the Specific Relief Act. Appeal court proceeds some other premises that I am claiming title through a record of rights. According to the appeal court, the recorder does not confer any title. Apart from that, there is error in the record of rights, which I have stated, but it is not a forum for agitating the same. But title, on that basis, appeal was dismissed. So, kindly turn to the appeal.
So, three things you have to overcome before proviso. You are depending only on the records of rights, which are not proof of title. And thirdly, you say there is an error in the record of right also. Your name was not recorded.
No, my predecessor name was there. That is why, my lord, we are claiming title from CS record of rights, CS records holder.
In the arrest records, it's not reflected.
Not reflected.
Someone else's name.
Somebody else's name is.
So then, what is the mistake?
Defendant have also admitted, yes, predecessor of the plaintiff is the original owner. He subsequently died leaving behind a wife and son. Wife and son transferred the property by way of a deed in favor of somebody else. Those deeds were not produced and they failed to prove that title over the property in question. My case is that my predecessor name was there in the record of CS record of rights, from whom we have inherited the property. So the title both the parties.
How can you stand on your case? CS records of rights is not
It is admitted. I could have understood there is a dispute regarding my predecessor. Then, my lord, once my predecessor title is admitted, then, my lord, by way of succession, I am inheriting the property.
What about proviso 34?
Yes, my lord. I am claiming they are the Borgadar. I am claiming the defendants are the Borgadar. The trial court is of the opinion when he has said that they are cultivating the land, therefore you have to seek record your position. So for my lord, the Borgadar stand of a Borgadar and relation between the owner and the Borgadar standing on some other footings, because my lord, my position is through my Borgadar. That your lordship will be kindly turn to internal page 6 of the trial court judgment.
No, but what is the relief sought? Permanent injunction, declaration and permanent injunction?
And declaration and injunction regarding not to disturb my position of the others, and also declaration they are the Borgadars.
Position you are saying you are not in position.
And also declaration they are the Borgadars.
Where is that plaint?
Plaint, yes.
You annex the plaint to the injunction, Mr. Rai.
No.
যা বস্তু যে প্লেটের বাহ handwritten copy, my lord, there is declaration injunction to that effect. May I hand over to your lordship, my lord, handwritten copy?
What would you do if it was before the bench of Justice Modhiresh Prasad? Handwritten Bengali copy?
Adjournment not for translation. After that, it will not be mentioned.
You also seek for adjournment for us.
As a lordship, I cannot. দেখে একটা legal copy গুলো দেয় না। Well, if your lordship can turn to the trials code portion, internal page 6. The
suit is of which year? This is a draft copy. It doesn't even mention anything. How can we be sure this was the plaint? Mr. Rai, you never do this. The suit number is also not mentioned. This was probably the first draft. This cannot be the plaint.
I have to check it.
Even handwritten copies are maintained better. If it's a filed plaint, then there should be a stamp and a number.
Yes, well, it is not that it is handwritten office copy or like that.
It was a draft of the learned junior of your counsel in the trial court. You cannot go by this. হ্যাঁ টাইপের নাম্বার নেই স্ট্যাম্প নেই কিছু নেই ওটা প্রথম ড্রাফট করে দিয়েছিল জুন সিনিয়রকে তারপর থেকে আর কিছু নেই মুর্শিদাবাদ
On internal page 6, my lord, may I draw your lordship attention?
No, let us see what. No, we have to see the what you prayer is extremely necessary, Mr. Rai. What is this relief sought in the suit? How could you draft the memo, Mr. Rai?
That was the only copy which
you don't have drafted the memo. Achha, from there you read out from the plaint. You can read out whatever copy you have. That handwritten copy. We have returned it to you.
Well, kindly turn to, it has been narrated by the trial court. Kindly turn to internal page 2.
Yes.
Factual background, my lord, will find at the top.
Hmm.
The original suit projected the plaintiff is a suit property or it belongs to Atarul Haq. He was the grandfather of this plaintiff's appellant. His name was also recorded in the.
No. What is the
reliefs? After that, whether there is the actual title for the record holder, the transfer of no right title interest over the suit property, the status of the transfer defendants, respondents, and nothing but a borgather under the.
That is a plaint case. We want to see the reliefs, Mr. Without the reliefs, how can you? That is the premise of the finding regarding this. Borgathership section 21 has been spoken about here.
Because
so you have to see your reliefs. If you have sought a relief which comes under 21, how could the court grant it?
That is the ancillary relief, my lord. I could have said, my lord, because my title, I prayed for declaration of
the
title.
question arises that has to go to the.
If there is a dispute regarding the borgather, whether he is a borgather or not.
That's why we want to see your reliefs. If you have sought a declaration that he is a borgather, that's a question.
We'll make.
We'll put it out of the list, Mr. Rai. You don't have a copy of the plaint even. How can you move the appeal? You'll never have it. You'll have to take out a certified copy now. When you take out the certified copy, come back. At the time of hearing the appeal under Order 41 Rule 11 of the Code of Civil Procedure, it transpires that the averments and the reliefs sought in the plaint are vital for an effective adjudication of the matter. Full stop. However, since no copy of the plaint is available with the learned advocate for the appellants, comma, let the matter go out of the list for the present with liberty to be mentioned for enlistment as and when the appellants are furnished with due copies of the pleadings of the suit. Find out the written statement also, Mr. Rai.
Item number 33.
My lord, in this matter, Pankaj Haldari is appeared and I found adjournment only accommodation for today only.
Then it goes out. No accommodation in order.
I am for the appellant.
Dhruvodjyoti Datto, yes.
Yes, I am for the appellant.
Yes, move the matter.
You know,
Nothing in it.
I am the defendant.
Too bad, Mr. Bhattacharya. You are becoming a good advocate. Getting bad matters means you are a good advocate. Both courts.
106 notice. You know, only one thing. You know, if your lordship.
Let your junior argue, Mr. Bhattacharya. You'll add if something is to be added. Yes, what is your case? Fate will be the same, but we'll get a some net practice.
20
Yes. What is your best point?
Page 20, your lordship of the trial court's judgment.
So what is the best point? Ground. What is the ground?
Only on regard to the notice, your lordship.
That is not properly served.
Not properly served, that the address which is schedule has been mentioned in the notice that is not matching with the schedule of the plaint.
What will be our answer to that?
Joint tenancy and tenancy in common.
Notice about one of the tenants. One of
yes, please very
the court, Millard says, Millard, after the death of the father, Millard, the heirs become Millard joint tenants. Millard, that is not Millard.
Tenants in common, joint tenants.
Then Millard, the mode of service of notice, Millard, also changes, Millard. If your lordship would kindly comes to page 20 of the trial court's judgment, whether Millard the notice is binding. The same Millard finding has been given by the appellate court also.
Page 20?
Yes, Millard, of the trial court's judgment.
Yes.
Whether the notice is binding or not. Millard, may I place, Millard? In my view, the notice is binding upon the defendant because the has been sent to the correct address of the tenant after observing due formal procedures as envisaged in terms of section 106 of the Transfer of Property Act, and the said notice has been duly accepted by the defendant. Now the tenancy which the defendant all along with the legal heirs of original tenant are enjoying the single tenancy, and after the death of the original tenant, the heirs of such original tenant are joint tenants in respect of such terminated suit rooms, and the position between the landlords and tenants who inherited the suit property as heirs and successors of the original tenant remains unaltered as that of the relation between the landlord and original. Therefore, the notice of one of the tenants in a joint tenancy is binding upon all the tenants under such tenancy, because it is a single tenancy like tenancy in common. These two are different concepts.
Yes, it has been held on the basis of Supreme Court judgment that in this case it's a joint tenancy because a single tenancy is inherited. What is the wrong in that?
But,
those are different concepts that has been held here.
Yes,
that is immaterial in this case.
And another thing, if your lordship kindly sees the...
You are one of the tenants.
No, I am the sole tenant.
Then how does this help you?
No, there are other heirs of the original tenant. Father was the original tenant.
You were the only tenant.
Here, Millard, I have been only made party. And Millard, another thing, if your lordship would kind enough to see page 18
of the trial court
of the previous page, Millard, notice Millard was sent to Millard Shanti Stores, and Millard the proprietor Millard was made the Shanti Stores was never the tenant. It was the
notice caption in the address in the envelope said Shanti.
Yes. In the schedule of the notice, it says Shanti Stores.
That's a description and additional superfluous surplusage. Shanti Stores so that it reaches the correct place.
Shanti,
why do you make so much of Shanti Stores? The schedule has been described correctly. This is the error in the notice.
I could not improve in order.
The present appeal has been preferred against. It's a valiant effort, we may say. The present appeal has been preferred against a judgment of affirmance whereby both the courts below decreed a suit for eviction filed against the defendant stroke appellant on the ground of issuance of notice under section 106 of the Transfer Property Act. Full stop. Next para, learned counsel for the appellant assails the impugned judgments on two scores. Full stop. First, it is argued that the learned trial judge, and consequentially the learned first appellate court, erroneously proceeded on the ground that the tenancy which devolved on the present defendant stroke appellant is a joint tenancy, unlike a tenant in common, which, it is submitted, are totally different concepts. For sub next para, secondly, it is pointed out that admittedly in the schedule to the eviction notice, the expression double inverted Shanti, S-A-N-T-I, Shanti stores, double inverted clause was mentioned, whereas the same is absent in the plain schedule. It is further argued that Shanti stores was not the tenant of the plaintiff stroke lessor, but the present appellant. For the next para, however, we are unable to accept either of the said submissions of the appellant, insofar as the distinction between joint tenants and tenants in common is concerned, the same is merely academic in the present case, since it is nobody's case that any of the other heirs than the present appellant continued as a lessee in respect of the suit premises after the demise of the predecessor in interest of the appellant, that is the original lessee. Next para, even otherwise, the learned trial judge relied on a judgment of the Honorable Supreme Court in the matter of Suresh Kumar Kohli or Kohli? Kohli. Yes. Suresh Kumar Kohli, Kohli, versus Rakesh Jain and another, reported at 2018 6 SCC 708 to distinguish between the concepts of joint tenants and tenants in common, holding that the principle of joint tenancy is applicable in the present case. The said question is not germane for the present adjudication or the adjudication of the suit. It is well settled that a question which does not materially affect the outcome of the suit cannot be construed to be a substantial question of law within the contemplation of section 100 of the Code of Civil Procedure. Insofar as the other ground is concerned, since a business under the name and style of Shanti stores was continuing from the suit premises, merely to specify the address, the expression Shanti stores was used in addition to the description of the suit property in the schedule of the eviction notice. However, such surplusage, even if any, cannot render the notice defective, since it is well settled that if both parties sufficiently understand the property which is referred to in the eviction notice, the court should not look into such notice with a fault-finding approach. Next para, as such, the mention of the additional expression Shanti stores, whereas the other description of the suit property in all material regards was correct and identical with the suit premises, does not affect the outcome of the suit in any manner. Next para, even otherwise, we do not find any substantial question of law involved, since the concurrent findings of both the courts below support the eviction decree granted against the defendant stroke appellant. That apart, in a suit for eviction under section 106 of the Transfer Property Act, the primary and germane consideration is whether the notice contained a workable description of the suit premises for the noticee to understand the identity of the property, and whether such notice was duly served. Full stop. There being no demur on such ground, comma, we do not find any error in the judgments of either of the courts below. Accordingly, SAT 146 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Consequentially, Can 1 of 2025 is also dismissed, no address to cost. Next. Agony over.
Great.
Yes.
Item number 34.
At 34, my lord, I beg to appear for the appellant.
Yes.
Appellant, my lord, one appellant. My lord, perhaps there is a defect, my lord.
What defect?
Because in this case, my lord, what has happened, I filed the memo as well as section 5 as well as injunction application. But what has happened, my lord, in the back of the, my lord, certified copy, the application date is on 27/9/2024. My impugned order was on, my lord, 14th February 2025. Now, my lord, I applied for certified copy. Why? Because my ad interim injunction was granted on 26/9/2024. I applied for certified copy. Thereafter, my lord, injunction refused on 14/2. So, pursuant to my earlier application, entire, my lord, certified copy was given to me. Pursuant to, with that certified copy, my lord, I filed the memo. Thereafter, my lord, matter came up before the learned register Lojima. The learned register was of the opinion that the certified copy needs to be checked whether this is original or not. But, my lord, I don't want to say it, but what has happened, it was sent back, the entire bunch of the certified copy. Over there, my lord, the judge in charge, my lord, was of the opinion that he will take back the certified copy and will hand over the certified copy which I am entitled to pursuant to my application on 27/9/2024. That is why, my lord, the entire certified copy, the impugned order certified copy is not with the record. But in the second judge's copy, my lord, the entire bunch which I filed at the time of filing, my lord, is contained with the everything.
But that copy has to be given to us. Otherwise, the appeal is
My lord,
defective.
that was taken from the, my lord, the department in the court below, my lord, when it went for rechecking. Because I gone through with the record, my lord. Perhaps this is the defect, my lord. So what has happened in the first judge's copy, there is no certified copy of the impugned order. And, my lord, in the second judge's copy, as we put the Xerox copy of the certified copy, my lord, the
That won't do. Original certified copy
is with the first judge's copy, my lord. It has to be with
that is not there.
that they have taken, my lord.
What is there in the second judge's copy?
The entire bunch which I filed at the filing
That
time.
won't do. There's a defect in that. That's why it went down at the first instance.
No, my lord, it was down, but the copy which I filed at the time of filing, that certified copy has
That was found to be defective. That's why it was.
that was not that sent for rechecking whether that is original or not.
So there is no finding on that whether it's original or
My
not.
lord, the perhaps report is that inadvertently was given to me the entire certified copy.
Then that is not a valid certified copy. If that certified copy, which is with the second judge's copy, was inadvertently given to you.
Yes, my lord. That is why it's. But subsequently, I obtained the entire certified copy. If my lord allow me, then I can file it.
Then it will be time, but then you have to file a section 5.
I already filed, calculating 25 days delay at that point of time. Due to that problem, my lord, I need.
Will permit you to file a supplementary affidavit to that. Explain the further delay.
My lord, with that certified copy.
You file the certified copy right now. Learned counsel for the appellant submits that initially there was some discrepancy in grant of certified copy, comma, since there was a discrepancy between the date of application for the certified copy and the certified copy actually issued to the appellant. Full stop. Accordingly, comma, pursuant to direction of the learned registrar, comma, bracket Lozima, bracket close, comma, the matter went down to the trial court. Full stop. However, comma, apparently the faulty certified copy was taken back from the first judge's copy, whereas the copy filed with the learned second judge's copy is still on record. Full stop. Next para. We find from a report given by the concerned judge of the trial court dated September 9, 2025 that the concerned staff of the copying department and the staff of the district judge's court, comma, according to the learned trial judge, comma, were responsible for sending the record for copying to the copying department and have submitted their necessary clarification and admitted that mistake was bona fide due to inadvertence and shortage of manpower in the copying department. Full stop. At the same time, comma, the clarification has been annexed to the said report of the concerned judge, and it was recorded that the party has already returned certified copies to the concerned court, and on further reassessment of court fees, certified copies would be provided. Full stop. Next para. However, comma, to avoid unnecessary delay, comma, the appellant has applied for and obtained a fresh set of certified copies, which are filed in court today with the leave of court and are kept on record. Push up. Since an application for condonation of delay has already been filed by the appellant, comma, we grant leave to the appellant, comma, on the prayer of learned counsel for the appellant, comma, to file a supplementary affidavit incorporating the cause of the further delay in obtaining the certified copy. Full stop. Such supplementary affidavit shall be filed. You will just have to put whatever you have stated. The
Within
chronology.
2 days, my lord, I will file, my lord.
Such supplementary affidavit shall be affirmed within. Today we are on 9th, 10th.
By 13, my lord, I will file it.
By February 13, 2026. Full stop. The matter be listed on February 16, 2026. We have never directed you to serve copy. Acha,
This is first time.
the matter will appear on ye kora darkar nei. Matter will appear on February kichu kora darkar nei. The matter will next be listed on listed in the monthly list of March 2026. Full stop. In the meantime, comma, the appellant shall serve a copy of the condonation application as well as the connected an advance copy of this supplementary affidavit on the respondents.
My lord, so many respondents are there, all of them going expert in the my lord, trial court. Only 1 and 2 is contesting the suit.
On the respondent numbers 1 and 2, indicating that the matter shall be listed under the same heading in the monthly list of March 2026. Full stop. The appellant shall file an affidavit of service to that effect on the returnable date. Full stop. Next para. Service on the other respondents is dispensed with for the present on the submission of learned counsel for the appellant that the said respondents did not contest the matter in the trial court, in the
appeal court, because my lord, order 7 rule 11 was allowed, then I filed a first appeal.
They contested in the trial court.
Order 7 rule 11 in the trial court.
The other respondents contested in the trial court.
No, only my lord, the 1 and 2, their predecessor, and subsequently
Did the other respondents contest in any of the courts below?
No. No, others are not contested.
In either of the courts below. Did not contest in either of the courts below.
Grateful.
You serve this copy and supplementary evidence and come back so that we can take up the matter
Yes,
on
yes.
the next.
My lord. Grateful, man. Grateful.
Item number 35.
35, I'm for the appellant petition.
Yes.
Lordship. Lordship, appellant petitioner is the defendant. There is a eviction suit filed by the respondent.
Lost in both the courts?
Both the courts, Lordship. There are 3 points, Lordship.
Yes.
First of all, the petitioner is a school.
This is under the 1997 Act.
1997 Act.
On what ground was it?
Lordship, there are 2 grounds: the defaulter grounds and the reasonable requirement ground.
The decree was passed on both the grounds.
No, only on the reasonable ground.
Both courts found
both
unreasonable. Very well.
It is
Then-
decided by the trial court that there is no defaulter ground.
Very well.
Lordship, in page 12, that
What are your grounds you are saying?
Yes, Lordship. This is a school run by the district primary school council,
Yes.
a government recognition school. Therefore, whether a section 80 notice is required or not. The second point is whether a district inspector of school is a necessary party in this suit or not, and whether the suit property is reasonably required by the plaintiff or not.
So section 80, what was the finding of the courts?
They said that there is no requirement of section 80 notice.
So
By
how
both,
is that a relevant question? Oh, acha, you say there was requirement.
there was requirement because it is a government school run by the district primary school council. It
What
is
was
under
the- What was the reasoning given by the courts for not requiring a section 80?
They said it is a government aided school, but it totally runs by the Kolkata Primary School Council under district's primary
Show
school
us
council.
either of the court's findings on that first, section 80 finding. Then we'll proceed to the next point.
Lordship, both the courts plainly said that there is no requirement for Section 80 notice because it is a government-aided school.
You want
They
to
are
see that finding?
Lordship kindly comes to the internal page 4 of the ejectment appeal judgment, issue number 1.
You did not produce any paper to show that, did you?
Lordship, difficulty is we have filed order 41 rule 27 in the appeal.
Produce what? What document?
That is page 155 for producing all the documents that the school runs by the Kolkata Primary School Council
The
organization.
application was dismissed.
Dismissed, rejected. We filed the application for adducing evidence by the district inspector of the school.
One second, just give us half a minute. এই যে পেসলিপ ফিসলিপ সব দিতে চেয়েছিল পেজ 4 এ দেখুন ও অর্ডার 27 করেছিল তাতে অফিস মেমোরান্ডাম দিয়েছিল কাউন্সিলের প্রাইমারি স্কুল কাউন্সিলের পেসলিপ অফ টিচার্স অ্যাপয়েন্টমেন্ট অফ গ্রান্টস ইস্যুড সমস্ত দিয়েছিল Have you got a copy of your written statement? Have you annexed anywhere your written statement?
Yes, I have annexed my written statement, Lordship.
Where is that?
Page 24. And there is another additional written statement.
Where have you taken this plea of section 80?
During trial.
Can you? Don't you have to take that in the plaint?
It was not pleaded in the written statement, Lordship.
Also not in the additional written statement?
Additional written, no.
Then?
Additional written statement is regarding they have produced the will.
No, but if you have not taken this point beyond the pleadings, court cannot permit you to adduce evidence beyond the pleadings.
That's why,
take
Lordship,
this objection.
that's why, Lordship, we filed the order 41 rule
Order
27.
27 is for additional evidence.
Yes, Lordship.
The law is that you cannot produce any evidence, you cannot prove anything beyond the pleadings. Right? So additional evidence is also evidence. So if it is not pleaded, you cannot take that. So that point goes. District Inspector of Schools is a necessary party. Why? You are the tenant, eviction suit against you.
Lordship, my point is whether a headmistress can took a school from the suit property.
School has been made a party. School has been made a party.
School is a party.
School
The
is the
school
tenant.
is only the party.
School is the tenant.
School is a tenant.
So therefore, rightly so.
Can a headmistress can
Headmistress is a, I mean, the school itself has been made a party. Headmistress has also been,
Lordship,
she is in charge.
in this matter, they have
Rent receipts were given in the name of whom? The school. Rent receipts. The school has been made party. That's sufficient.
Lordship, there is a managing committee. They have made party in the plaint, but the school does not have any managing committee. It's totally.
The plaint has been annexed also, must be.
Yes, yes.
Let us see the plaint. Mr. Ghosh, you are appearing for the caveator.
Yes.
That's why you're nodding your head. Yes.
The plaint is annexed to B, page 16.
Secretary, managing committee, headmistress.
But the school does not have any managing committee. It runs by the.
Misjoinder does not vitiate a suit. Non-joinder vitiates. Misjoinder does not.
But our point is that.
You are the school. Your rent receipt was granted in your name.
Yes.
What is the third point?
Third point is whether the.
Your only good ground is Mr. Ghosh is appearing for the other side. You may have some point. No other ground. Yes, reasonable ground. What is? No, you are arguing very well. What is your name?
The last point.
What is your name? Not your school's name, your name.
Anesha Dash.
Yes, Ms. Das, you are arguing very well. Yes. Carry on. What is the... But we don't assure that you will win the case. But you are arguing well. Yes. Reasonable requirement, what is your argument?
Yes, reasonable requirement. Lordship, there are... the suit was instituted by one Ira Bishas. The suit property was actually belongs to Sripati Bishas, the husband of Ira Bishas. Ira Bishwash, the suit property bequeathed to Ira Bishwash by way of a will. That is, I have annex of will, page 58.
Probate was obtained also.
Probate, no lordship. In that will,
Yes.
there are three property they have. One, the suit property 1 by 19 Paikpara Road, the school. Another property is 8 Bhupendra Bose Avenue that belongs to the respondent number 1.
So you say they have alternative accommodation.
Yes. Now, lordship, the most important thing, the plaintiff number 3, the respondent number 3 have another accommodation, that 4 Bhupendra Bose
There is only
Avenue.
one plaintiff.
They have suppressed this fact.
Oh, there are 3 plaintiffs. Ila died in the meantime.
Ila died.
So have you taken these points that they have alternative accommodation or something?
Yes.
Where?
In the commissioner's report.
In the pleadings, have you taken this point anywhere?
Yes. In our written statement.
Show us that. The additional accommodation agreement. Alternative accommodation কিছু বার করে স্টেটমেন্টের কথা বলেছে
Lordship, if you comes to
yes,
the trial court's judgment paragraph, page 12, it is admitted that the defendant, page 14 of the trial court judgment, it is admitted there that the 4 Bhupendra Bose Avenue is bequeathed to the plaintiff number
this is
3.
you are reading from which paragraph? Page 14 of trial court.
Trial court.
Yes. Which paragraph of that page?
I'm reading. The second paragraph. The last line. Moreover, it appears from the said will that the premises number 4, Bhupendra Bose Avenue, Calcutta 7/4, has been bequeathed to the father of the plaintiff number 3 and thereafter to the plaintiff number 4, plaintiff number 3 absolutely and forever. It is from the will. They have suppressed this fact.
Let's see how the court deals with it.
No, nowhere. In fact, the commissioner's report, nowhere it is stated. They only dealt with the 8 Bhupendra Bose Avenue and the suit premises. And moreover, Lordship, in 8 Bhupendra Bose Avenue, from the commissioner's report, it transfers that 8 rooms at 8 Bhupendra Bose Avenue, and there are 5 rooms and 1 garage in the suit premises. Therefore, total 13 rooms and 1 garage.
No, this is where? In the suit premises. Commission was held in respect of all the premises.
In both the premises. In 8 Bhupendra Bose Avenue.
So the other premise, regarding the other premise also, which was bequeathed to them, commission work was held.
Was held, but not in the 4th Bhupendra Bose Avenue.
The suit premises is 1 by 90, Paikpara.
Paikpara Road.
Very well.
And there are 2 other premises.
4 and 8.
8.
So Paikpara was held, and regarding 8?
8? Commissioner held.
Regarding 4, nothing was
held. Was held. And this in this 2, in 8 Bose Avenue, there are tenanted portion in the ground floor.
All right.
There is a bank.
Right.
And
so 8 goes.
8 goes. There are 8 rooms.
But tenanted?
No. In their possession. In the plaintiff's possession.
8 rooms
in the plaintiff's possession.
All right.
There are 5 rooms and 1 garage in the suit property in plaintiff's possession.
This is from the commissioner's report you find?
Commissioner's report.
Yes.
But
total 13 rooms.
Total 13 rooms.
But these are in different places.
Only 3 kilometers away.
No, but they cannot be compelled to divide their family. That's also settled. Landlord cannot be dictated.
Yes, Lordship.
So they cannot be
Now,
compelled
Lordship,
to.
if you
So if half of the
come-
family resides in 1/19, other half resides in 8, son will call the father for breakfast from 8. She's residing at 1/19. And the mother will
no one
cook
resides
from
1.1 by 19. Only
and
the
your family cannot be divided. That's also
Lordship,
certain.
only my point is in the plaint, it comes that they required only 7 rooms and thereafter they amended the plaint and they required 9 rooms.
9.
Only 9 rooms after amendment.
9 rooms are not available anywhere as a composite whole.
Lordship, they have more than sufficient
How
requirement.
was it dealt with by the appellate court? Let us see. This reasonable requirement. These points must have been dealt with. Let us see.
And Lordship, this is a primary school. If the school is evicted, then this is all the
Regularly happening. Regularly happening. Schools are evicted.
all are from slum areas.
Banks are evicted.
There are still 25 or 30 students are studying in the school. All are from slum
Government
areas.
runs primary school. Are there still students? There are only teachers now. No midday meal, no students. Only teachers.
30 students are still reading in the school.
That cannot be a ground. We cannot later compassion come in as a substantial question of law. Even Mr. Ghosh may be compassionate, but we cannot do that as the court. We cannot do that. It is second appeal. Where there is a 50-50 chance, compassion comes in, definitely. But our hands are bound by law. If there is no substantial question of law, you cannot admit. Let us see how this your poor Bhupen Ghosh was dealt with. But still, they require it for the family. That is the thing. But they require for their family.
At that point, the trial court held that for Bhupen Bosch Avenue.
আমার পোর্ট ভূপেন বোস নিয়ে যদি অ্যাডমিট করি 10 বছর চলে যাবে এর ল্যান্ডলর্ডে 10 বছর আগে চলে যাবে রিটেন স্টেটমেন্টে নাও থাকতে পারে প্লেন্টিফারিটা লায়াবিলিটি অল্টারনেটিভ অ্যাকোমোডেশন দেখান প্লেন্টিফারি ডকুমেন্ট থেকে দেখা যাচ্ছে উইল আছে প্লেন্টিফারি ডকুমেন্ট থেকে দেখা যাচ্ছে ফোর ভূপেন বোস আছে 8 ভূপেন বোস করেছে ইন্সপেকশন করেছে দেখো 8টা ঘর পেয়েছে ফোর ভূপেন বোসের কথা বলেছে এই যে ক্যালকুটে আপনার পেজ 14 এ দেখুন এই যে সেকেন্ড প্যারাগ্রাফ প্রেমিসেস নাম্বার 4 has been bequeathed. বস্তির ছেলেমেয়েগুলো পড়ে তো অনন্তকাল তো তার মানে এই তো নয় যে ল্যান্ডলর্ডের তো কোনো দোষ নেই সেটা ওর ভূপেন বোস কিন্তু কোথাও দেখেনি ওর ভূপেন বোস কিন্তু অ্যাডমিট করা যেতে পারে From the commissioner's report, is there any other ground floor premises in either in 8 or 1 by this?
No, only 8 and 1 by 19.
There is no no vacant room on the ground floor.
No, it is a back portion of the property, the school. In the front portion, there is a garage.
No, the rooms in their occupation, there is no, they don't have any ground floor room in their
No, no.
occupation. So one of the requirements is to open a coffee shop or food outlet.
Yes.
That has to be on the ground floor.
Yes.
So therefore, I mean,
It can be done in the 4 Bhupendra Bose Avenue also.
poor
Lordship.
Bhupendra Bose.
It's in the Shambazar area, Lordship.
Suite properties in 1/19.
1/19. It's a slum area, Lordship. Totally a slum area.
কত টোটাল রিকোয়ারমেন্ট দিয়েছে দেখুন তো, ক্যালকুলেট করেছে? রিকোয়ারমেন্ট বলেছে 9. Occupation?
7 rooms.
7 rooms? তাহলে ওকে
School, Lordship.
এত হয়ে যাচ্ছে। ফ্যামিলিকে ভেঙে দিতে হবে। 7 rooms পেলে 9 rooms যদি রিকভার করে পার্শিয়াল এভিকশন করা যেত। কোথায় হোল্ড হয়েছে 9 rooms? কোথায় হোল্ড হয়েছে? Was there any quantification by any of the courts as to actually how many rooms are required by them?
No, no, no.
Check up.
It's only in their plain, Lordship.
Not quantified. 7 rooms in the suite property and your this
7 rooms, 1
And-
lobby, 2 balconies.
plus they are in occupation of 5 other rooms there.
In the first floor. 5 others room in the first floor.
Partial eviction.
There are other rooms, Lordship, in the front portion.
Premises Tenancy Act একটু দেবেন? Premises Tenancy Act. West Bengal Premises 97. নতুন একটা কি আছে ভুলে গেছি বর্ষার বিষয়। Hmm, 63. You take instruction whether you are agreeable to partial eviction. Whether you are agreeable to partial eviction from a portion of the property. Take instruction and come back tomorrow.
Yes, sir. Sir.
We can at best admit only on the ground of partial eviction, but then in that event, we'll have to enter into a quantification and hear Mr. Ghosh on that also. Although it's your consent which is required under the law. If you agree only then we can think about that. Otherwise, we don't find any such ground.
Yes, sir.
During hearing of the appeal under Order 14 Rule 11 of the Code of Civil Procedure, it prima facie transpires that as per the requirement pleaded by the plaintiff, at least 9 rooms are required by them, whereas at present 5 rooms are available on the upper floors of the property and a garage on the ground floor, whereas the plaintiff requires the plaintiff's requirement also includes the requirement to open a coffee shop / food outlet. comma, which would necessitate a ground floor. Full stop. Next para. From the materials on record, comma, we find that the suit premises are comprised of about 7 rooms. Full stop. As such, comma, in our opinion, comma, a prima facie case has been made out of the requirement pleaded by the plaintiff stroke respondents being satisfied by partial eviction of the tenant from the suit premises. Full stop. Next para. As such, comma, in order to explore the possibility of attracting section 6 within bracket 3, invoking section 6 within bracket 3 of the West Bengal Premises Tenancy Act 1997, comma, we request learned counsel for the appellants to take instruction from the appellants as to whether they are agreeable to partial eviction of the from the suit premises, and comma, if so, the extent of their minimum requirement with regard to the suit premises. You also take instruction as to what will be the minimum requirement. I mean, beyond that, less than that, you cannot go. You cannot agree. So take instruction on that. If you are agreeable to relinquish a part of the premises, and if so, how many rooms you have to retain for running the school. Take instruction, come back. When should you keep it? Tomorrow will be too close. Tomorrow you can come back. No, they'll have to take a decision. The school management may take a decision. Come back on Monday. We have recorded our order. The matter be listed next on February 16, 2026 under the same heading. An execution case has been levied, Mr. Ghosh.
The next date is 21st.
Yes, Lord.
21st of this month. This month.
For delivery of
Verification is fixed for verification.
verification.
Oh,
Okay.
it is expected that the respondent shall not execute the impugned decree in the meantime.
Right.
Why did you the notice or not? Because no, I cannot utter anything because at the order.
At this stage, if only if they're agreeable to partial eviction, we shall. You also take instruction unofficially, Mr. Ghosh, since you are here. Take instruction whether your client is also, because otherwise, if you feel that your purpose can be served by partial eviction, because you probably have pleaded 9 rooms your requirement, and 1 room is required on the ground floor, definitely.
Not only that, the third respondent is an engineer. He has not taken any job to stay
So
with
2 rooms on the ground floor.
on the ground floor, and apart from that, residential.
The rest of the residential. So therefore, 9 rooms in total. 2 out of 9 on the ground floor. You have 5 rooms on the top.
Top floor that has been bequeathed to daughter. She is in possession.
But
That
then 4 Bhupenbos comes in.
Bhupenbos, 4 Bhupenbos, Lord, I have not taken into consideration.
It will take into consideration. Remind us of 4 Bhupenbos.
I think Lord, both.
Yes, Lordship, it is in the will.
Tenanted entire.
You have to make out that case.
Yes.
You have proved your will, which says 4 Bhupenbos is there.
Found by the trial court that will they knew, but not pleaded anything.
It's your onus, Mr. Ghosh. You have to show that you don't have any alternative accommodation at 4.
Yes, Lord,
You just remind us of 4 Bhupenbos whenever he does not agree on the next day.
My Lord.
Thank you.